continuing to be with us. We'll start with public comment on matters appearing or not appearing on the agenda. Come up, ma'am.
Good afternoon, Commissioners. Thank you for serving our city. My name is Ellen Lee Zhao, that is ELLEN LEEZHOU. I have been working as a behavioral health clinician for public health for more than 11 years. I am a bargaining team member for SEIU 10-1. We had approximately 16,000 SEIU members in San Francisco. I represented the public workers. I brought 5 public workers who experienced retaliation and discrimination to Ethics Commission between April 2017 to June 2017. We made initial interviews and provide a lot of reports and documents to Ethics Commission staff. I am here today to follow up with you to see if your investigation have started yet on the Ethics Commission. Our records and audio record were missing. We have 6 people did the intake interview in different days. Many of the SEIU 1021 city employees from different departments spoke in front of the Civic Services Commissions, testified in December 2015, August 15, 2016, September 9, 2016, September 18, 2017. I myself also came here to speak to you the Ethics Commissions on October 23, 2017, November 27, 2017, January 19 and 2018 about extortion, bribery, retaliation, discrimination, and ongoing harassments. The last contact we had with employee who informed us that EEO department, Whistleblower Department, and DHR refused to give our records for Ethics Commission to take action against corrupted management staff. We were told our record will be released only with a court order, but now our employee records are missing from the Ethics Commission Department. As some of you remember, the District Attorney and the FBI has been investigating bribery and extortion for many, many years. And many of us, the public services workers, took the courage and stood up and cooperate with FBI agents and HR management staff. We were told we will not be retaliated. Yet, some of us who spoke up going through harassment, discrimination, bullying, retaliation since we report those problems. Many of the victims are Asian, Chinese people, and people with limited English skills, and people of color. Some of the HR and DHR leaders, instead of working on the problems to improve our HR, they have said they're going to do better policy, but yet nothing happened. They turn around on those who took the courage, like me. I stood up for the workers because I'm a bargaining team member and because I'm a union sub-steward. I make those people who report the problems into a problem employees. We, the victims, become more victimized by management staff, and that is not acceptable, and it's not ethical, and it's illegal. Ethics commissions set up to address corruption, and we set this department up to help people to have equal opportunity employments. So I'm here today. Please investigate the complaints that we filed with ethics commissions. Maybe you can help us, tell us what to do, and how can we hold those people, the public workers, who violate the law accountable. Tell us, the residents who pay the taxpayers, who pay the tax, and who are residents, who are workers, that we stand up to fight for corruptions. You guys are important to fight for corruptions. I make a commitment. I will be here every month until you guys do something about corruption. It is not acceptable. You are here appointed by the public. We want investigation. Tell us what to do when Ethics Commission supposed to be ethically keeping our records, but now our audio record is gone, our written report is gone, our public record is gone, and the EEOHR refused to put out our records, even I signed for release. You guys are judges before, and you guys are lawyers before, and you are appointed for public. Tell us. I have hundreds of people stood up and came out and spoke to you in different days, many years. Please help us. Teach me what to do. Lead me what to do so the public can be protected by people who are extorted employees, and those are repeated cycles, and you know that. It happens in the 70s, 80s, 90s, and today this is 2018. If the HR people refuse, then they should not be at their job. Do something else. Let somebody who is able to do the job and stop corruption and do the job. Thank you.
Ms. Pelham, last time when the lady was here, we had a question about the assertion that we had lost their records, and have we resolved that? Have we found the records? Did we ever have the records? What's the story on that?
We've done a diligent search, and we don't have records of any of the individuals that Ms. Zhu identified as filing a complaint, except for one who filed a complaint on her own. And so I would like to publicly call. We've asked Ms. Zhu privately on a number of occasions to provide us with those names and to ask the individuals who made the complaints to come to our office and talk to us again. And I'd like to publicly call on Ms. Zhu to do that, to have the 5 individuals who she claims have filed complaints with our office to please come again. And we are sorry that that has to be the case, but please come again and talk with our investigator. Mr. Pierce, who's been handling her case, will talk with her once again outside today, as he does after every time she speaks to the commission, to try and get more information about those 5 individuals so that we can follow up with them. Names, contact information, anything would be helpful.
Is there any indication that you received any records that are now not able to be found or available to you?
For every physical record.
No, I'm sorry.
Okay,
I'm
well,
just
excuse me.
asking later. Thank you.
Those conversations happened in a closed-door meeting with another investigator who's no longer with the commission. So the only witness to that would be Ms. Zhu. So if she says there are records that were handed over and recordings that were made, I have no reason to doubt that. They're just not in the commission. They're not in commission's official files.
So has that been explained to Ms. Yu about the former employee
Yes.
and the difficulties in regard to talking to that former employee and
Yes.
getting any information from that former employee?
Yes.
Okay. All right. Thank you.
Can I ask,
Go ahead.
what can we do when the ethic
I think
commission?
I think what you want to do is Mr. Pierce is over there, and you can, if you like, you can go.
I understand that.
No, hang on, I haven't finished. I would suggest that you go talk with Mr. Pierce right now. He's available. The two of you can go outside, have a full discussion about it, and then if you're not satisfied by that, come on back in, and then at the end of our meeting, we'll talk more with our staff people. But in the first instance, why don't you have a discussion with Mr. Pierce? Okay,
There's
Mr. Pierce?
nothing we can do about missing files.
I'm sorry?
You telling me that there's nothing we can do about our
No, I'm
missing
not
files?
telling. There may be a lot of things that we can do, and I'm
Okay.
trying to get, if there
I'll
is,
try to do that. Happy New Year to you guys.
we'll
Thank
talk
you.
with Mr. Pierce.
I have a question.
Yeah,
I think. Did you keep copies of the documents?
I keep all the physical records except the audio.
Wait, did you keep copies?
Yes.
Well,
keep all
what's
the
the
records.
problem then? Bring the copies with you.
But the problem is they are missing something, shouldn't he be held accountable? Because the employee is missing. That is the problem.
I don't understand.
Mr. Pierce,
I'm
if
sorry.
you will.
I'm sorry. We are dealing with corruption in here. We have an employee who is missing from the department and lost everything that we have. That is the department problem on purpose. Because we were told
You may
that
be
people
right. You may be
refused.
right on that. You may be right on that, but we're going to try and sort
Okay.
that out now with Mr. Pierce.
All right.
At some point, when you start dealing with the Ethics Commission, you move from a petition for the redress of governmental grievances to they aren't going to do a damn thing, so all I can do is document the fact. and this seems to be another case of it. You know, you say, oh, well, one of our former employees left and everything's gone. Oh, what a miracle. You know, basically the law says you're supposed to have those documents, and blaming it on some employee that's no longer here is really a BS excuse. The civil grand jury of City and County of San Francisco for 2010-2011 issued a report entitled The San Francisco Ethics Commission, the Sleeping Watchdog. The report includes the following. Because of the Ethics Commission's lack of enforcement, no city employee has been disciplined for failing to adhere to the Sunshine Ordinance. The Commission has allowed some city officials to ignore the rulings of the Sunshine Ordinance Task Force. Because of the Ethics Commission's lack of enforcement, no city employee has been disciplined for failing to adhere to the Sunshine Ordinance, ever. Not once, ever. The Commission has allowed some city officials to ignore the rulings of the Sunshine Ordinance Task Force. And here are the 36 orders I have personally, so I know whereof I speak. As the civil grand jury reported in 2010, so it is now and so it shall continue. These 36 orders of determination I personally have, and a number of them have been sent here, most of them dismissed without a hearing, and those that did have a hearing were held under the most bizarre circumstances and done in ways that no reasonable person would think they were fair hearings. None of these has been enforced, as that is your responsibility, and you simply refuse to do it. You refuse to follow this law because the Ethics Commission is on this list 4 times, including the latest with Commissioner Kopp deciding that he is going to abuse his power by interrupting my public comment, and Commissioner Keene aiding and abetting him by letting him do it. Why would you enforce these? You don't want to bite the hand that feeds you. The people on this list are the people who appoint you. Frank Herbert wrote, "Politics is the art of appearing candid and completely open while concealing as much as possible." So anybody who approaches you with a reasonable expectation that you're going to do a damn thing to bring ethics to this city should look at the history. The history shows you never have done a thing.
Good afternoon, Commissioners. I just wanted to acknowledge that this is our 2nd anniversary for our Executive Director, who's been working so hard, as we all know, to craft an organization unlike anything this city has seen. That doesn't say it's perfect, but I think she's on her way. And I did want to thank her for her hard work, catching up, and doing such superlative work.
Thank you. Any further public comment? If not, then we'll move on to item 3, which is discussion and possible action on the draft minutes for the Commission's January 19th, 2018 regular meeting. Commissioners, is there any discussion on that?
I move that we adopt and accept the minutes.
Second.
Got a motion, it's been seconded. All those in favor, say aye.
Aye.
Aye. Opposed?
Public comment.
Oh, I'm sorry, public comment.
Commissioners and members of the public, these minutes are the official public record of the proceedings of this body. Unfortunately, they give a very slanted view of what goes on in the San Francisco Ethics Commission. The minions of the Ethics Commission, for the most part, put in what the commissioners want in the official record and exclude anything they don't. If you praise them, the very best of that will appear. If you are critical, however, that just doesn't make the cut. So what you get is these minutes. In these minutes is a completely skewed presentation of what these commissioners do and whether or not it has any effect whatsoever on the ethical conduct of governmental business. I've dared you a number of times to come up with one example of anything this Ethics Commission has done in all these years that has made the city more ethical, that has caused our politicians, and basically everybody looks at it and they go, pay for play. Just keeps getting worse and worse. And you can do all this song and dance about how much better this is now than it was, but that's a bunch of BS. That's all it is. These commissioners wholly confuse activity with accomplishment. They confuse governmental paper shuffling with any meaningful result. I've been coming here for years, and I say these things to your face, and the only thing I ever get is reactions. And they're usually just ones that expose how corrupt most of you are. You're lawyers. You know what the law is, and yet you'll let one of your members interrupt a member of the public in their public comment and give it a blessing and say nothing about it. You all took an oath of office to support and defend the Constitution, but unlike you, when I took that oath several times, primarily the one I took when I joined the United States Navy, I meant it, which is why I come back here month after month to point out the fact that I see nothing in your behavior that shows that you mean it, that you intend to follow your oath of office, and the worst thing about it is you all have law degrees. And you all come out and you do this. I'm a former Superior Court judge. I'm a former dean of a law school. What good does it do to the public if you don't do anything with the skills and abilities you have? And again, give me an example of anything you've done over the years to make the city more ethical. Yeah, didn't think so. My name is Ray Hartz, and I'm the director of San Francisco Open Government. Members of the public may contact me at sfopengovernmentbs@comcast.net. That's sfopengovernmentbs@comcast.net.
All right. The minutes, I think we voted on it. Did we didn't vote on it. All right, let's vote on the minutes. All those in favor say aye.
Aye.
Opposed? Minutes are approved unanimously. Let's go now to item 4, discussion and possible action on proposed anti-corruption and accountability ordinance. And there are attachments in the revised staff report dated February 14th, 2018, an attachment to that. And Mr. Ford is going to take us through it. Matt?
Good afternoon, Commissioners. Pat Ford, Policy Analyst. Agenda item 4 really encompasses two distinct components. They're combined here in this agenda item for reasons that I'll explain, but I will kind of tee these up for you as two items. So the first is the Anti-Corruption and Accountability Ordinance that you approved at the November meeting. However, this has an attachment that is a version with some of staff's recommended amendments, and I will go through those amendments shortly. The second item is a proposal that was recently put forward by Supervisor Peskin. This involves financial disclosures by major donors, and this has been proposed to be potentially amended into the ordinance, and we have Mr. Hepner of Supervisor Peskin's staff to speak on that item shortly. So the ACAO, Anti-Corruption and Accountability Ordinance, you had approved in November. This was sent to the Board of Supervisors for them to engage in their process, and ideally for them to pass this into law, to send it to the mayor for his signature. Part of the reason, or perhaps the main reason that you took this action, was you wanted the Board of Supervisors to engage on some of the more controversial aspects of this piece of legislation. I think Commissioner Lee, in particular, were very concerned and wanted the board to engage in this. So I can report back and say that over the last 3 weeks, staff has been engaged with the Budget and Finance Committee, as well as Supervisors Peskin and Tang, who are not members of that committee, but have gone through or taken a lot of effort to engage the ordinance and really provide a lot of thoughtful feedback. And we're appreciative to both of them and the members of the Budget and Finance Committee for that. Staff has also worked with Commissioners Chu and Rennie to kind of preview some of this feedback to them and to also try and formulate specific amendments to the ordinance. And a lot of that is reflected in the draft that's before you today. Staff believes that these amendments in Attachment 1 are fair compromises that address some very valid concerns that the board has raised. However, we think that even with these amendments, those particular amended provisions will still carry out the core purposes that they were included in the ordinance to do. So just to give you a little procedural background, so this ordinance has been heard twice now at the Budget and Finance Committee, first on February the 1st, and then again yesterday on the 15th. We also met separately with Supervisors Tang, Peskin, and Mr. Hepner of Supervisor Peskin's staff. What the current status of the ordinance is at the board. Yesterday, the file was duplicated, so there are now 2 files that are pending before the Budget and Finance Committee. The first one is being called the ethics version, and that's essentially what is attached here as Attachment 1. So this is the version you approved in November with staff's recommended amendments. So the committee adopted that as the ethics version. The other version, which is being called the committee version, has certain amendments that were proposed by Supervisors Peskin and Tang. Some of those amendments overlap with staff's proposed amendments. Some of them are the same. Some are different. Some go further, and we can go through that separately, but not in this presentation. And then also the committee version of the ACAO does have Supervisor Peskin's major donor financial disclosures piece that has been amended into the committee version of the ACAO. So before I go through the changes that are in the new staff's recommended amended version, I'll just mention that our recommendation to you today is to accept this amended version, to vote to approve those changes, and additionally to vote to place this item on the June 2018 ballot. You could also accept the changes and not vote to put it on the ballot and merely approve the amendment that the Budget and Finance Committee made yesterday and basically adopt that version and then allow the board to continue through their process with that. But staff is recommending that you vote to place this on the ballot. So if I may, I will refer to the memo on this item, Agenda Item 4, to walk you through the major changes.
All right, Mr. Ford, fellow commissioners, I suggest the following procedures. We have the ordinance itself, and we have the various amendments beginning at page 2 that we start, since we've adopted the ordinance and now we have these proposed amendments, I would suggest that we start with each of the amendments. First, the amendment that listed at section 2A, discuss that and vote as to whether or not we want to approve the amendment or not approve the amendment, and then go on to the next of the amendments. Oh, yeah, we'll have public comment because I think we have to vote separately on each one of these amendments. I'm getting a series of ambiguous head motions from people in front of me.
Thank you, Chair. No, we were just clarifying, if the commission takes the approach, there will be, of course, public comment on every item that the commission chooses to act on individually, although I think it's the consensus at this table that it's not required for the commission to take... Oh, I'm sorry, you do? Well, maybe you'd like to speak then.
Yeah, so I just...
Go ahead.
I was actually just saying to the executive director, sorry to disturb your explanation, but I actually agreed with your approach, Chair Kane.
And that we need public comment on, yeah, I think we do, before we vote on each one of them. And then after we've done that and dealt with the ordinance itself, we then take up Supervisor Peskin's matter. That's my suggestion, members, if...
That's fine. I just want to suggest that the public comment be limited to the subject matter of the specific section we're dealing with and not a general statement about the approach.
Boy, are you an optimist. I'll go along with that.
I think under parliamentary rules, that's right.
I agree. I totally agree with you. I totally agree with you until we get into the practicalities of what happens during public comment in our group. Commissioners, so is that the way to, is that okay to proceed? So, Pat, why don't you go ahead and address and take us through the first of the amendments at page 2A, and we'll discuss that, and then we'll take public comment and vote on it. Okay?
Great. Okay, so the First Amendment is to Section 1.114.5. In the November draft that you voted on, this would have required that for any contribution of $100 or more, that the committee receiving the contribution collect a signed contributor card from the contributor that would essentially attest that the contribution does not violate certain provisions of CFRO. So we heard from the Budget and Finance Committee, particularly from Supervisor Peskin, same anxiety that this requirement would actually suppress small dollar donors, that people that were making small contributions would perhaps not do so if this requirement were placed upon them. So in response, the amendment in this version would make the contributor card not compulsory. It would be voluntary. However, the committee would still benefit from a rebuttable presumption if they do collect a signed contributor card that the contribution does not violate those particular provisions of CFRO. So that was what already in the ordinance, that this rebuttable presumption would be triggered. However, now this would be voluntary, so the committee could choose on an ad hoc basis whether or not to collect a contributor card.
Question,
Commissioner Kopp.
through the chair. Do you know of any other jurisdiction which requires the contribution card?
I don't know of one that has a compulsory contributor card requirement. Many jurisdictions use it, but I'm not sure if any of them are compulsory.
Use it, what, voluntarily or compulsorily?
Yeah, they make one available for use, but do not require it.
So it's voluntary in other jurisdictions?
I believe so.
Right. Thank you.
So if there aren't any questions, I will.
So have you finished addressing that amendment?
Yes, that is exhaustive of 2A.
2A, you have.
Yeah, on the memo, which is section 1.114.5, the contributor
That's
card
right.
requirement.
Okay, all right. Before we get into further discussion of it, I want to thank Commissioner Rennie and Commissioner Chu for last week when I had to go, I was gone, and the week before, a number of meetings were scheduled with Supervisor Peskin and other people relating to these matters, and Commissioners Rennie and Commissioner Chu did a lot of work attending those meetings and dealing with the questions and the discussions. So I want to thank you both very much for that.
Well, I want to thank you for the compliments, but it was the staff who did the work. I was present, but the work was done by the staff.
Likewise.
You still were not struggling to deal with the beach and Kauai as I was, so to that extent, I thank you. All right, so commissioners, why don't we get your thoughts then on the amendment that Mr. Ford has just addressed?
I would move that we adopt the amendment.
I would agree. Second.
Okay, there's been a motion and it's been seconded. Commissioners, any further comment before or discussion before we go to public comment and vote?
I mean, I think there was merit in Supervisor Peskin's belief that the swearing that was necessary on our original, that the contributor would have to give, that if I were a $150 donor and I was asked to sign a card swearing that I haven't violated sections of the CPRO, which I might have no idea what they are, I might say, heck with it. So I think it makes sense. It's the committee who has the benefit from getting them and gets a presumption if it has them. but if it wants to run the risk without them, that's its decision.
Well, let me comment. I don't think it's a burden, but I don't know unless it's been used somewhere where there's information as to whether it constitutes a burden. And I would ask through the chair that, not today, of course, but that the staff specifically investigate other jurisdictions which might have such a provision. Thank you.
Okay, we can get that information from the staff at a later meeting then. All right, we'll take public comment now on the amendment.
Good afternoon, Commissioners. Lee Hepner from Supervisor Peskin's staff. I was actually kind of hoping to back up a moment and provide a little bit of a report more generally from the Board of Supervisors, if that's okay. I mean, I can certainly limit my comments to
No, go ahead, just whatever you want.
Wonderful. So, Commissioners, Commission President Keene, welcome back. I wanted to start off by thanking you all for agendizing this once again. I mean, you've been considering this for well over a year, and I've been engaged in some of that, and Supervisor Peskin has certainly been engaged in a lot of that. This really is coming at a historic time in San Francisco politics, as you know, and I think that the urgency is there. We believe in this accountability ordinance and in working together on this. Before, though, addressing staff's specific recommendations, I wanted to, at a very high level, kind of address the process as Supervisor Peskin sees it relative to the Ethics Commission's own deliberations. And, you know, as has already been stated, we've convened several meetings over the past month to go over a lot of these amendments, and I just want to appreciate staff and the commissioners and actually stakeholders on every side of this issue for attending those. Supervisor Peskin's office, as we've expressed in those meetings, is committed to getting this right and getting it done fast. We have held 2 lengthy committee meetings in the past 2 weeks, proposed several amendments, many of which are before you in your packet today, some of which are not. On a procedural note, though, at the end of the day, because of this commission's charter authority, whatever the board committee did yesterday is not before you here today. So in a sense, we were kind of in a vacuum operating in our own silo yesterday, and I'm not sure the extent to which this commission or staff was able to incorporate full analysis of what happened at committee yesterday for the commission's hearing today. Similarly, you know, the Budget and Finance Committee, the next time that it meets, will be bound by whatever this commission does today. You, as your independent legislative body, are really controlling what the Budget and Finance Committee can and cannot do with this file. And therein kind of lies a little bit of the absurdity in the process as we're experiencing it right now. Because while this should be an iterative process, it feels on some level as if we're considering amendments to clarify and in fact even to indeed strengthen this ordinance in our respective corners and not really having the productive and procedurally clear dialogue that is necessary for this to pass effectively. So yesterday at the board, Supervisor Peskin expressed a desire to convene a joint meeting between the Board of Supervisors and this commission. And it was his proposal to achieve the best and most elegant means of communicating between these 2 independent legislative bodies and producing an anti-corruption and accountability ordinance that works and, most importantly, that is implemented as quickly as possible. And so, again, to that end, at committee yesterday, we did introduce an amendment that would have deleted the operative date of January 1, 2019, in the interest of really instituting a lot of these reforms before the November election. We are in a historic election cycle for June. We should certainly be able to get some of these amendments, if not all of them, implemented before November. And, you know, voters are deciding right now on who is going to be deciding policy for this city for the next decade. Now is the time to be implementing this immediately. So I understand that this does pose an implementation hurdle for staff. And to that end, Supervisor Peskin has committed, if we go down this collective path to implement something sooner than January 1st, 2019, to give the ethics department all of the resources that it needs in order to achieve that implementation. And certainly, relative to the prohibited activity in this accountability ordinance, some of this can be implemented immediately without any back-end function on the part of ethics staff. Certainly, I understand how a disclosure requirement may require the developing of a new form and an electronic filing process, and that's a bit of a labor-intensive process. But as to a prohibition, and what comes to mind is the prohibition on contributions by folks with land use matters pending before the Board of Supervisors or another board or commission. That is something that prohibition can be implemented immediately. It creates an enforcement issue and a notice issue to the public that would be affected by this, but no back-end filing or form creation issue that would cause implementation to be delayed. So I'm happy to dive into more of these, each of these actually amendments one by one. Relative to the one that was just raised, I don't know if this body wants me to address that. I'm here all day to answer any questions that you have of Supervisor Peskin and our office's perspective on this. And additionally, to present in more detail the major donor disclosures piece and the real-time disclosures in television and advertisements that I think is something that we could implement in April of this year if things move quickly.
Commissioner Chu.
Yes, thank you, Chair Keen. Lee, thank you for coming. I had a question from a process standpoint. So, as I understand it, from what you just said, that Supervisor Peskin would like to engage in further dialogue with the Ethics Commission to revise and amend the the ordinance. Would that a couple questions? One, would that also include his proposal on the major donors piece?
So procedurally, what is taking place with the major donor disclosures piece, we did introduce an independent standalone ordinance on Tuesday to the Board of Supervisors. We've been advised by our city attorney that would in fact have to come to this ethics commission. It would sit for an independent 30-day hold and then elicit your feedback and recommendation back to the Board of Supervisors. Because that is just going to take a lot of time, we've also recommended that this body amend the major donors disclosures piece into this accountability ordinance, consider it simultaneously in the context of all of these reforms that are very much in the same spirit, and yes, that be part of the conversation between the Ethics Commission and the Board of Supervisors in the context of this accountability ordinance, or indeed, if this commission sees fit, in its communications with the Board of Supervisors as part of that iterative process that could move along very quickly in a joint meeting, could pass this piece out independently and have it approved independently of the broader accountability ordinance while we address some of the more, I think, detailed and granular issues in the broader accountability ordinance. But our priority is to get the major donors disclosures piece passed immediately and implemented as soon thereafter as possible.
And then, with regard to the Ethics Commission, I guess the ethics version of the ordinance, what is the expectation or the hope on the board? I don't know if you can speak for Supervisor Peskin or your general sense of what the committee or the board is thinking in terms of a timeline to wrap that up and actually vote and, presumably approve such an ordinance.
As to a timeline, I think that that's the real advantage of this proposal to convene a joint Board of Supervisors and Ethics Commission meeting, because that will cut out what we are currently faced with, which is the Ethics Commission making a recommendation, us taking it up at Budget and Finance. If we make any comment or amendment to that is substantive, it sends it back to the Ethics Commission, back and forth, back and forth. And that is just a lot of delay. I think that we could probably accomplish that by, if this commission acts to send forward to the Board of Supervisors the accountability ordinance with some of staff recommendations today, there are a lot of items that the Budget and Finance Committee members, and we are not on that committee, Supervisor Peskin is not. I cannot speak for the other supervisors who may have other really positive substantive amendments to this. I can't really speak for what they would do, but that back and forth is going to take a lot of time. And certainly my hope is that should you choose to put this on the November ballot and have that leverage over the Board of Supervisors to act on this legislation before the deadline to remove it from the November ballot. My hope is that the Board of Supervisors could act before then. My proposal is that we could act even quicker. Supervisor Peskin's proposal for that joint meeting would accomplish that.
Thank you.
Thank you.
Question.
Commissioner Kopp.
When would this joint meeting occur?
It's a bit hypothetical right now. I think that we would need the support of Supervisor Peskin's colleagues in order to initiate that
All right,
meeting.
so you don't know.
I would hope by the first week of March.
All right. Secondly, last month Supervisor Peskin told me that he recommended that this be on the November ballot. Has he changed his mind?
I think the logic to putting it on the November ballot again is to give the Board of Supervisors a little bit more time to pass something there that we could have implemented long
All
before
right,
January 1st.
I didn't ask for the logic. I asked, has he changed his mind?
It only makes sense, sir, to put it on the November ballot if the board acts.
I agree. So I infer he changed his mind.
I'm not sure what his mind was in the first instance when you spoke with the commissioner.
He wanted it on in December.
Okay.
I mean, November. And so as a good soldier, I said, all right, that's fine with me. Okay, thanks, Mr. Chairman.
Thank you, Commissioner.
Commissioners? Okay, thank you, Mr. Hebner.
Thank you.
Do we have any public comment?
Chair Keen, members of the commission, I'm Larry Bush for Friends of Ethics. We have 3 points that we wanted to make about the 1.114 section. The first is the issue of making the card voluntary puzzles us because this same information is required anytime you make a contribution. If you go online and make a contribution to Act Blue, you have to certify that you're an American citizen, who your employer is, your address, that this is your own funds. It's the same thing on any kind of candidate contribution form. And why it suddenly becomes voluntary when in fact the law makes it mandatory is something that I don't understand. Secondly, it fails to talk about prohibition of contributions to defeat a candidate. It's only about contributions to elect a candidate. And yet we know that it's negative campaigning that draws the greatest amount of money. And finally, in 1.114.5b, it deals with independent expenditure contributions only when it is at the behest of a city elected official and not when it's just a contribution that you make without a behest. And we know that that's where the majority of money comes from. People do not need to be coached when they're writing a check for $100,000 as to why they're doing it. Thank you.
Thank you.
Chair Keen,
Yes, Commissioner Chu.
sorry, Mr. Bush, I had a question. In these online contribution forms, are the donors swearing under penalty of perjury that they're not violating other campaign finance laws, to your knowledge?
They are affirming, and I don't know if it includes a statement of perjury, but whenever I've given, I have to affirm it in writing.
Thank you.
Mr. Bush, my understanding is that the card that I fill out when I give a political contribution has no language in which I'm making any affirmative record other than saying this is my name, this is my address, this is my employer.
Most of them have a check mark. You check and you put in the name of your employer. You check and say, this is my money. You check and say, I am a U.S. citizen.
Right.
So that's all we're talking about here.
No, the form that we proposed had a specific reference to certain sections of CPRO, and that you had to swear that you hadn't violated. And I think that was the concern that was voiced by Supervisor Peskin.
Was there an option then to just strip out the references to CPRO and just say you've affirmed it, rather than making the whole thing voluntary?
No.
That would seem to me an option.
Right.
I'm Bob Planthold. As a former ethics commissioner, I'm often concerned with process and making sure that whatever you folks decide doesn't encounter some foul-ups. So I want to bring to attention something that may be a problem. In looking over the staff memo on page 2, it talks of in addition to the members of the committee, the hearing was attended by, well, Supervisor Cohen is chair of that committee, but was not present yesterday during any part of the hearing, nor was any staffer present indicating any intent to speak. It may seem minor, but I want you to understand that even those details, she was not there. So from that, I started to look at the statements that comments were made by Supervisors Peskin and Tang. On page 7, you've got a heading that says, Proposal by Supervisor Peskin, Major Donor Financial Disclosure. During the hearing, Supervisor Tang made some oral statements of amendments she was proposing. I don't see anything in here specific to those. I don't know whether they've been formally incorporated into the memo or into the text. After the end of the hearing, I went to the office of Supervisor Tang and asked staff to print out copies. They said there was no text on those amendments, that it was just general outline. So I asked, could I have it by 5 p.m. yesterday, or at the latest by 10 a.m. today? I got nothing, not even by 1 p.m. So from this, I cannot tell whether Supervisor Tang's proposed amendments are part of this packet. And I'm suggesting that because if you start to pass something today that may lack her formal specific amendments, could that be a problem later on in terms of what the Budget and Finance Committee wants, in terms of the expectations of the board? And again, if it's in here, it's not clear. Thank you.
Thank you, Mr. Planthold. I just want to note that a part of your remarks had to do with an analysis of the Supervisor Peskin's major donor thing. What I'd like to do, and what was suggested and what the commissioners agreed to, is we leave anything relating to Supervisor Peskin's proposal separate and get to that later after we discuss the amendments. I understand how you link them in terms of the procedures and all that.
But there's nothing about Supervisor Tang, so that's my concern.
I understand, but if we can, as Commissioner Rennie pointed out, in our remarks relating to the particular amendments, let's focus in on those amendments as we talk about them.
If I could explain a little bit, Commissioner. So the amendments by Supervisor Tang are not incorporated into this draft. This is the version that has staff's recommended amendments, and that's part of the duplicated file process. So this reflects part of the duplicated file that's known as the ethics version before Budget and Finance. The version with Supervisor Tang's amendments in it are not before you.
Right.
That's the committee version. So that's the distinction there. And then also the explanation about what occurred at the hearing, that was in reference to the first hearing before Budget and Finance on February 1st. Yes, Supervisor Cohen was there on February 1st.
What we're talking about now in regard to these amendments have nothing to do with the discussions at the supervisors' meetings. In terms of what we've got our original ordinance, and we've got the staff recommendation as a proposed amendment, and we're looking at those. They may have certain similarities relating to what the supervisors have been discussing, but those are really extraneous to what's on the floor as I see it, unless someone wants to correct me.
No, that's correct. Staff's recommended amendments are based on the feedback that we got from the supervisors. Their actual amendments are in the committee version. That's not before you. So this is separate.
Well, when you attachment 3 is referred to as the Board of Supervisors version, committee version. Is that
Attachment
right?
3 to this agenda item.
Yes. There's a document that says.
Yeah, sorry. Yeah, yes. Attachment 3 are the comments and proposed amendment by Supervisor Peskin.
Is it just, it's not the proposed amendments that were the subject matter of yesterday's meeting?
No.
Okay.
Apparently not, because as was discussed by Supervisor Peskin's aide, it was just done yesterday, and we really haven't gotten the benefit of that, any of that.
Well, that's what I wasn't clear on when I saw where it says Board of Supervisors.
Right, and also just to clarify, this memo came out on Wednesday, and the second hearing at Budget and Finance was Thursday yesterday.
Okay,
so
okay, fine.
we're trying to orally, fill you in on what's
Right.
happened since this memo came out.
Good. Thanks.
It's a moving target, yeah. Okay, further public comment?
Ray Hartz, Director, San Francisco Open Government. Before I comment specifically on this point, and I'd like to raise a question as to whether Mr. Hepner is appearing here as a public citizen making public comment or a representative of the Board of Supervisors, in particular Aaron Peskin. He can't have it both ways. The public needs to have a clear understanding as to what he is saying and whether or not it is an actual representation as his official in his official capacity as an aide to the supervisor, or whether he is including his own personal public feelings about this matter. And I sincerely hope that this before you, and you've really thrown some confusion into it, it doesn't include anything that happened at the meeting yesterday, because then you're in a public notice quandary because you didn't send out anything. And I'll be honest with you, I at this point have serious questions as to whether right now issues are being raised that were discussed yesterday, and the public was given a representation that none of this would have been there, and now you're trying to say that it isn't, but it is being talked about. So I think you can't have it both ways. Either it includes something from yesterday or it doesn't. Either he's speaking as a representative of the Board of Supervisors, in particular Aaron Peskin, or whether he's speaking as a public citizen, and his comment periods should not be during public comment unless they are his personal public comment. Now, as far as the actual agenda item, I agree with Commissioner Keene. Telling people you have to sign this form that says that I certify that I'm not violating CIFRO or any other campaign finance, 99.99% of the citizens of this city wouldn't have any idea whether that was the case or not. They wouldn't have the faintest idea because they wouldn't even know what those things were. So to put a requirement on them before they can give a political contribution of certifying that they're not in violation of some law they're not even familiar with is the ultimate absurdity. And the reality is the only thing this will do, if you require people to certify it, is turn this public contribution issue into the same thing we have with public finance of elections, where only the big people with a lot of money can afford to go through all the paperwork garbage that you force them to put in. And the only people who seem to get caught in the machinery are the small candidates who get small donations and a few hundred people to sign for them to run for an office. And now they're the ones who end up getting fined because they can't find all this points of the law. And again, this I agree with Aaron Peskin. It makes no sense to make this mandatory, but it makes no sense to do it if it's not.
Commissioners, on the prohibited attestation piece, or the prohibited contributor attestation, on behalf of Supervisor Peskin, our representation was that this does provide a disincentive to small dollar donors. To Commissioner Chu's question as to whether this is under penalty of perjury, it may not be, but the civil penalties that are in section 1.170 of this code do authorize a $5,000 fine and up to 6 months imprisonment for a violation of this code. So if I'm a small dollar donor, $25 donor, who should be encouraged to contribute, we should be amplifying that voice in these election cycles. If I am going to spend $25 of my money and then sign on to a form that says I'm 18 years old, happy to do so. Happy to make a representation about my employer, about my occupation, what have you. But if you ask me to make a similar attestation under the penalty of $5,000 or 6 months imprisonment as to whether I am a, quote, prohibited contributor and want me to look up that law and determine whether I am, that is going to chill my contribution. So either put a threshold in or make it voluntary on behalf of the committee.
Mr. Chairman,
Yes, Commissioner Kopp.
to the staff, doesn't this apply only to $100 and more?
It does not. And maybe
Wait,
staff can
wait,
correct.
wait,
And
wait,
I'm
wait, Mr.
asking
Hefner.
our staff.
Oh, excuse me.
Yes, it does, and what we're currently proposing is voluntary.
I know what you're currently,
Yes, it's $100.
it's $100.
Yes.
All right, now, Mr. Hepner, where'd you get this $25?
Maybe I'm wrong, but my read of the code is on the prohibited contributor attestation that there is no dollar amount attached. If I can be shown in the section to that, maybe that would alter the representation on behalf of Supervisor Peskin's office.
Mr. Hepner, what I'm going to do, sort of as a ruling of the chair, in order to keep the flow of this going, we do appreciate your presentation, and we do appreciate all of the information and feedback and the valuable contribution of Supervisor Peskin in this area. However, in regard to our discussions relating to it, I would ask you that you, and sort of goes along with something Mr. Hart's observed, that as we get to each point of public comment on it, if you want to publicly comment on it and give your opinions on it, we'd be happy to hear it. But I don't think we can have this continued colloquy in regard to. No, it's not. I'm not blaming you for anything. I think it's our fault in terms of we got into it with you. But let's when we get to the last part of this, which is Supervisor Peskin's proposal, at that time we'd like to hear quite a bit from you. Okay, but until then, as we go through each of these amendments, don't keep coming up and unless there's a question. I'm not faulting you for anything, but you're very helpful. But it's better so we can get through these particular amendments if we all address it, the public addresses it, each one of those amendments, and you address it as and give your opinion on those amendments as well. Otherwise, what you've done so far, you've been terrific. So, and I want to thank you for it. And now we'll go to Mr. Marsteller. Why don't we?
Charlie Marsteller with Friends of Ethics. I would draw you back again where we started with Mr. Bush. He made very salient comments for amendments to 1.114.5A as well as section 1.114 in general and 1145B to simplify the process, making it like Act Blue, as well as to avoid some of the pitfalls in legislative attempts in the past where we've had, for instance, people filing a complaint, take a sheet and check what violation of the laws, chapters and verse they were citing in their complaint. People were clueless. The other thing that happened was that we passed a bill, or a charter amendment in 2001 that did in fact say any advocacy by the city attorney is prohibited on the year in which she's on the ballot, whatever the provision was. It was on the modification of the election law and setting up the Elections Commission. So you have to add support or oppose, because they had to rewrite that charter amendment again in 2002 because much of it was poorly drafted. So I draw your attention specifically to what Mr. Bush has referred to, and that would hopefully be a part of the amendment that you're going to make on this section, which I assume you're going to do by seriatim, correct?
Yes.
Very good. Thank you.
Any further public comment or any comment by the commissioners before we vote on the amendment?
I'm in response to both Mr. Bush and Mr. Marsteller. Is there any reason why we don't say?
Paul, Commissioner, could you just step up to the microphone, please?
Oh, I'm sorry. Is there any reason why we don't say for or against? that if it's a contribution to a committee against a candidate, that it also has the same requirement of a donor has to, or they to get the presumption, they've got to receive a card from the donor making certain representation.
I'd be happy to take that as a motion to amend the amendment if there's a second.
I think it might be helpful if we could have a specific reference to what section or line of the draft the public comment is suggesting we amend.
1.114.5. And
Yeah, so maybe for clarification, 1.114.5A is the only thing that is proposed as an amendment. So if people are talking about 1.1145B, that is not on the table for an amendment today. So I don't think it should be part of the discussion.
why is that?
People are only, Chair Keene gave the recommendation that people only talk about what's in front of this body on the individual items, and
No, but today we're.
it is not agendized. It is not agendized.
It's certainly an agenda item because the whole ordinance is an agenda item. I don't understand saying it's only the proposed changes. Maybe I'm wrong.
Well, no, Commissioner Carani, I think you're both right in terms of that. But what you're saying is, in regard, Kyle is right that what we're taking up now is the amendment and the language of the amendment, which is at page 2.
Right.
And that's what we're doing. What you're suggesting is, in regard to things that Mr. Bush has said, that there be a change, that there be an amendment to the language of the amendment to make it more extensive as to what it applies to. And you had some language for that. I think that's in order. So if you want to propose some language to amend the particular amendment that we're talking about, and we'll, if there's a second to it, we can then talk about that. City Attorney, see any problem with that?
Yeah, so let me just address the process point because I think it's getting a little confusing down here from our perspective. So if the commission is going to move to forward this to the ballot today, the commission should bear in mind that the more changes that we're doing on the fly, the more prone we are to making some sort of inadvertent error.
More prone we're doing?
To making an inadvertent error in what we're proposing these last-minute amendments. Because if the commission does submit this to the ballot today, these will all be last-minute amendments. And I know the staff has put a lot of effort into preparing these amendments, putting a lot of thought into them. But not to say that the commission can't act on further amendments, but again, if the intention or the plan is to submit to this ballot today, again, we may want to focus the discussion.
I agree with the city attorney in regard to that observation, but I'm perfectly open to any.
Mr. Chairman, may
Commissioner
I
Kopp, yes.
confirm my understanding? The commission is considering a proposed amendment, which is reflected on page 6 of the ordinance, section.
Oh, I'm sorry.
1.114.5, paren, small a.
Right.
And is that the section, through the chair, Commissioner Rennie, you want to amend by adding a line that says for or against?
I don't think that specific.
Page 6.
I know, I'm on page 6, and I don't think that specifically.
Okay, well,
Or-
I
or-
understood,
Right.
Mr. Chairman, that that's the section of the amendment that is before the commission.
Yeah, what is before the commission exclusively, and it's stated on page 2, under main criticisms expressed by members of the board, A, section 1.114A, paren A, and it's that amendment that we're talking about.
Yeah, but it's,
Right.
but it's already in the text on page 6 that way, is it not, through the chair to, whoever is answering, Mr. Pender?
That is our proposed amendment, so yes, it's in there.
That is the amendment.
Correct.
On page 6.
Correct.
Yes, it is, yes. I appreciate Commissioner Kopp's frustration. We're going sort of round and round here, but that is the amendment, and it's reflected in its language on page 6. Commissioners, any further discussion, or are we prepared to vote on the amendment? All right, is there a motion in favor of the amendment?
I think there is a motion already made.
There is, okay, and it's been seconded. Okay. It's seconded, and we've had public comment, so I think we're in a position to vote on the amendment. All those in favor of the amendment, please say aye.
Aye.
Those opposed, nay.
No.
All right, the motion passes, the amendment passes 4-1.
It does not include a mandatory
Okay, let's move now to the second amendment that we are going to take up, which is at the bottom of page 2, begins at the bottom of page 2, in regard to disclosure of bundling. Kyle.
Thank you, Chair. Okay, so Section 2B, this describes a proposed amendment to Section 1.125 of the ordinance. This section would create disclosure of bundling, and the specific amendment in this draft is to strike one of the particular disclosures, and that would have been whether or not the bundler has attempted to influence the person for which he or she has bundled contributions. So what would be left is just a more strictly financial disclosure. So who the bundler is, which contributions were bundled, and how much they were for. And it would not include attempts to influence.
Okay. Commissioners, any discussion on this amendment?
I have a question, Mr. Chairman.
Yes, Commissioner Kopp.
The amendment deletes the language attempts to influence for ambiguity. Is that accurate through the chair?
That is correct. There was concern that this would be...
I know what the concern is, please. What about the phrase practiced legislative advocacy? Does that have enough certainty to overcome the ambiguity claim?
I mean, I can't really answer that question. That's really for the members of the Board of Supervisors that raised this concern. I can't say whether that would satisfy their concern.
Well, Mr. Chairman,
Yes,
I'm going to
Commissioner
propose
Kopp.
it as an amendment to assert that language in section 1.125.
What is the language, Commissioner Kopp, that you'd be?
The words attempted to influence, blah, 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 that is being deleted. The word attempts to influence, those three words are being recommended for deletion.
And I think what you're saying is you're suggesting that we not delete them.
No, I'm suggesting substitute language.
Oh, okay.
Still three words.
All right.
Practiced legislative advocacy. And I'll get you the exact line and page where that would go in.
That's also not
Oh, I see. You've taken it out. That's what confused me.
if you-
Where was it?
If you go to page 55 of
It's
the,
on page 9, right?
yeah, but you'll have to, in order to see the language that had attempted to influence in it before, you need to go to page 55 of the packet, so at the bottom right corner.
Page 11?
Right. And in the red line version, so it's attachment 2, you can see where that paragraph was struck in line numbers 4 through 8. And then in line 6, you'll see attempted to influence, and I understand your proposal to mean you would strike attempted to influence and instead place practiced legislative advocacy there.
Yes, it sought to influence.
And sought to influence?
Yeah.
All right, that's the motion to amend the amendment. Is there a second to the motion?
I'll second it.
Okay. Commissioners, any further discussion on the motion to amend the amendment?
Chair, could you repeat the language?
I could, but Commissioner Kopp could.
Practiced legislative advocacy.
Okay.
And attempted to influence?
Hmm?
And attempted to influence, or just practice legislative advocacy?
Just practice legislative advocacy.
Attempt to influence.
It's line 8
Okay.
is the language that gets changed.
Or you could say engaged in legislative advocacy.
City Attorney have an observation here?
Yeah, just to repeat my prior caution. Again, if the commission wishes to submit this to the ballot today, I think we should definitely try to steer away from these last minute amendments and introduce new terms that don't have any definitions. Now, if it is not the intent of the commission to introduce this, submit this to the ballot today, then I think we can open up this to a broader discussion. But I fear that we're going to lose some of these amendments, and we're going to learn of inconsistencies later after we have formally submitted this to the voters. Just a word of caution.
I agree totally with the city attorney on this. I mean, we've been talking about this now for over a year, and we got it. The staff has worked hard as can be to put this in a really good form. And to start tweaking with it now at the 11th hour, I understand the concerns of Commissioners Kopp, Commissioners Rennie in regard to it, but for these minor tweaks at this point, when this is all ready to launch to put on the ballot in June, I don't think they're good ideas. That's just my personal opinion, Commissioners. So we have that motion to make that change, and it's been seconded. Do we have to take public comment on that?
I mean, you may just want to have that motion on the floor and then take public comment on this entire proposed amendment at one time.
I'm sorry, I don't understand you, Andrew.
Right. So I think you can have Judge Kopp's proposal on the floor.
Yeah.
And take public comment on that and the actual proposed amendment proposed by staff
At the same time.
Have public comment at the same time.
At the same time, and then we can vote on the amendment, and then vote on the amendment to the amendment, and then we'll vote on the amendment.
Correct, Chair.
Okay, I think that's a good idea. So we'll. I think then at this point, if there's no further discussion by the commissioners or no further amendments to the amendment by the commissioners, we'll take public comment, and then we'll go on to vote in accordance with what the city attorney has suggested. Take public comment.
Commissioners, Ray Hartz, Director, San Francisco Open Government. I'm a member of Mensa, and this is about as clear as mud to me. There are a lot of very wealthy citizens in this city, many of whom are politically active for one reason or another. If I and 4 of my friends decide we're each going to get $5,000 and give it to a particular ballot measure or candidate or whatever, they give me each a check for $5,000 each, and I add my $5,000. When I make this certification, I may have not tried to influence anybody in the matter, but I'm not able to certify whether any of my 4 friends did. I don't know them, and to the extent that I would follow them around and know if they've talked to anybody or not. So basically, you're asking me to certify something which I have no real way of knowing whether it's true or not. Did any of my 4 compatriots approach anybody about to influence the candidate? I don't know. I didn't think to ask them because I'm not familiar with this law. And when I sign this form, I'm just kind of blindly signing it and saying, well, I'm certifying that I didn't try to, certify a candidate. Now, this leaves open a tremendous loophole. If I want to have 4 of my friends, all of who've talked to the candidate about the item and attempted to influence him or her, I can then simply be the straw man. They give me their checks, I add my check to it, and I certify that none of us had, that I have not attempted to influence the candidate. Now, I'm just simply covering up the fact that my 4 friends all did. And so I don't know exactly what it is you're saying that I'm certifying. And if it's saying that I'm certifying that I didn't attempt to influence the candidate, I can do that. But what about the other 4 people who gave 80% of the money? Did any of them attempt to influence the candidate? Who knows? And when I make my statements, is it possible down the road that I maybe get hauled into court with this fine and all this other stuff because one of my friends, unbeknownst to me, sent emails to the candidate about certain matters? And then he gave me a check for $5,000. I passed it on and signed your card. Damned if I do, damned if I don't. Like I said, this makes absolutely no sense as far as clarification goes. 99.9% of the people who contribute would have absolutely no idea what this law was and whether they were adhering to it or not.
Mr. Chairman.
Commissioner Kopp.
Through the staff, does this provision apply only to the bundler?
Yes.
Thank you.
Commissioners, Larry Bush for Friends of Ethics. I'd just like to say, as a point of personal privilege from us in the public, we are not the ones who are tweaking this language. This language was tweaked by staff yesterday. All we are doing is asking that the language we have seen and worked with for the past several months now be used. So, for example, suddenly we see a provision that says that we're exempting volunteer people in campaigns. What we know is that people who serve on finance committees for candidates are volunteers. They're not paid. They're not going to show up in any record. Do we know, has that been significant? Well, Ed Lee's campaign in 2011 was asked directly by the San Francisco Examiner at the time to disclose the names of his finance committee, and he declined, saying that there was no requirement that he disclose who's on his finance committee. So that's one example. The second thing is the issue of whether or not you're influencing people is easily tied to whether or not you've hired a lobbyist or an advocate on an issue. It's not just about a financial issue. It's also about appointments to commissions. It's about policies like where is a bus lane going to go. These are not direct financial things. If you go onto the ethics webpage, to the list of lobbyists, and see what the lobbyists are reporting that they are contacting city officials about, it is not about things that have direct financial interest. I'm afraid that what we have now is the second time with an amendment before this commission that was not significantly road tested and does not reflect the reality of what's going on in the politics of the city. And you are not going to be well served if you can't match the reality of what the public faces with what you're getting from your staff. Thank you.
Thank you.
Charlie Marsteller for Friends of Ethics. It seems to me that since we are talking about lobbying in effect, or lobbyists and lobby registration, that we might want to also include the term practice legislative or administrative advocacy, because that's the terms in the law. Thanks.
Thank you. We've received a letter from Supervisor Peskin, which nicely clarified the sort of confusion we were in earlier in regard to the remarks of Lee Hepner, Mr. Hepner, during public comment in terms of, it says, I hereby authorize Lee Hepner to address each of the individual amendments to the Anti-Corruption and Accountability Ordinance in his official capacity as my staff and representative before the February 16th, 2018 Ethics Commission meeting. Mr. Hepner, thank you. That clarifies things very nicely. Do you have any, do you want to address the Second Amendment that we've been addressing?
You told him to wait till the end. And do them all at once.
Do them all at once?
Yeah, I thought that's what you'd suggested when we get to the Peskin Amendment.
No, I was actually talking about him addressing what's in the, all in the Peskin Amendment all at one time. But if Supervisor Peskin's representative wants to address these particular amendments and confine his opinion to the particular substance of the amendments rather than going into other things that might be on Supervisor Peskin's plate, that's perfectly fine. And now we can see how he'd be addressing them. So do you have any comments, Mr. Hepner, in regard to the disclosure of bundling amendment? You don't have to. But
yeah.
You do.
Respectfully, I missed the entire discussion. I'm not sure what I'm commenting on, so I think I'll sit this one out.
Smart move. Okay.
With the consent of the seconder, I'd like to amend the motion to amend, add, and administrative.
And administrative. Okay.
Legislative and administrative.
Okay, that's the motion has been, it's been accepted by the seconder, Commissioner Rennie. Any further discussion before we vote first on the amendment to the amendment and then on the amendment itself? Commissioner Chu, did you have a? No, okay. Now, so we're voting now on Commissioner Kopp's language, proposed language, amending the amendment. Commissioner Rennie.
I have one question, Commissioner Kopp. Did you mean to insert back in paragraph 4? In other words, it's now out.
Yeah.
So that you are suggesting that paragraph 4 be put back in with the amended language.
Yeah, thank you.
Okay.
And just for the record, could we please read that as amended?
I think that's a good idea.
Okay, so this will be start on line 4, page 55. Whether during the 12 months prior to the date of the final contribution that makes the cumulative amount of the contributions bundled by a single individual totaling $5,000 or more, the person who bundled the contributions practiced legislative and administrative advocacy and sought to influence the city elective officer who controls the committee in any legislative or administrative action, and if so, the legislative or administrative action that the contributor sought to influence and the outcome sought.
Thank you.
Okay, all those in favor of Commissioner Kopp's amendment to the amendment, please signify by saying aye.
Aye.
Those opposed?
Aye.
Say nay. I still don't know who's opposed besides me.
Oh. I thought I said no.
Oh, I'm sorry, I didn't hear you. That's my fault.
No.
No. Okay, 3. That's my aging hearing. Okay, so we have 3. So the amendment to the amendment fails, 3-2. Now let's go to the amendment itself. And all those in favor of the amendment, please signify by saying aye.
Aye. Aye.
Any opposed?
No.
The amendment passes 4-1. Okay, so let's go to now the next amendment, which is reflected at page 3. It's the amendment to section 1.127. Kyle.
I'm going to attempt to shorten this process up and hopefully make this a bit simpler. So if you would all turn to on your packet's agenda item 4, page 60. Okay. Section 1.127 was dealing with persons with land use matters before a decision-making body. Staff is proposing in deliberations with Commissioners Chu and Rennie, and in deliberations with the members of the committee, that be deleted. That is reflected here in the crossed out language. The amendment is to delete in its entirety provision 1.127.
Okay, that is the amendment. Commissioners?
I move that be accepted.
Second.
It's been moved and seconded. Any discussion, commissioners?
Yeah, question
Commissioner Kopp?
to the staff.
Yes.
With respect to the bottom of page 3, the definition of developer is arbitrary and does not reflect real world land use transactions. What does real world mean?
That provision is being deleted. I can't speak to that.
Well, who?
That was a criticism from the board.
From the Board of Supervisors? How about Mr. Hepner? What's real world?
Yes, and just to be clear, Section 1.127 has been before this commission since Supervisor Peskin introduced this amendment in January of 2017. We did not request that this be deleted. Rather, I think it would be appropriate for this body to conform it to the version that Supervisor Peskin put before this body. To your point, Commissioner, the definition of developer we thought was overbroad and vague and did not make sense. We therefore proposed to exclude all of that definition on page 3, lines 6 to 7. I think this conforms to the version that you have, but in any event, it's on page 87 of your packet. All of the amendments that Supervisor Peskin properly noticed into the packet for this meeting, to delete the language or being the developer of that project or property. I have other comments on how to conform this properly to what Supervisor Peskin presented to this body that I think is enforceable and makes sense, matches to the real world way that these land use decisions are contemplated by the Board of Supervisors and other commissions.
Why don't you make your comments now in regard to all of the comments you have now in regard to this particular message since you're speaking?
Relative to the definition of land use matter, I don't know how this became to include, quote, any request to a city elective officer for planning code or zoning map amendment. We would request that that language be deleted from section 1.127. And instead be replaced with the threshold that we had introduced in our file. That would add the language, and which has a value or construction cost of $1 million or more. This term shall not include an ordinance or resolution, provided that land use matter shall include any ordinance or resolution that applies only to a single project or property or includes an exception for a single project or property. There's additional language after that section that we did not want to include in section 1.127, and that language that we propose to strike from section 1.127 says, land use matter shall not include discretionary review hearings before the Planning Commission. Or rather, we anticipated including that, or at least some distinction between mandatory or affirmative DR, because for people who are going before the Planning Commission on a mandatory DR, it's a completely different situation that they are presenting their case to than a case that is being presented in response to somebody affirmatively taking discretionary review from an approval like a variance or a rear yard hearing.
Thank you, Mr. Hepner. Any further public comment?
Commissioners, Ray Hartz, Director, San Francisco Open Government. I honestly don't know what the hell it is we're considering here. You go through this whole presentation of how the staff did all this work of amending and putting this forward. It was sent out to the public that this is what was being discussed, and now all of a sudden we have Aaron Peskin sticking his mitts into the middle of this with your acquiescence, I presume, since you didn't object to his little letter you just got or notice. So what are you discussing? Are you discussing what the public was told you would be discussing? Or are you discussing whatever Aaron Peskin decides you should be discussing today? And are you going to pass what the public was told you were going to consider, or fail to pass what you've told the public you're going to consider? Or are you going to just make changes willy-nilly so the public doesn't have any idea whether, wouldn't have had any idea whether or not to come to this meeting? The whole purpose of public notice is so that if I'm an affected person, if this is going to be something that affects me or about which I am concerned, I get the public notice, I go through it, and I make my decision as to whether to attend the meeting based on the fact that I believe that what is in here is or is not appropriate. Now we come in with all this other stuff that's being added in willy-nilly, changes. Your staff sits here and says, you know, it's probably not a good idea to start making changes in the middle of the stream. And you go, yeah, that's fine. And then you proceed to just go ahead and do it again. And the second thing is there's a clear conflict of interest here. Number one, the three people we're talking about in disposing with this are the city attorney, the board of supervisors, and the mayor. And so basically 3 out of the 5 people who appoint you to these chairs are saying, oh, we don't want a restriction on us getting contributions, take it out. And you're going to do their bidding. That's what it looks like to me, and I think that's what it looks like to most of the public. And getting little notes from Aaron Peskin in the middle of the meeting and saying, oh, yeah, Mr. Hepner can come up willy-nilly and the public can figure out whether he's actually representing Aaron Peskin or whether he's representing himself during public comment. Public comment is public comment. It is not Mr. Hepner representing the comments of Aaron Peskin. Aaron Peskin is my supervisor, and he's a shady character. I don't trust him any further than I can see him. And the bottom line is you're going along with this in such a way that I can't see any way that this makes it onto the June ballot in any credible function where you can go to the public and give a representation that this wasn't unduly influenced by the people who appoint you to those seats.
Mr. Chairman.
Commissioner Kopp.
For the record, Aaron Peskin is not a shady character. Aaron Peskin is a trustworthy person. Thank you, Mr. Chairman.
Thank you, Commissioner Kopp.
And also for the record, the discussion that Mr. Hepner was having is part of the record that was circulated to the public, and the public knew that was an area of comment. It's not something that just came up by Mr. Hepner.
I would like to second Commissioner Rennie's observation of that. Everything that we've been discussing so far has to do with the particular literal amendments that are stated in the attachments that have gone out to the public, and we have not departed from that. We've had one proposed amendment change to add some language so far to one of those amendments, and that proposed amendment change to add that language has been defeated. So far we have been faithful completely to the language that we gave the notice of the public that we'd be discussing. Okay, so further public comment.
Commissioners, Larry Bush for Friends of Ethics. I'd like to respectfully point out that your agenda says that you're going to discuss the anti-corruption ordinance. It does not say you will be limited to those points that were raised in a staff report. So we've just, for example, skipped over 1.126, which is about contributions from contractors, where we had wanted to see that you adopted a provision that banned contractors from bundling, just as we do lobbyists and others, as well as from paying for trips. But it's not on the agenda of what the staff gave you, and so it's not coming up on anything you're doing. That's where it turns out that what the public comes expecting to be able to discuss is not going to be discussed. That's wrong. Thank you.
Thank you.
Charles Marsteller again for Friends of Ethics. I've been around 20 years watching the Ethics Commission and this city, and I think it's clear to the public, the people who pay taxes, that after so many press articles that land use is the mother's milk of politics in a city which has some of the highest land values in the world, particularly in an era when we've become an international city from our perhaps provincial backwater state, which I'm joking. But in any event, it's clear that this could be rewritten in a way where you can amend this to be in conformance with Mr. Peskin's knowledgeable approach, because he too is a land use specialist, as you know. He did this as a private citizen for many years. So I would urge you to be cautious on deleting some of these things, particularly when Mr. Peskin may be actually advocating for some tweaking of the language so that the provision conforms with his concepts moving forward now at the Board of Supervisors.
Do we have any further public comment? Kyle?
Just could I make a brief comment, please?
Sure.
With all due respect to the supervisor and commenters, we're deleting this provision in the interest of our recommendation to place this entire item on the ballot in due regard to the comments that we heard at Budget and Finance and that we've been hearing from interested parties. We are by no means just merely trashing this issue. We are merely tabling it so we can have further discussions with building inspection, with planning, with the supervisors, hopefully, and get this language right. But to have 12th-hour amendments, I think, is inappropriate if we want to move this forward.
I agree with that, and I think what the staff has done quite responsibly is attempted to draft a nice, clean ballot measure that the voters can look at in June and understand. Many of these other things that we may be addressing have tremendous merit, and we're not abandoning them at all, as Kyle has said. We're going to be taking them up further in ordinance discussions with Supervisor Peskin, among ourselves, but we're certainly not making any judgments relating to it. We're just putting the final version on a ballot amendment that's going on the ballot in June, after the staff has heard all of this input and has worked very hard to get it to the form that we have it.
Mr. Chairman, I have a
Commissioner
question.
Kopp.
In light of the last comment on page 4, describing the proposed amendment, the staff says that, in pertinent part, a contribution restriction based on participation in a land use matter would likely be better executed through a separate process that can properly address the various concerns raised by members of the board, meaning the Board of Supervisors. What is that process?
So I think that process is sort of what I just laid out. It's going back and meeting with planning and the persons in the know and clarifying the language, probably working again with Supervisor Peskin, who originally proposed this piece, and ensuring that we get this right.
Well, for when? For June, November, for the ballot, for a Board of Supervisors ordinance?
I think as soon as possible after this item is concluded.
Well, what do you contemplate, a charter amendment?
No. It would be an ordinance.
An ordinance?
Correct.
All right, and you think legally, Mr. Chen, that's legally justifiable, an ordinance?
Yes, that is a subject matter that could be addressed by ordinance.
All right.
Any further public comment? Okay, then I think we're ready to vote on the amendment to section 1.127. All those in favor of the amendment, please say aye.
Aye.
Those opposed?
No.
Okay, the amendment passes 4-1. We now go to page 4, which is the amendment to section 3.207, the conflict of interest provisions.
Thank you, Chair. I'll address you from here if that's all right.
Sure.
And if you don't object, I'd actually like to skip 3.207 because what this says is that there is no proposed amendment.
Oh, I'm sorry, you're right. That's purely informational in regard to what it says, but that's not going to be an action item. But Supervisor, Commissioners.
I do want to ask the questions regarding section 3.207.
Please,
I don't want
yes. Yeah.
Would you like me to preface this with what's in the memo, or
Yes,
would
please.
you like to pose your questions? Okay.
Yes, please.
Sure.
Background.
So 3.207 contains conflict of interest provisions, which are described here in the section summary. I won't go through each one. I'll skip to the criticism. So one of the rules uses the term anything of value, which is a defined term. and essentially says that an official may not accept anything of value if it's reasonably to be expected to influence their actions. And this term was criticized as being vague, as too broad, and various suggestions were made as to how to fix this, removing some words or adding, with concrete monetary value or something. But the approach that's reflected here is not to change it, but instead to depend on the term reasonably to be expected to influence their actions as a sufficient limiting component. So even though the term anything of value is in fact broad, that's by design. So it would incorporate things with little value, granted. However, things of little value are not reasonably expected to influence an official's official conduct. So an example that came up in discussions with the committee was, what if somebody gives an elected official a ride, just gives them a ride to City Hall? That could be something of value, could be a favor, and therefore it would trigger this provision. So to an extent that's true in that it is within the definition of anything of value. However, it's very unlikely that that is reasonably to be expected to influence their vote on an ordinance, for example. And that's where the analysis in this provision lies, is what's reasonably expected to influence someone's judgment. And I think that staff contemplates that perhaps a solution is to just clarify in a regulation to the definition of anything of value that it excludes items of de minimis value. I think that would be perhaps something that could address that concern. But by and large, staff thinks that the term reasonably does inject a reasonable limitation there. So the other point that we address here is what does it mean for an official to be associated with an organization? So an amendment was suggested at committee that this not include organizations for which the official or the official's family member is a volunteer. So, for example, if this person were an unpaid director at an organization, that organization should not be considered one with which the official is associated. So what that would mean effectively is that the rule that says an official may not use his or her position to direct value or to seek a benefit for an organization with which that official is associated, that rule would not apply if the official were, for example, an unpaid director of an organization. That official would not be prohibited from using his position to try and direct things of value to the organization that he's a director for. And I think as staff, we thought that undermined part of the core purpose of this rule, that even if an official doesn't get monetary compensation, the official still arguably would get benefit in some form by directing benefits to that organization, whether it's prestige or an indirect non-monetary benefit, that there's still a danger there of pay to play, of someone using their position to try and influence people to direct benefits to an organization that official is an unpaid director for. So that's why that amendment is not reflected here.
Yes, Commissioner Lee.
Thank you, Chair, and thank you, staff, for clarifying this. And first of all, just for clarification, I'm the only non-attorney on this commission, so I want to make sure that this is not a...
Be grateful.
I am. Badge of honor. Since I started on this commission, we've discussed this proposal, and I must commend the staff for your openness to really engage with the stakeholders, because I've seen improvements at every meeting. The anything of value to me has continued to be a major concern. Mr. Ford had mentioned about, the expectations that anyone could reasonably not expect influence. But we are in an alternative fact type of times right now, and the way this is written is going to have a chilling impact on the most vulnerable population in our city, the community service agencies. And I had mentioned, and the latest federal budget proposal has really affirmed that the community service agencies and nonprofits are in for a really, really rough ride. And this is a time that the city really need to bring together the public and the private sector to really address the human issues that we're going to have to face. And again, the anything of value is too broad. And even if you say that anyone could say that, hey, you know, just because you gave them a ride does not mean, but there will always be someone who would just say that, well, you gave someone a ride, therefore you were bought. And at this time when we're trying to encourage people to get involved with civic engagements, it's also going to be scaring off people that they don't want to serve in commissions. Because if you have to choose to serve your school or your community arts center or what have you, under this rule, anything of value is still so broad that, you know, using another example that folks have brought up is if you're a nonprofit trying to do a walkathon, one of your staff or your board members happen to be on the city commission, but if you need to use a business for a water station, that is anything of value, and that's prohibited. That is going to hurt the nonprofit or the community service bottom line in terms of their financial and service programs. So I still believe that this is too broad, and no matter what language is going to put in, you're expecting people to be reasonable. And I feel that if we were to put this on a ballot, we need to be really specific.
Yeah.
And if there is not an opportunity to put a monetary value on that, my proposal is to delete the whole section, because there's already language to really address the potential conflict of interest without hurting inadvertently the folks who will be really in need of a public-private partnership that we will need to rely on for the next few years. So I like to make a proposal to amend this, and by deleting the section A, what's the section A? That address the anything of value, that whole paragraph.
Okay, is there a second to the amendment?
I'm sorry, so through the Chair King, through the Chair, Commissioner Lee, you were proposing to amend section 3.207 by deleting subsection A? I just want to make sure I understand.
Yes.
What section?
A.
Definition
Was
section?
anything of value?
The anything of value.
Yeah,
Which
that's
is,
section 3.203.
Section 3.207, section A, subsection 1.
Well,
Those
but
are
the definition,
Yeah.
I guess the problem I have is you give some illustrations, but what the prohibitions are, it says no if you look at 3.207, 1, no city elected officer or member may use his or her public position to obtain anything of value. You have a problem with that?
Yes.
That a public official should have a right?
No, she wants to delete the term.
I know, but what are you putting in its place? What are you putting in its place? What is it that the public official is prohibited against?
Well, right now, the way I interpret this, anything of value would mean if a supervisor is going to be if a supervisor is going to be a co-chair of a fundraising event for a community service agency within his or her district, he or she will not be able to ask for anything of value, including someone lending a storefront for a water station, for a walkathon, or a temporary station for people to stop by, or a Warriors stadium walkthrough. So for me, it goes back to the whole broad interpretation of what anything of value is. I don't have problem if people put in specific monetary value, if they say anything over a certain amount, which was something that was recommended, I think. But the way it is left right now, anything of value could be, as Mr. Ford said, a ride to an event, or lending a storefront to hold an event when nonprofit organization will not be able to rent a facility. So for me, given the dire situation facing nonprofit organizations and community service agencies providing vital human services, this would be a chilling deterrent for folks to really want to help out nonprofit and community service organizations. So therefore, my proposal is we either put in, but that was something that that was rejected. Someone mentioned about monetary value. So my amendment is then we just take out the number one, and number two actually address the conflict of interest too, because
Well, let's take them one at a time there, if we can, Commissioner. I hear, the chair hears a motion to delete the term anything of value. That's one of your motion. Is there a second to the motion? There being no second, I'm sorry.
The deletion would be from section 3.207A subsection 1.
Right.
And not from subsection 3.
No, it's section 3.207, section A, and subsection 1. No city elected officer or member of a board or commission may use his or her public position or office to seek or obtain anything of value.
So may I ask a question?
Okay, sure. Then I'd like to get to hear whether there's a second. We're going to continue discussing this.
Well, before we get
Well,
to that.
Commissioner Chu has a
Oh, I'm
Sorry,
sorry.
no, you had a question as well?
Well, yeah, I'm not sure. Do you want it to read, is what you're asking that 3.207A1 should read, no city elected officer or member of a board or commission may use his or her public position or office or seek to obtain anything for himself or herself, his or her immediate family, or an organization with which he or she is associated?
No, it would be for an organization with which he or she is associated. So
I think in the interests of order, I think in terms of Robert's Rules of Order as well, at this point, since we've had significant discussion since there was a motion, and we haven't had a second yet, I'm going to ask my colleagues whether or not there is a second to Commissioner Chu's motion to amend and take out the language anything of value. Do we have a second to that? There being no second, the motion dies. Let's, Commissioner Chu.
Yeah, so I wasn't prepared to second the motion because I think there is, I have a few questions that I would like to have some discussion with Commissioner Lee and also hear from my fellow commissioners. So, Commissioner Lee, is there a dollar threshold that you would contemplate for this? Or is this anything of value deletion is only with respect to organizations, but not for their own private or professional benefit?
For me, is the organizations that the individual is associated with.
I see. Okay.
So maybe I didn't make it clear. Too much antibiotics. The intent was anything of value applying to the organization that the individual, the elected official or the appointed official is associated with.
I see, but it would stay for that they cannot seek or obtain anything of value for their own family or personal or private benefit. Okay.
Okay, so in regard to that, since there is this particular part, there is no action anticipated, we need not take public comment since we're not going to vote. And we're moved now on to the next item, which is the item relating to repeated recusals. And could we have the presentation relating to that?
Yeah, I will set this up, explain just briefly what these amendments are, and then Director Pelham will speak as to why they're here. So Section 3.209 sets up a procedure for the Commission to review repeated recusals. So the amendments that are here, one will change this provision so that it only applies to members of city boards and commissions, not including the Board of Supervisors. Previously, it had a clause that said including a member of the Board of Supervisors. You'll see on page 72 of the packet, if you look at the red line version, line 12, that has been struck. An additional amendment is to add a notification procedure, and this language is taken from the municipal code in Los Angeles. So the notification procedure formalizes a way for a board or commission member who is recusing him or herself to formally notify the Ethics Commission. And you can see there are certain requirements. They have to state their name, board or commission that they serve on, where the recusal, when the recusal happened, et cetera. And there's a 15-day deadline to submit that. And then we changed the recusal review language. Also, again, taken from Los Angeles because the language, after reviewing it, we found it to be more precise. And also we'd benefit from some interpretation that they've done of the language to help clarify that process. And then you'll see subsection D was added at the city attorney's advice that we should make clear that this doesn't apply to the Board of Supervisors. So that's why that is there. So I will turn it over to Director Pelham to add on to this a bit.
Thank you, Pat. This is an example of something that we took a very close look at following comment from the first Budget and Finance Committee meeting, and also hearing comments that others made at the time and around that. And I think from in hearing the questions, there were a number of questions about what is the recusal review's purpose and how would we count this 1% trigger for a review. So I just wanted to provide a bit of background on that. The language and the thrust of this proposal really is a basic transparency issue. It would provide a way for those who recuse under the law and do a good thing by recusing to avoid conflicts. It would provide an opportunity for the public to have a chance to understand repeated recusals so that there can be an opportunity to engage around the basic threshold we have or tolerance we have for conflicts in city decision making. So if there is a repeated recusal, and we'll get into how this approach would calculate that. There is a process for the Ethics Commission to review those recusals and determine whether there's an ongoing and significant conflict that exists for that board and commission member, so that the commission then, if it believes it is warranted, can recommend to the appointing authority that perhaps that individual shouldn't sit in that particular role, or they might divest. But this is not a mandatory ethics commission taking somebody off of a commission. It's really a transparency tool and a way to elevate the significance of avoiding conflicts in city decision-making. So what this would do is essentially create a system that's parallel to what has been in place in Los Angeles for a number of years. But essentially, a commissioner has to recuse each time a matter appears on an agenda. There would be a process and a form and tools to enable the commission member to do that. The form would be filed with our office, and essentially it's a one-to-one relationship. If there are 3 recusal forms, as it's proposed here, filed within a 365-day period, or 1% of all matters that have been appearing on the agenda, that would be something that the commission would then review. And in reviewing that, the commission would look to things like, is the number of recusals by a particular commissioner significant? Is the subject matter of the recusals significant, even though it may be ongoing? And is the impact of the recusals significant? So these are questions that would be part, or could be part, of every review. And that would be, we envision it would be a staff report to the commission. The commissioner would have an opportunity to respond and to be able to have a discussion whether or not there is a repeated recusal in place that would suggest that commissioner's financial interests that are causing the repeated recusal might be a reason to talk about whether that commissioner should not serve on that commission or should be recused or divest of those interests. Again, that's a decision for the appointing authority of the commissioner. This is a transparency measure to help with that discussion. So again, this focuses language a bit more clearly in an attempt to be more clear about how this process would work. We've looked to another model that's working in another jurisdiction, and also tried to be clear with what it is that would trigger the recusal requirement and what would be the result of a recusal requirement in order to determine whether something is continuing and significant. So with that, I'm happy to answer any questions or hear public comment, but I wanted to provide a bit of background on what the change was here as we've looked to narrow it.
Commissioner Kopp.
Does the Los Angeles ordinance have a time within which the official must divest or otherwise remove the conflicting interest?
I don't know. The Ethics Commission has, as I understand it from their current staff, has not ever required a commissioner to divest.
So there's no experience with it.
Correct.
Well, it seems to me there should be a time limit, Mr. Chairman. And I don't know what a practical time limit is, but so that the public may comment, I'm going to move an amendment on page 26 under C2, after the words fails to divest or otherwise remove the conflicting interest, add the words within 90 days of the Ethics Commission's determination.
That's the motion. Is there a second?
Chair Keane, may I offer an additional amendment to your amendment? So within 90 days or as promptly or as reasonably practicable, because in the event that it is an interest that will take longer than 90 days to divest, I don't think that we can cover everything with 90 days.
Commissioner Chu, can I take it that you're seconding Commissioner Kopp's motion and you're offering
Yes.
some additional language?
Yes.
And Commissioner Kopp, do you accept that?
Tell me the language again.
So that the divestiture or the removal of the conflict of interest would need to occur within 90 days or as promptly as practicable.
Reasonably practical.
Promptly.
As practicable.
Yes, this is the Ethics Commission.
Okay.
Command to the appointing authority.
I'll accept that.
Okay, that's been accepted. So we have the motion to amend the amendment to add that language. And commissioners, any discussion?
As worded, Commissioner,
You gotta
you
sit in closer, Paul.
as you amend the amendment, you in effect say they have 90 days in which to do it, but if they don't do it in 90 days, they can extend it out if they can show some practical necessity. I would be disposed to say they'll do it as promptly as possible, but no longer than 90 days. But I don't feel
I
strong.
would accept that.
I mean,
Accept that.
the, sometimes, you know, and if it's a divestiture of a private equity interest or something, it might not happen within 90 days. You know, there could be closing conditions that would require a longer time period, but if they've entered into an agreement to divest, but they need antitrust, you know, regulatory approvals, that it could conceivably take more than 90 days.
So, Commissioner Rennie, are you proposing your change in the amendment in terms of the language that you just stated?
I will not propose any change from the language that has been
moved and second.
If the moved and second, if the commission is satisfied that the extending it beyond 90 days is in the public's interest.
Well, my contemplation is that it wouldn't be at the discretion of the commission member or board member, but that if they have moved to divest or to remove the conflicting interest, but it's not practicable or it's not possible to complete it within the 90 days, I wouldn't want them to be penalized for it. That if they have gone to sell shares that they have in a startup or, you know, a private company, but can't, you know, complete the divestiture within the 90 days, that they would, but they have taken steps to do that, and it would take 91 days or 100 days, that would still be acceptable to us.
Or a year. But you're through the chair, Mr.
Yes,
Chairman.
Commissioner
I may
Cobb.
be recognized. The Commissioner Rennie suggests maybe the Ethics Commission should have the authority to determine whether the time is as practical as, or as prompt as is practical.
That's satisfactory.
Yeah,
From my-
maybe that should be it, so it isn't open end, and then you have a dispute as to whether it's practical or impractical. Can you give us language, Mr. Chen?
Actually, I would like to take a step back, if I may, on this provision. So this provision...
Well, that isn't what I asked.
Right, but I think it may be helpful regardless. So this provision allows the Ethics Commission to make a recommendation as to a official's potential conflicts of interests. It is merely a recommendation. So in that recommendation, should the commission wish to issue it, I believe the commission can also specify at the time that's issued whether they would recommend that that interest is disposed of in 30 days, 90 days, so on and so forth. So I'm not sure if you necessarily need to introduce a limitation one way or the other at this point.
Well, if it's what difference it make? I mean, it makes a difference if it's a recommendation, but as far as language is concerned, what difference does it make if it's causing a recommendation? Can you give me while other people? Can you give me language, or you want me to write it myself?
May I take a stab at reiterating what I think I heard?
Yeah.
So this begins on page 25.
Right.
Page 25 well, it's agenda item 4 amended, page 33. It's shown as page 25 at the end of the page on the right-hand corner. But it starts reading on line 24. If the Ethics Commission so determines, the Ethics Commission may recommend to the official's appointing authority that the official divest or otherwise remove the conflicting interest, And if the official fails to divest or otherwise remove the conflicting interest, insert, within 30 days or within 90 days, or as the Ethics Commission determines as reasonably practicable. The Ethics Commission may recommend to the official's appointing authority that the official should be removed from office under Charter Section, et cetera, et cetera.
I withdraw my previous amendment, and I adopt that language in a motion to amend.
Okay.
And invite a second.
Okay.
I'll second. Where are we? In terms of, Commissioner Chu, you've heard the colloquy between Commissioner Kopp and seconded by Commissioner Rennie. Does that also encompass your concerns, or would you?
Well, actually, it raises new concerns on my part, because I don't think that the Ethics Commission should be in a position to determine whether or not a sale or a divestiture is proceeding as timely or as quickly as we would like. In that we are simply making a recommendation to the appointing authority.
Yeah.
I don't know that is it a difference that makes a difference?
Only to the effect that you have a motion on the table, and I'm
Right, yes,
asking whether
no.
or not, I don't want to do anything that short circuits what your intent.
Well, so I
was.
think the first motion that Commissioner Kopp presented, he has withdrawn. That's the
That's
one that
right.
I had seconded.
Exactly.
Right. So I'm fine with
Good.
that withdrawal.
All right, terrific. All right, so we have the language that Ms. Pelham put forth that has been proposed by Commissioner Kopp and is seconded by Commissioner Rennie. Is there any, and that's as an amendment to the amendment, so when we take the ultimate vote on this, we'll vote first on the amendment to the amendment and then on the amendment itself. Is there any further discussion among the commission on this item? Hearing none.
I move that we adopt the staff's proposal as to section
Second.
3.207.
Okay. With
the amendment?
Okay. That motion has been made and seconded. Commissioners, any further discussion before we go to public comment? I will take public comment. Mr. Hebner is going to speak on behalf of Supervisor Peskin.
Correct. Thank you, Commission President King. In your packets, you have an amendment that has been proposed by Supervisor Peskin. It exists in the Budget and Finance duplicate committee file right now. When we were looking at this recusals provision, I think we were having trouble wrapping our minds around why we are creating a disincentive to recuse. We want board members and commission members to recuse themselves when they meet the requirements for a recusal. And to that end, the clarification in subsection A regarding recusal procedures, I think, provides some good clarification around when a board member or a commission member should recuse themselves. I would suggest that this commission, and Supervisor Peskin rather, would suggest that this commission delete the subsection relative to repeated recusals. That creates this potentially punitive dynamic where if you recuse yourself more than 3 times, you are subject to removal from your board or commission, or the recommendation of Ethics Commission to be removed from your appointment or commission. That removes the disincentive to recuse. That allows for ethics investigators to instead focus on enforcement of when somebody is properly recusing themselves. The Ethics Commission can still be the repository for all of that information. Public can still go to the Ethics Commission and seek that information about how many times someone has recused yourself. And when it comes for that board or commission member's reappointment, that is public information that everybody will have before them. But let's not create a disincentive to recuse by saying that you are subject to divestiture from your financial interests if you properly recuse yourself. Let's do it right and focus on when somebody should be recusing themselves. So the proposal is to delete all of subsection B, repeated recusals. Incidentally, this is also tied to the anything of value issue that Commissioner Lee was suggesting, because if a commissioner receives anything of value, they must recuse themselves. In your packets as well, I do have, I think, a rather elegant amendment that Supervisor Peskin has introduced to the committee file to address the anything of value issue, short of deleting anything of value altogether. It would be an amendment to the definition of anything of value. That is in your packet before you. It was drafted by the city attorney for inclusion in the packet on Tuesday. It is publicly noticed in the public packet. I believe, lastly, the calculation of 1%. We've talked to staff about how you calculate 1%. And I don't think there is a really elegant way to do so. We agree that this is a transparency measure in as much as it clarifies recusal procedures, but how is the 1% being calculated? Retroactively, I understand that this exists in LA, but I don't think we've been provided with a whole lot of clarity on how LA calculates 1%, but for retroactively. We had an inadequate response there and therefore thought that, let's just delete the disincentive entirely and instead focus on compliance with the recusal requirement. Thank you.
Let me ask a question that is off the subject, but I'm curious. Why is this referred to the Budget Committee?
That is above my pay grade. That is the prerogative of the board president.
My understanding is because the amount of increased costs. Got it, I think, 200,000
It has a financial
which gets
effect.
it to the financial.
Thanks.
But Mr. Hepner, I do have a question of you. Where is
go ahead. Chair Rennie, go ahead. Go ahead, Chair, Commissioner Rennie.
I'm sorry, I was just curious, where in the packet that you say proposed amendments?
I believe they begin on page 87, our Supervisor Peskin's attached amendments.
And that's got that has a definition of something of anything of value?
There is a definition, a modification to the definition of anything of value. I don't know if it's prudent to be discussing the subsection that you guys had previously
I think not.
To.
We've dealt with that.
Okay. Mr. Hepner, I had a question for you, if Chair Keen.
I don't see any.
So, with repeated recusals, I don't think that it is the intent of this commission to chill or otherwise deter commissioners or board members from recusing themselves if they have a conflict of interest. I think the question that we're wrestling with is in the event of repeated recusals. Now, if a commissioner has matters coming before him or her and has to recuse himself or herself at the January meeting and the February meeting, and it's over and over and over again, is this not a problem?
Commissioner Chu, thank you, and through the President, I do believe that that is a problem that is best addressed through the reappointment process. I think that it is a fair grounds for the public to scrutinize whether that person properly sits on the body. I think the problem that you will run into either way is making sure that board members and commissioners are properly recusing themselves. And I believe that ethics resources would best be directed at making sure that you properly recuse yourselves when a conflict of interest exists.
Well, if you're finished, let me point out another way of looking at it, and that is it may give pause to an appointing power to appoint a member of SPUR to the Planning Commission in the first place, so that 1, 2, 3, maybe more recusals don't have to occur.
If I may respond, Commissioner Kopp, through the President, I think that may be the case as well. And again, I think that is fully accomplished with the recusal procedures clarification. I think that it's not just about the Planning Commission. What if you're an engineer on the Building Inspection Commission, what have you? This is, if you focus on the recusal procedures, you accomplish the entire goal without creating sort of a disincentive to recusing, which I think is just policy-wise a bad move.
Chair Keen, so is it the number? Is it the number of times of recusal? Because I think through the appointment process, we all sit for 6-year terms. And does the public have to wait for 6 years before, if I recuse myself 8 times out of 11 meetings, over a same issue, I can't reappoint it anyway, but is this something that the voters and citizens of San Francisco need to wait until it becomes an article in the Examiner? It's like, oh, well, this is kind of a problem. One of the commissioners is out of commission because of repeated recusals, and that there's no public forum. Now, the commission doesn't have the power to remove, but could certainly create transparency around what matters and what conflict I may have.
Right. Through the chair, again, it's not just the number, and I do believe that the appointing authority also has the authority to remove an appointed person from a commission or board if the recusals start stacking up. I think the question that I'm getting at is, say, if I'm being faced with the decision whether to recuse myself, and somebody has given me a ride to work 4 times in the past year, and the matter is actually a discretionary review before my body, and I'm making that line call on whether I've received anything of value. And I know that if I recuse myself one more time, I'm going to trigger an investigation by the Ethics Commission. That's a disincentive to recuse myself. That's not appropriate. The decision should be, I am absolutely recusing myself because the perception that it might be of something of value is there. And I'm going to recuse myself in light of that perception. We should be creating incentives to properly recuse and remove conflicts of interest from these decisions.
Where does it provide that a appointing power can remove an appointee?
Maybe the city attorney can verify that, but I'm pretty confident that that appointing powers.
I'm not confident. I am not.
That may be the case. I think maybe in my experience, it's been the appointing authority has called for somebody to step down from a committee.
It's done it de facto, not de jure.
Chair Keen, if I may.
Noted.
Commissioner Chu.
One last question, Mr. Chair. The idea of having someone after recusing oneself 3 times and having it being reviewed by the Ethics Commission has been portrayed as a negative. Why is that the case? There's no power that the Ethics Commission has to remove, and there's an opportunity to clarify and provide greater information to the public, as well as the Commission and the appointing authority as to what the circumstances were behind the recusal. So I'm not sure I follow why this is such a terrible thing.
Yeah, through the chair, I think that's a policy call for the commissioners to make, essentially. And what you're asking, though, is for a respondent to an inquiry from the Ethics Commission to not see it as something potentially punitive or interrogatory. We're asking to destigmatize an investigation by the Ethics Commission. I don't think that that's realistic, but that's a policy call for this commission to make.
If I might also clarify, this would not be an investigative process. It would be a policy review bringing forward a public discussion for the commission.
Thank you.
Okay. Further public comment?
David Pilpel. I haven't been by in a while. My father passed away, and I've been spending much of my time on that. I want to thank Commissioner Kopp for his very nice personal letter on that. I'd also note that it's kind of warm outside, so I was looking for a shady character who I can spend some time under and cool down a little bit. Anyway, on this particular provision of 3.209, I think that this is attempting to solve a problem that we're not sure really exists or exists in the scope and manner that is suggested. I would respectfully suggest that rather than, and I agree with Lee Hepner's comments, that A and perhaps B makes sense, but certainly not C. What I would suggest instead is that as part of the filing officer's report annually following the Form 700 collection, that they disclose for any board or commission that the filing officer, who's usually the board or commission secretary, addresses, that they report the name of any member who during the past calendar year recuse themselves on any matter due to a financial conflict of interest. And we try that for a period of time and see how many of the 500 plus Form 700 filers who are members of boards and commissions actually have had to recuse themselves for reason of a financial conflict of interest. There are occasional instances of this. In my experience, they are not many. They are usually related to land use matters and usually discrete land use matters involving occasionally members of the Planning Commission or Board of Appeals, more so the OCII board, but it's really a extremely limited number of individuals based on their circumstances. And as Lee Hepner said, we should be encouraging proper recusal, not discouraging it. And just finally, on the proposed subsection D, that the requirements do not apply to members of the Board of Supervisors, it's not clear to me if that applies only in their capacity serving on the Board of Supervisors, or if that also would apply to their service on other boards, i.e. the Retirement Board or the Health Service System Board, where their investments may play a role in whether or not they need to recuse for reasons of a financial conflict of interest. Thank you.
Thank you.
Hello, Commissioners. Debbie Lerman from the San Francisco Human Services Network. The discussion around this particular issue, in my view, has shown that you're not looking at the entire picture of the impact of repeated recusals. And in fact, this provision has been of deep concern to our organization and our members throughout this process. Many of our volunteer commissioners in San Francisco work for nonprofits, and in fact, they are asked to serve on commissions specifically because of their expertise in, for example, health and human service matters or arts matters or whatever. So we often see in the Department of Public Health, Department of Aging, Department of Human Services, appointees to overseeing commissions who come from nonprofits that also have contracts in that department. And the city benefits because they share their expertise through that commission, through that public service. However, their service does sometimes require them to request recusal, particularly when they are working for an organization with those contracts and those contracts come up for a vote. And this is not just a once-a-year thing. Many organizations have multiple contracts that cover each program or service. I believe, for example, an organization like Catholic Charities has over 60 city contracts, so maybe they have 40 of them before the Department of Public Health. And the only time the person is recusing themselves is when those particular contracts are coming up, but they're going to exceed that number 3 over and over. That would then subject them to this enhanced and ongoing scrutiny and report filing to the Ethics Commission, specifically because of the very thing that they were appointed for, their expertise and their knowledge around a particular area of interest. So then you have, when you're talking about asking somebody to remove the conflict or divest themselves, this isn't an investment. This is their day job. This is their career. This is the reason they were asked to serve. So it makes no sense. And then, if they don't quit their job, then the commission would then perhaps go to the appointing authority and say, this person shouldn't be on the commission. Perhaps if I was in a nonprofit in that situation and I was asked to serve, I would decline in the first place because, frankly, I would not want to have to come to this commission every time I recuse myself. So it is a major disincentive for nonprofit representatives to serve and to share that knowledge and all of their expertise for the benefit of the city and county of San Francisco. So we do support Mr. Heppner's and Supervisor Peskin's suggestion to remove the repeated recusal section from this legislation. Thank you.
Thank you.
Good afternoon, Chair Keene and commissioners, and also staff. First, I'd just like to very briefly say I do appreciate very much all the hard work both you, the commission, and staff have put into this. I think it's very evident from the various iterations of the language that public comments being taken into account, and on behalf of Alliance for Justice and the nonprofits we work with, we appreciate that. On the subject of Section 3.209, without repeating what I think Ms. Lerman and Mr. Heppner have very eloquently said about the matters of nonprofit employers, and then also the issue of disincentivizing good behavior, I wanted to point out two other issues which may be of concern from the perspective of nonprofit representatives. And that's that current law already does require a fair amount of transparency around recusals by requiring planning commissioners, city councilors, boards of supervisors to publicly recuse themselves and leave the room. And in so doing, their recusal actually becomes part of the public record, which can be obviously then appreciated by people who are present, members of the public, and of course, people who then look up the hearings on YouTube and the minutes and so forth. So that's one issue, is that there is some degree of transparency around recusals presently. And secondly, one issue that I haven't heard addressed is that many officials under current law are required to recuse themselves from matters relating to their homes. Often for most of us, that's the biggest financial interest we have, and there's not necessarily an ethical problem with needing to recuse yourself because a matter affects your home just due to your proximity from a particular matter, which makes a lot of sense when we think about it, because that's why we might serve on a particular board or commission, is because we're part of that community. So I just wanted to bring that to the commissioner's attention as well, just as another potential unintended consequence of that may affect board members and commissioners who have to repeatedly recuse themselves. So with that, I would again respectfully echo what Ms. Lerman and Mr. Hepner requested that the commission consider on this matter.
Thank you.
Commissioners Ray Hartz, Director, San Francisco Open Government. I'd like to associate myself with all the prior speakers. I think this whole section is really kind of impracticable for a number of reasons. First, as a side, I'd like to apologize to Commissioner Lee for tarring her with the attorney brush. That was a misunderstanding on my part. And unlike members of this commission, when I make a mistake, I'm willing to admit it and acknowledge it. Excuse me?
Libelous, too.
Yes. Thank you. We have a provision in the law for most boards and commissions that the people who attend the meetings or fail to attend meetings are supposed to be reported, and if they have a certain number of failures to attend meetings, that they are reported to their appointing authority and recommended to be removed. Well, I know as a practical matter 3 boards that have a number of commissioners who have not been to a commission meeting in a year, and it's not even reported, let alone as any action taken. So basically, we have a non-functioning member. Now, here you have a situation where you're going to put the onus on the individual themselves to report their recusals. And I'm saying, well, gee, if the, how do I say it, the fair person who's administrator of a body won't report somebody for not coming to the meetings, why would we expect the person to report themselves for something they've done that is wrong? And we are dealing with politicians here. So basically, this matter comes before the commission. I know it's going to be on the agenda 5 times. I know that there is a key here now that if I recuse myself 3 of those 5 times, there's going to be an ethics commission review. So I will simply recuse myself 2 times, and I will not show up for 3 other meetings. There's always a way around this. You're trying to, close doors with people that are used to finding another exit. And that's what they're going to do in this case. Number 1, that 3rd time, I just won't report it. And there's nothing in here about what's going to happen to me if I don't. And who's going to keep track of the fact that I didn't? Nobody that I can see. So I recuse myself time 1, I recuse myself time 2, time 3, I just keep my mouth shut. And then there's all the practical matters that the prior speakers brought up. Yes, we want people to recuse themselves if there's a conflict of interest. I'll be honest with you. I think there are cases where I see a clear conflict of interest in matters where the person does not recuse themselves, and I question that. And I would much rather have a situation where a person has a moral obligation or a feeling of obligation to recuse themselves without having to put the onus on them to then have a penalty that they must pay for doing so.
Commissioners, Larry Bush from Friends of Ethics. I'm looking at section 3.209 on page 24 of the material that you have. It's talking about recusals and when there's a financial interest. There's nothing in here that says of membership in a nonprofit on a board of directors. There's nothing here that gives rise to the issues that were just presented to you by members of the public. Unless I'm missing it someplace else, it's just totally a bogus issue. Thank you.
Thank you.
Thank you. No, I'm sorry, there's just one turn to each person. Okay, any further public comment? All right, then, on the question of whether or not we adopt the amendment,
Mr. Chair. Oh, sorry.
I'm sorry, Commissioner Lee.
Because I'd like to offer another amendment. Just a couple of weeks ago, several friends of mine were sharing the exciting news of them starting an informal group, getting millennial community advocates to get interested in civic engagement by learning about city commissions.
You want to speak a little closer?
By learning about getting involved with commissions and boards. And they were excited because they were looking at the new generation of leaders. They have the knowledge, they have the compassion of serving the communities, and there was a disconnect between serving the communities and serving the city. So my friends were so excited that, within this group of young millennials devoted to community service, some of them are starting to pay interest to serving the commissions. And reading this, it's going to be another excuse for some of the folks to say, see, that's the reason why I don't want to get involved with politics, because I want to do good and they're punishing me, they're penalizing me. So I do agree that even though Mr. Bush said it does not mention anything about nonprofits, but financial interest could mean a nonprofit organization's fiscal impact. So if we are touching upon these experts, these community advocates who know policies, who know the application of the proper programs and policies to really improve the well-being of the residents of the city, the recusal language is really going to punish them. So I would like to propose an amendment that would remove this section from section 3.209. And I don't know if we should take the vote on the previous two amendments.
Well, that's your motion is that we remove section 3.209 entirely. Is that correct?
Right.
Okay.
Right.
Is there a second to that motion? I'm afraid the motion fails for lack of a second. Okay. So we are, commissioners, I think we're prepared to vote. All right. All those in favor of the amendment, please say aye.
Aye.
All opposed?
No.
Okay, the amendment passes 4-1. Okay, we move now to the next amendment.
I thought there was an amendment to the.
I thought the first vote
You're
was
correct.
the amendment to the
You're
amendment.
quite correct, okay.
So there's still a second vote.
All right, now the second vote on the underlying amendment. Made the underlying amendment itself as the staff has put it forth to us. In regard to that amendment, all those in favor of it, please say aye.
Aye.
Opposed?
No.
So we have, I think I heard 4 ayes and 1 no. Correct? Okay. The motion passes 4-1. We move now to the behested payments disclosures, section 3.600. Pat?
If I may, Chair, could I recommend that maybe we take a quick break since we're approaching the hour mark?
So, good idea. Excellent.
20 minutes appropriate?
20 minutes is fine. Is that okay in terms of all the committee? Yes. Let's take a 20-minute break.
Is that too long?
15?
Let's
Get a
would have no problem without this one. But because I support everything up to here. See, which is true. Private and public benefit of him or herself or the family.
SF Gov TV, San Francisco Government Television.
Suggest that it would be wise for the staff to do the same, summarizing what I'm reading is saying, his organization, his family, his. And I think we're well into an age where, I looked at that and then I went to look at the law, so it said him, so it herself, things like this, which I think in this day and age it should be included, but that also I think should be reflected by the staff.
Yeah, David. Okay.
David, sorry about your loss.
Yeah. The pharmacist, the best kind of profession. Yeah.
Who's the pharmacist?
Yeah.
Which one?
His David's father.
But which
He had a
pharmacist?
store in, not on Noriega, maybe it wasn't.
All right, the Ethics Commission is back in session. We're now going to move to the last of the items we're dealing with for the amendment to the matter to be put on the ballot in June, and that is behested payment discussion, F, at page 6.
Thank you, Chair. I think I will direct you to the red line version. I think that'll be the easiest way to just look at these. So if you'll please look at page 76 in the packet. That's where the first change is that I'd like to show you. So as you know, the behested payment,
76.
page 76, correct. Those are the small numbers on the bottom, not the large numbers. Yeah, it says, yeah, agenda item 4 amended, comma, page 76.
Go ahead.
Okay. So as you know, the behested payment reporting system that would be created by this ordinance has been narrowed such that disclosure would only be required if a person makes a behested payment and such person is an interested party vis-a-vis the city official who is asking them to make the payment. So this version of the ordinance, attachment 1, makes an important change to the definition of interested party. And you can see that change on the final line, line 25 of page 76. And what this does is it says that now if you actively support or oppose a governmental decision by the officer or a member of board or commission who is asking you to make a payment, that will only be disclosable if you have a financial interest in that decision, whereas previously that was not a requirement. So, for example, if you contacted a member of the Board of Supervisors, tried to get them to change their vote on something, and then they asked you to make a behested payment, that would require disclosure. But now there's the extra requirement that only is disclosure needed if you have a financial interest. And then financial interest is defined above, lines 17 through 19, by reference to California Government Code. So that would benefit from the body of law that's built up around that. It's a well-established term. And then a third change is actually above. It's on the previous page, 75. There was a slight tweak to what it means to actively support or oppose. There was some concern this wasn't precise enough what it meant to act to influence. So that was changed to communicate in an attempt to influence. And then lastly, I don't need to direct you to the page, but throughout these sections, we changed the language from proceeding to matter in which someone is involved, just because that will now incorporate both being an interested party by being a party or participant to a proceeding, or by being someone who has a financial interest in a government decision and attempting to influence that decision. So matter should encompass both a decision and a proceeding. So those are the changes to these sections. Be glad to answer any questions about that.
Okay, is there a motion to approve the amendment?
I'll move.
Second?
Second.
The motion's been,
May I just suggest
Commissioner Kopp.
one grammatical addition on page 33, 77, and you go niece, nephew, put in the word and, first cousin, before you go to the next verbal inclusion.
Yes. Okay, we can make that grammatical change without any problem. Okay, so we have a motion made and seconded to approve the amendment. Commissioners, any discussion? Any public comment?
Hello, Commissioners. Debbie Lerman, Human Services Network. First of all, I would like to wholeheartedly support and thank the staff and hopefully the commissioners for accepting the amendment that it only applies if you have a financial interest. I think that this is a significant improvement and removes a lot of the risk around this proposal. I am still concerned about this broad language of including as an interested party people who actively support or oppose. And I'll be honest, the first time we saw this language was 3 days ago. I still haven't read this packet, and I have not had the chance to even wrap my head around what that means. But I know the board also expressed concern about that language at the hearing on Thursday. And to me, it says that if somebody speaks at a public hearing or takes any other action to communicate a position, which can include anything as small as signing a petition, or somebody who participates in a rally on the steps of City Hall, that would be included in this definition. And I think that it has a real risk of not only chilling civic engagement and the expression of one's First Amendment rights, but also I have no idea how you would even begin to enforce something like that. Are we now supposed to electronically deliver our petition signatures so they can be double-checked to see if there's anybody with a financial interest in there? Are we supposed to go out on the steps of City Hall and take attendance at our rallies and sign up the names? And there is, under the Sunshine Ordinance, the right to testify at any public hearing anonymously. So I just think that this is unenforceable and too broad, and I would urge that you go back to the original language that says an interested party is a license, permit, entitlement, et cetera. Perhaps include someone who hires a lobbyist or something like that. Make it a very clean definition. But this really broad stuff about taking any action to oppose or something, it could be somebody who just writes a letter to their legislator. It's too much. We also still have, I have one concern about the donor reporting section. I have a lot less concern than I used to because we're only talking about people with a financial interest, but I think there should be a safe harbor. If the public official fails to tell a donor that they're supposed to report, that donor should not be penalized. Perhaps they should be, if the ethics staff finds out that somebody didn't report, they could be told that they need to report, and if they don't do it, that's fine, but we should not be punishing donors for nonprofits. Thank you.
Thank you.
Hello, Chair and Commissioners. Again, Torrin Lewis from AFJ. I'd like to echo Debbie Lerman's strong support for these amendments, and I think this was this behested payments issue was one that many nonprofit representatives had concerns about, and I think these amendments show were really listened to and incorporated into this legislation by the staff. So we sincerely appreciate that. Specifically, adding a financial interest component and tying that to state law, I think makes a ton of sense from our perspective. And while I think reasonable minds and well-intentioned good government advocates can disagree about the particulars of a disclosure regime, I have to say that from our perspective at least, we support efforts for disclosure and transparency, and I think again, we can debate the particulars, but from our perspective, this is far, far superior to a ban, and tying it to an actual financial interest on the part of the parties is hugely helpful. So thank you for your work on that.
Thank you.
Commissioner Larry Bush for Friends of Ethics. I'm delighted that this language now is going to be everybody in free for Ron Conway and for Willie Brown, who had a wonderful party for Ed Lee on the night that he was elected at the Palace Hotel with lobster and filet mignon and an open bar that cost thousands and thousands of dollars. I believe it even had MC Hammer providing the entertainment, none of which was at all reported, all of which was gratis to everybody who walked in the door. But that's all free now. There's no worries that that's going to ever be a problem, because neither of them had a financial interest in front of the city that was going to be decided that we knew of. Same thing with Sean Parker and the money that he's been giving. There are a number of people who give a lot of money and who do goodwill with it. But it's not a behested payment, because it's not a check that's written at the request of an elected official. That's the connection here that we're talking about. If you look at who the behested payments are going to, it is not going to the kind of groups that Debbie Lerman is talking about. It's not happening. And what we're hearing now is if you sent a Valentine to someone, you're in trouble. This is how absurd these arguments have become. I would go one step further and say that limiting this to financial interest does not represent the reality of how city government works. If anybody understands city government, it's a number of members of this commission. You know that groups like the Committee on Jobs met regularly with the mayor with their list of people they wanted appointed to city commissions. Did they have a financial interest in those appointments? Not necessarily, but it was a regular meeting that took place. I know, because I was in the mayor's office, and I knew the meetings were taking place. I see no recognition in any of this language of how decisions are influenced and how it provides ultimately something coming back. Thank you.
Thank you.
Charlie Marsteller with FOE. To me, this is our greatest disappointment, the behested payments issue. And it's for the simple fact of something that your staff told me a year ago when this process started, and that is many of them who are attorneys understood that the laws in their home states were clear that behested payments in those jurisdictions and in many jurisdictions in the country are actually considered bribes and extortion, and they're illegal. And this is the only state that I know of that basically has seen a mission creep when the FPPC made a technical error now in retrospect and established behested payments as a mechanism that was lawful in California in the late 1970s, exactly about 20 years ago. I think it was 97. So I've been in conversation with other people, including some of the nonprofits, since that time, and I do think there's benefit, since we have institutionalized this practice, to look at thresholds ultimately as our remedy here, and that we need to tighten up on any loopholes that we're going to create when we set up thresholds, because that's the problem. When you don't have an outright ban, you end up with tools that very clever people can exploit, unfortunately. It's not our intent, not your intent. But the reality is there's a lot of smart people in this city, particularly. We're gifted that way. So I'm disappointed very much that we haven't really come to grips with behested payment to the extent that I think we have. And I'm hoping that at our next crack at some point in the future, we'll have another chance to look at this again. It may be after a series of major corruption scandals that will precipitate an outswell of the public on this issue. Thank you.
Thank you.
Commissioners, Ray Hartz, Director, San Francisco Open Government. Although he probably doesn't appreciate it, I want to associate myself with Mr. Marsteller's comments. We have a lot of smart people in this city, and we have a lot of smart politicians. And this idea of behested payments, it comes up. They're smart enough to know not to ask for the check, not to ask for the dollar amount, not to specify anything. They have some cutaway or cutout, whatever you want to call it, ask for them. I'd like to refer you back to this. I have previously referred to the activities of the Ethics Commission as, quote, rearranging deck chairs on the Titanic, end quote. Commission President Peter Keene, in a matter previously heard against our current mayor, is quoted as saying, Mr. Farrell, an elected supervisor of the city and county of San Francisco, has never had the political will or courage or integrity to come before this commission and look us in the face, end quote. He went on to blame the results on former Executive Director John St. Croix, saying, quote, he was clearly totally incompetent in allowing the statute of limitations to run out or marginally corrupt for going along with the idea of not pursuing Farrell, end quote. Throughout the history of this commission, when they can't enforce the laws already on the books, which you can't and don't, they find a scapegoat and claim they need to rewrite the law. What did Einstein say the best definition of insanity was? Repeatedly doing the same thing, expecting a different outcome. And here we are again, once more, rearranging the deck chairs. And all the people that we're talking about are the people who appoint you to this commission. I don't know really whether I have any expectation that you can fairly and in an unbiased fashion deal with any of these political issues for the simple fact that the people who appoint you are all politicians. They all run for office. They all ask for these payments. They all accept these payments. And if I remember correctly, part of Mr. Farrell's argument at the time was that, well, it was one of my staff members who asked for this payment. I knew nothing about it. It's like Sergeant Schultz in the old comedy. I know nothing. And as your commission president said, didn't have the integrity to come forward. Well, bottom line is, if I was having to testify against myself, I wouldn't come before you either.
Hello, Commissioners. Thank you for allowing me to speak. My name is Mark Bruno, and I didn't come here to speak today on this subject, but I have lived in North Beach for over 35 years, and I work with the homeless primarily through St. Peter and Paul Church, where I'm head of the St. Vincent de Paul Society, which, as you know, is a nonprofit. I just want to say that as a citizen who's run for office and has lived in the neighborhood and worked on many political campaigns, that outside of what the law might permit in terms of free speech and allowing people to give money as a form of free speech. We all know that that's been determined by the Supreme Court of the United States to be a form of free speech. That if you ask most people who voted for me and voted for other people in the neighborhood, if you ask the homeless, if you ask the people who live in North Beach, whether they be old or young, most people would consider what we're calling here a behested payment a sort of bribe. And so without expressing a kind of anger here about who owes who what, or Mark Farrell, or the history, I'm not familiar with all those histories, but I think the common person would consider it wrong that an elected official would be permitted to tell somebody, hey, can you help Mark Bruno's nonprofit? Can you please give them $20,000 or $20? That seems wrong because the public official has a tremendous amount of power, and the public official has a tremendous amount of sway over who gets jobs and what property values are worth. We all know the story, because we're all familiar with the history, of why George Washington himself, the first president, was eventually given a very high salary, because George Washington and other people at the time were investing in properties in Georgetown and in what is now the District of Columbia, because they had a very simple thing that didn't seem like money but was. And that simple thing was knowledge. They knew that there was a compromise being made between the North and the South about where the new capital, the federal capital, would be. It ended up being, of course, D.C., the District of Columbia. And it was those people who had that knowledge and were able to invest in that property who made money. And yet, on its face, at the beginning, those connections weren't really about money. They were just about decision-making. Where will the capital be? Those decisions were made based on a slavery South and a North that seemed much more industrial, New York and Philadelphia. And so that's where the compromise was. But in fact, those people who knew what was going on, as is the truth today, if they have that knowledge, they're able to make money from it. And so it feels wrong to allow people who are elected to ask for any money whatsoever from a citizen of San Francisco or outside the city to give to a nonprofit. It just seems on its face like a bad idea. Thank you for your time.
Thank you. Okay, so we're prepared to vote then in regard to the behested payments disclosure amendment.
One question.
Commissioner Kopp, yeah.
Where's the definition of interested party? Is that the California Government Code?
No, Commissioner, that is defined in the ordinance here, and I will direct you to it shortly.
Where is it?
So it is on page 76 to see the red line version. Page 76.
Oh, I don't have a red line. I've got
well, the color doesn't show up on your copies. I apologize, but.
Thank you.
But I will point out that parts of this concept were borrowed from state law,
borrowed from what?
From 84308, which is the section that says that the public officials cannot accept gifts of $250 or more from certain people.
Right.
And we borrowed.
All right, that's the definition of interested party.
Not exactly.
I mean financial then.
Part of it.
Well, it's not defined in what Commissioner Chu just gave me.
This is page 76.
All right, Mr. Chairman, you're satisfied that it's defined in other provisions of law?
Yes, Commissioner.
All right, thanks.
All right, so we're prepared to vote on the last amendment. All those in favor of the amendment, please say aye.
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 Any opposed? The amendment passes unanimously. We have all the amendments now. Is there a motion to proceed to approve the ballot measure itself as shown in the attachment 1 agenda as amended and place it on the June 5th, 2018 ballot? Do I hear such a motion?
Mr. Chairman, before we do that, could I make a request that could we go back to a section that we dealt with before where the vote, I think, was maybe been either 3-2 or 4-1. But at least, Commissioner.
Sure. Right.
And that's section 3.207, which is the additional conflicts of interest for city elected officers and members of boards and commission, which Commissioner Lee made a very impassioned argument against the first A1 of that, which is a prohibition in which one says, no city elected officer or member of a board or commission may use his or her public position or office to seek anything of value.
Yes, Commissioner Lee did speak to that.
And she indicated, during the recess, she indicated to me that the only part of that section that she would like to have the board the commission consider deleting is or for organizations which he or she is associated.
Okay.
And so
we have voted and we have adopted that amendment
Right.
without that. So I think what would be appropriate now, if we're going to make a change, would be a motion to reconsider.
right.
And
I don't think we voted because there was no action required, because under the staff recommendation, there was no amendment added, so there was no.
oh, that's correct.
right.
You're
So-
I
So
beg
I
your
think
pardon.
if
Yeah.
we could make a,
That was just, that was one of the ones where there was no
vote.
action recommended, so therefore no motion. So Commissioner Rennie, you would?
Well, I would be prepared to make a motion that we delete that language after the word family.
Delete what?
Delete the language, or an organization with which he is associated. That's the language on
He or
page
she is-
4 under the conflict of interest.
3207.
provision. Okay. So that's,
Yeah, I found that. on
delete the
page.
language, or an
Finance
organization
plan.
with which he is associated.
He or she is.
He or she is associated. So that would be the motion. Is there a second? Commissioner Lee? So Commissioner Lee, that was your main objection. Oh, okay, that's fine. That's-
Well, there must be a motion to reconsider.
We have one by Commissioner Rennie, who voted in the affirmative, there was no vote.
No vote.
There was no vote, so you don't need a motion to reconsider. You just, Andrew, yes.
I just want to suggest a friendly amendment.
Sure.
So if that's the intent to delete the last clause of 3207A1, I don't think we need, after conferring with Mr. Ford, I don't believe we need the definition of associated in the prior page and the prior section 3203.
for any organization.
Also, just as cleanup, we also probably want to insert or prior to his or her immediate family.
So what you're addressing is other language that
Just to implement.
parallel to make it,
Just to implement that idea.
okay.
Yes, Chair.
So the main point here is to eliminate the, in regard to conflict of interest, the definition of an organization to which someone is associated. That's the nub of it, as I understand. Is that correct, Commissioner Rennie? And we have a motion, and it's been seconded. Commissioners?
I have a
Yes,
question.
Commissioner
So I'd have a question for staff. So the scenarios that Commissioner Lee raised, that using a storefront, for purposes of a nonprofit, if an elected official is going to try and accommodate that request on behalf of a nonprofit, is that something that's contemplated as being prohibited under this section?
So that would depend on the definition of associated. And associated says that an organization in which, or it means an organization in which an individual or a member of his or her immediate family is a director, officer, or trustee, or owns or controls directly or indirectly, and severally or in the aggregate, at least 10% of the equity or of which an individual or a member of his or her family is an authorized representative or agent. So to break that down, you or your immediate family member has to be a director, officer, trustee, or you have to own or control 10%, or you have to be an authorized representative or agent in order for that organization to be associated with you.
Okay, so if it were a third party, completely separate, they would not be, even including this language, anything of value for an organization, it would not implicate the scenario that Commissioner Lee was contemplating. It would only be with associated nonprofits.
Right. If an official were just volunteering or doing something, participating in an activity or an event or something, but did not meet one of these specific categories of being associated, then no, it would not be implicated. The organization would not be associated with the official for purposes of 3.207A1.
If I could just add, I feel very strongly about this provision on a personal level because there was a situation that Judge Kopp alluded to earlier involving the Planning Commission and a spur board member. And this particular provision was really designed in order to prohibit that type of activity. It's designed to address officers of organizations, people who have a high stake, financial stake, and paid advocates, authorized agents. And I think that's an important thing to keep in mind.
Mr. Chairman, I want to associate myself with Ms. Bloom's remarks. I am unhappy about what has been done to this proposal, meaning the whole proposed so-called Anti-Corruption Act ordinance. I apprehend what will be done to it in the Board of Supervisors. One of these nonprofit representatives called this an improvement. It's not an improvement. It's a degradation of the original Proposition C and prior law in San Francisco. And even though this isn't the most important part of that degradation, it certainly is relevant and it is essential. And I shall vote against the proposed amendment for those reasons.
Commissioner Chu.
So, Commissioner Lee, does that alleviate your concerns at all? Because as I read Section 3.207A1, that the elected official or, of a board or a commission member would not be able to seek or obtain anything of value for a nonprofit that one of his or her own family members is a director of or an officer, so that would be a form of self-dealing to your own family members, or their family member is a trustee or owns at least 10% of the organization. So it wouldn't be any nonprofit; it would be those that would be run by or staffed by the elected or appointed family members.
Can you show me where specifically is the...
Can't hear you.
Can you show me the specific language of the association and organization? Because
Sure. So that's on page 69, again referring to item 3, attachment 3 is the red line version. So that's page 69, attachment 2 rather. So page 69 of agenda item 4. And it begins on line 5.
well, the last line, of which an individual or member of his or her immediate family is an authorized representative or agent. So if I were on a board of a nonprofit as a director of a nonprofit community service organization, that would cover me, right?
Yes, and even more explicitly, a director is listed in the second line. If you're a director, officer, or trustee, you would, yeah.
So my thing is, we have many commissioners who either serve on nonprofit boards or who are associated with nonprofit boards. So even under this definition, they're still covered by the conflict of interest rule, right?
I'm sorry, what was your question?
Even if you take out the language as that Commissioner,
No, but I'm just saying that by taking it out, then it would be okay. If the proposed amendment is to take out the associations, right?
Right, to remove the line "or for an organization with which he or she is associated."
So you're saying that it actually doesn't apply to nonprofits because the way associated means whatever. But I'm looking at the last line, Commissioner Chu. In addition to the offices that these officers or the board or the family members are associated with at least 10% of the equity. The one line that still troubles me is, or of which an individual or member of his or her immediate family is an authorized representative or agent, which I read as a member of a board of directors. So.
Right, and sorry, I didn't mean to communicate that this would wholly exclude nonprofits. I think it definitely could include them in certain instances, as you point out. If the official is a director of a nonprofit, then that nonprofit would be considered an organization with which that official is associated for purposes of this.
Right. So a nonprofit still would be included in the current conflict of interest.
They certainly could be. Right. Yeah.
And what would they be prohibited from doing?
Well, so if a nonprofit organization is considered an organization with which an official is associated, then under 3.207A1, that official would be prohibited from using his or her official position to direct benefits to that organization.
So is it anything of value?
Right.
Yeah, tell it. Explain what that means. Yeah. What it means is you can't vote or direct funds or benefits to the nonprofit on which you are sitting as a board of director, a paid advocate, or have a 10% financial interest in. So it's,
or your family member.
Yeah, using your official position. So this commission, if you're sitting on a board somewhere, couldn't, if you had power, vote to fund that board. You'd have to recuse yourself. You'd be prohibited from taking that vote. That doesn't strike me as that problematic.
and I think your analogy having to do with the spur and the planning commission situation that we saw was spot on in regard to this. That's what this is talking about.
But again, I'm just looking at the nonprofits who are not the Spurs of the world. I'm looking at the mom and pops struggling to serve meals or work with homeless youth. I'm talking about those nonprofits. So under,
But Commissioner Lee, if you would delete this exemption, if you make this exemption, you would allow people sitting on boards and commissions in the city who control grant money and who control contracts. You would be allowing them to direct money to their nonprofit. That's. Oh.
No, that's another conflict. This is asking anything of value. I'm still looking at the anything of value. And you're asking someone for access to the lobby so that they can put a water station when they're having a walkathon for a nonprofit. I'm looking at that type of anything of value that impacts a nonprofit organization. So I'm not looking at the Spurs, I'm not looking at the ballet board, I'm just looking at how it impacts community service organizations. Under this proposed rule, anything of value to them may mean only, let's have a water station right in front of your storefront because we don't have any money to pay.
Chair Keen.
Commissioner Chu.
So I think, Commissioner Lee, if I understand, if I can answer your question, is that if there's an elected or an appointed official who is wanting to make the request for a water station at, along the walkathon, and is making the request on behalf of a nonprofit for which their family member is either serving as a director or what was it? A director, officer, or trustee, or is an owner, or if they are an authorized representative or agent, then that would be prohibited. But if there's no relationship between the elected/appointed official, and correct me if I'm wrong, getting this wrong, staff, if there's no relationship between the elected and the appointed and that nonprofit, there shouldn't be a problem. It's only if it's a family member or there's some sort of relationship between the elected/appointed person and trying to direct a benefit, something of value to their affiliated nonprofit.
But the way the so-called association means, if I were a supervisor of my district, and if I am asked to be on the event committee, because we'll do that all the time, so I am associated with that organization. So that event would be included as the anything of value count, right?
I think it'd be somewhat rare for a sitting supervisor to be also serving on a board of directors, but perhaps that's wrong. I don't know. But that's the hypo, right? Like, it's a board member sitting on the board of an elected board member, also sitting on the board of a nonprofit, and the board member wants to put up a water station at the nonprofit's walkathon.
Or a co-chair of a fundraising event. Is that considered ownership? I mean,
Not use of office. I think in that case, it would be arguably not use of that person's public position. If they were just fundraising in the community, you'd have to look at whether or not that person was acting as the official. This would still allow people to act in a private capacity. You would have to look at, are they trying to use their office? And I could imagine, this is off the cuff, but I can imagine looking at facts like, did they use their city letterhead? Did they call people into their office? Did they try and use the office to obtain anything of value? Or were they just acting purely as a community member? Those are the kind of things that you'd be looking at under this scenario.
And with the water station, I think if a board sitting supervisor directed city funds in whatever form to a nonprofit on which he was sitting as a board member, I think that's okay to prohibit.
Oh, that I understand. I understand. But what I still don't understand is when it comes to the public official trying to support a community organization, that's where I don't see the separation. But I think we've done enough talking on
Chair Keen, if I may.
Yes,
So I think that it's, an elected or appointed using his or her official capacity and role as that elected or appointed official and trying to benefit this is what I think the ordinance is getting at, is trying to benefit a nonprofit in which that elected official family serves. So it's kind of I'm going to use my position to help my organization that my sister is on, or that my brother-in-law owns 50% of. That's what we're trying to get at here.
Chairman, what's before us now?
What's before us now, as I understand it, is a motion by Commissioner Lee to take out...
Commissioner Rennie.
Excuse me, Commissioner Rennie, to take out the language on Section D of Section 3.207, the language, no city official shall use his... excuse me, let me just find it again. Here. Go ahead, Commissioner Rennie, you go ahead.
It is to delete from Section 3.207A1 the language "or foreigner organization with which he or she is associated."
Or an organization with which he or she is associated. That's it. That's what we have before.
May I call the vote?
The question's been called. Is there a second? Yes, okay. So we will now vote on whether or not we will take.
Do we have to take public comment?
Little public comment.
Right. Public comment.
Commissioners, on this motion, related to this issue, Supervisor Peskin had suggested an amendment. It's in your packet, starting at page 87. It's not going to address all of Commissioner Lee's concerns or Commissioner Rennie's concerns for that matter, but I think it's something that this commission can probably get behind. That is in the definition of anything of value in section 3.203 to swap out the word favor and to substitute in private financial advantage. I think that would make this sentence read the definition of anything of value. Anything of value should mean any money or property, private financial advantage, service, payment, advance, forbearance, etc. I think when you look at how this is reflected in the regulation 3.207, particularly in subsection A2, which I know that Commissioner Lee did not raise, but what it means to indirectly receive a favor, I think, is what would be prohibited and yet kind of unintelligible. I think it's much clearer and ensures, and anything with clarity from our perspective ensures compliance and enforceability if you swap out favor and include instead private financial advantage. I think that this might get around the question about whether donation of a water cooler for an event is prohibited activity. And I don't know that that really smacks of the impropriety that this ordinance is trying to get at. So private financial advantage instead of favor would be our suggestion. Thank you.
I'm sorry,
Commissioner
Mr.
Chu.
Thank you, Chair King. Could you direct me to the page on which this language appears?
Yeah, my pages got all mixed around, but in the redlined version, I'm looking at section 3.203, the definition of anything of value in the redlined version, which shows all the edits on page 25, line 1.
Okay, and then what is the language that you are referencing from Supervisor Peskin's amendment?
Right, and that amendment is in your packet at page, gosh, I want to say it's between 87 and 92. Again, I dropped my packet and it got a little mixed up, but the language would be to delete favor and to insert private financial advantage. I think that more closely approximates the ill that this body is trying to get at. I don't think it counts as watering it down one iota. I think it's a clarity amendment to ensure compliance, to take out favor and substitute private financial advantage.
Commissioner Chu, did you find the page?
No, not yet.
I can't find the page anywhere.
Okay, if staff can help at all, just my packet is completely mixed around.
I see the word property, favor, service.
What page is that on?
Okay.
That's on page 90.
That's the definition.
It's on page 21, line 1 of staff agenda item 4 packet. Page 21, page 29 rather. I'm looking, okay, so page 29 of the ordinance, page 29 of your packet, agenda item 4 packet, page 29. My proposed definition is in the back. It is, well, I was told that it was before you in the 10 documents that I brought today and was told not to distribute because you already had it in your packet. It is.
Is this in the Board of Supervisor packet?
This is, it's right here. There are 10 copies of it over there. I was told that it was in your packets. It ought to be. No.
Oh, this is packet.
I don't see it, Mr. Chairman, in mine.
When did you make that?
This change was submitted to ethics staff before your packet went out for inclusion to be properly noticed. It was made at the Budget and Finance Committee yesterday. I brought 10 copies.
Yeah.
Right, and I believe it was sent out in your packet.
What was in our packet is something like this, as proposed amendments. Mr. Hebner, is this what you're referring to?
Yeah.
I do have one additional copy here that reflects that amendment.
This what you're referring to?
That packet, correct, and
Right,
it's
where in that package does it talk favor?
on the bottom right. It says page 28, and it's the first line of that page 28. Deletes favor and inserts private financial advantage.
Yeah, but the problem is, I don't have a page 28. I have a page 24 and then a page 30.
Yeah, I've got it, all right. What's your point? I know. What's your point?
Commissioner Kopp, through the chair, my point is that this adds clarity and ensures compliance and enforceability of a measure. The definition of anything of value includes the word favor. I think relative to the regulation that it's prohibited to indirectly receive a favor, I challenge anybody on this commission to illustrate what it means to indirectly receive a favor. I think that it's much clearer to write private financial advantage. That was Supervisor Peskin's amendment that he made yesterday at the Budget and Finance Committee.
So it wouldn't apply to a nonprofit?
No, it absolutely would, Commissioner. Excuse me for interrupting, but it would absolutely apply to a nonprofit. This is in no way exempts a nonprofit.
Who gets a private financial advantage out of a nonprofit?
No,
I'm sorry, I don't think that that's the nature of the regulation.
Chair Keen, I believe that the private financial advantage would be included in the definition of anything of value, such that the elected or the appointed could not use his or her official position to deliver or obtain private financial advantage for the benefit of an associated nonprofit.
Chairman, are we in public comment?
I wouldn't interpret.
Because the question.
We are in public
By the
comment.
motion.
We've now heard Mr. Hepner. Yes, sir. Why don't you go ahead and speak? And then we will vote on the motion of Commissioner Rennie.
Thank you, Chair Keen. So I'd like to wholeheartedly echo what Mr. Hepner just said, and to illustrate an example that shows how you can receive a private financial benefit from a nonprofit. Current law already would make the following scenario a conflict of interest. If I were to serve on a city commission and my wife, let's say, were a volunteer board member, sorry, not a volunteer board member, but rather a paid executive director, let's say, for a nonprofit, and I directed city funds to her employer, that financial interest, her receiving a financial gain through her employer because of my official action, would be imputed to me as the public official, and I would have a conflict of interest, in this case, under Government Code 87100 at SEEK, under state law. So that sort of arrangement is already illegal, whether you're talking about a nonprofit employer or a for-profit employer. I think the concern from the perspective of...
Excuse me, before you leave, Mr. Chair.
Yes, Commissioner.
What code is that in, the Government Code?
Yes.
What
the California
section?
87100, the conflict of interest section.
Thanks.
And there's a similar
Thank you.
provision under 1090. But so the concern of ours for nonprofit volunteers and unpaid board members is that in the scenario I just gave, if I'm a city official, my wife, again, let's say, is an unpaid board member, if I were to use my official position once again to make some sort of favor to her organization, which is not very clearly defined, I would now, as the public official, have a conflict of interest, even though there's no financial gain imputed to her since she's unpaid. So I think that's our concern there. And I think, again, I think reasonable minds can disagree about whether I should, as a city official, be able to direct funds to a nonprofit that is under the direction or control of my wife. But our concern is if there is no payment requirement, then we would respectfully ask that anything of value be then very clearly defined. And I think, Supervisor Peskin's amendment would help do that, something like that, so that public officials would be put on notice so they can better comply in good faith. Thanks very much.
Thank you.
Commissioners, Larry Bush from Friends of Ethics. It seems to me like we're traveling the world in a submarine, looking out of the tiniest little hole. The issue, when you talk about an organization, includes for-profit entities. So we do have commissioners whose spouses are vice presidents of major entities in this city, and they do have contracts with the government. If you change this to meet Commissioner Lee's concern and said that you were providing an exemption for a nonprofit that provides services, human services of housing, health, and so forth, to indigent people who are not being reimbursed for it, then you would have something similar to what exists in Los Angeles in their lobby law, and it's what we have said before. Then if you have someone who's on a board and they are providing a benefit to a nonprofit that's a 501c3, you're not running into the situation of Spur because they don't provide services. They are just an advocacy organization. But you are helping people who are doing a mom and pop food drive in the community. So I think if you have an exemption that says that it applies for 501c3s that are providing services at no cost, that are human services, that you would be well within the grounds. Thank you.
Debbie Lerman, Human Services Network. I just want to briefly concur with Torrance remarks. I also agree that that removing organization from there would not affect true conflicts of interests, which are already prohibited under the law. But I also just have it's a gut reaction, but just the use of the word organization in that sentence strikes me as targeting nonprofits. And as Mr. Bush just pointed out, it, I believe, applies to for-profit associations too, but that is not clear to me on reading it. So I would urge you to, at minimum, change the word from organization to corporation or something similar, or clarify for-profit and nonprofit.
Thank you.
Again, my name is Mark Bruno, and through the chair, I would like to comment on Commissioner Lee's criticism or description of a situation where a nonprofit might be negatively affected because a supervisor or a commissioner, an unelected public official, might want to do some favors for a small group. I was co-chair with Mohammed Nuru many years ago when former Mayor Lee was the advisor to what was then called the Graffiti Advisory Board, and we were given the task of finding enough people to be on that very non-sexy board called the Graffiti Advisory Board. Well, in those days, and I think the same challenge is faced by all commissioners and boards now, it's a virtue in government to reach out to other people. There's no reason that the president of the Board of Supervisors also has to be associated through her family members, for instance, with a small nonprofit, or that a member of this commission should be the chair or director or friends of a board member of another nonprofit. So the law should exactly do what it can do best, separate all those interests so that we are required as citizens and as commissioners and as elected officials to reach out to new people. What's wrong with having nonprofit directors become commissioners or new faces become Board of Supervisors members? Isn't that one of the purposes of popular government and of democracy? So again, one of the virtues of the law being left alone and not removing that section on excluding organizations as part of as the public interest, the conflict of interest law rather, not removing that is to force all of us in the city to go out and meet new people and get them on these boards so that there is no obvious conflict. Instead of being a little government where we all see the same people and do favors for each other all the time and then become suspect because it seems that we're doing favors for our friends, we would not be having only friends in city government. Why not expand the nature of government family, the so-called San Francisco family, and include people who aren't normally included? I think that's one of the virtues of this law as it was written. Thank you so much.
Thank you.
Commissioners, Ray Hartz, Director, San Francisco Open Government, and I would like to associate myself with the previous speaker. I do believe that the city government, one of its major problems is its incestuous nature. There are too many people who appoint a person who appoints another person to another board, and you don't know who is colluding or who is simply supporting or who is doing what with whom about anything anymore. And if we expanded the mandate and said we need to get people who haven't been on boards and commissions over and over and over again for the last 20 years. I always hear that as this wonderful talking point. Oh, well, they've served on boards and commissions for 30 years. Well, maybe it's time to get somebody new. Maybe it's time to get somebody who isn't so set in their ways and so blinded by their previous experience that they are willing to consider new things, new people. The trouble with a lot of the boards and commissions is the appointment process is so secretive and done in such ways that the public doesn't know exactly why an individual got appointed to a board or commission, and therefore the concern that comes up to members of the public is, what is really driving this person's action? What is their agenda? Is it clearly what they say out in public, or is there some sort of hidden motivation going on that is driving not just their vote, but their support or non-support for certain items? Again, I agree with the person. I think that a person there ought to be a law in this city that basically says once you've served 5 terms on any board or commission, that's it. And we need to get new people in who have new experience, who can bring new viewpoints, new things, rather than simply having the same old people appointed and reappointed again, and then simply move when they're termed out to another board or commission where we see the same person and have to ask the same questions. So again, I agree with the previous speaker. We need to get more people involved in government. And one of the reasons I say that is because, as far as I'm concerned, the First Amendment exists so that people like me can come here and say the things I say to people like you. You don't like what I have to say, but you never refute it. You never give any factual undermining of it. You simply make some vacuous comment like, your mother wears army boots.
The question has been called and it's been seconded. We will now vote on Commissioner Rennie's motion to delete the language that's been indicated. All those in favor of deleting the language, please say aye.
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 All those opposed?
No.
No. The motion fails 3-2. Okay, now at this point, I'd entertain a motion to approve the ballot measure in its entirety as we've put it forth with those amendments as shown in Attachment A, and place it on the June 5th, 2015 ballot. Do I hear a motion? It's been moved by Commissioner Rennie.
Yeah, if I could just
go ahead.
2 very slight friendly amendments. I know it's been a long meeting.
Yeah.
So it's all the changes reflected in attachment 1 and for the June 5th, 2018 election.
Yes.
Thank you.
What did I say? Where was I?
You referred to attachment A. And
All right. Oh, I'm surprised I didn't say 1970 or something like that. That's where my mind still is. Okay, so is there a motion?
Mr. Chair, I have a question. Earlier in the day, I think someone mentioned that there was an offer to have a joint meeting between the Board of Supervisors.
Yes, we'll take that up. I think that's out of order at this point because we have the question has been called for a vote, and we've had public comment, so we now have to vote. We have to vote. All right.
Yeah.
So let's vote.
Are you going to take public comment on the motion?
We'll take public comment on the motion. Yes.
Thank you.
Has it been seconded?
I don't know. Has it been seconded?
Oh, yeah.
There has been a motion. Is there no second to put this on the ballot? Who moved it?
Okay.
I did.
Commissioner Rennie moved it.
Oh,
Do we have a second to put it on the ballot? I'll second it.
Yeah.
Oh.
Commissioners, on the motion before you to put this on the June 5th, 2018 ballot, I will reiterate some of the comments that I made at the outset of this hearing on behalf of Supervisor Peskin. I think generally on behalf of the Board of Supervisors, though I hesitate to speak for other supervisors. I think that there are a couple of paths forward, and I am not confident that the June 5th, 2018 ballot is the best path forward. The primary reason I say that is if you were to forward this to the Board of Supervisors, yes, you run the risk of the abundant skepticism that a body charged with regulating itself cannot do so appropriately. But I think the countervailing pressure and the countervailing need of this body and of the Board of Supervisors is to get something on the books, passed at the Board of Supervisors, and implemented before the November election. Much of this can be implemented before the June election. Everything relative to a prohibition can be implemented immediately. And I see staff shaking their heads no, but respectfully, I think that there are prohibitions in this ordinance that can become effective immediately. Everything relative to creating a form and filing online, I understand, is going to take some lead time to allow staff and IT and NetFile to create those forms and to create that back-end infrastructure. But what we need to do today, the imperative before this body and the imperative before the Board of Supervisors, is to pass these reforms and make them effective before the most consequential election in recent San Francisco history. That is the emergency before you. That is the emergency before the Board of Supervisors, and it is the imperative that I beg you to hear today. That is what I was charged with coming here to deliver, was that. Everything about the amendments is noise compared to the imperative to try to get something effective in advance of one of the more consequential elections in this city's history. So I encourage you to vote against putting this on the June 5th ballot as is, which wouldn't render this operative until January 1, 2019, and to instead let the Board of Supervisors, perhaps in a joint session with this body, to pass something in the dual capacity of these legislative bodies together, pass something immediately that can become operative and effective 30 days from that date. That is before the June election. That is certainly far before the November election, when we have a bevy of very, very, very hotly contested supervisorial races where the dark money is going to be flowing like the salmon of San Juan Capistrano. So that is my plea for you today. I'm happy to answer any questions. What we have not addressed at all is the major donors disclosure piece.
Commissioner Rennie.
May I ask Mr. Hebner a question? Are you guaranteeing that the Board of Supervisors is going to pass this?
Commissioner Rennie, through the chair, I cannot speak for the other supervisors. I can speak to the conversation that took place at Budget and Finance Committee yesterday and a genuine willingness on behalf of the Board of Supervisors to move this forward. Now, an alternative that you could use is to keep this on the November ballot with the same operative date of January 1, 2019. Keep that leverage over the Board of Supervisors to act meaningfully. You don't gain or lose anything because this isn't going to be operative, even if it's passed on the June ballot, until next year anyway. Put it on the November ballot, keep that pressure over the Board of Supervisors to do the right thing, and let us prove to you that we can do the right thing and get this operative and effective long before the November election really gets up and going, if not also before the June election.
Commissioner Kopp.
I'll repeat. Mr. Peskin told me 3 weeks ago that we should delay this to the November 2018 election. Today, Mr. Hepner, you represented that it should be on the June 5, 2018 election. I am confused, but I will consider your remarks accordingly with guidance from my fellow commissioners and our staff. Doesn't require any comment.
Commissioner Chu.
Mr. Hebner, could you please clarify for my benefit what exactly you're proposing with regard to the ordinance as amended that we've just discussed today from a procedural standpoint, what you are proposing?
My proposal today, and it's enunciated in detail in the letter in your packet from Supervisor Peskin that I 150% guarantee was properly noticed and agendized before Tuesday. I am proposing that you not consider this for the June 2018 ballot. Do not. And that, to Commissioner Kopp's concern through the chair, this is not, I have not changed the position there. Supervisor Peskin has been adamant throughout that this should not go to the June 2018 ballot. Rather, if you kick it out to the November 2018 ballot, you maintain the leverage to get the Board of Supervisors to do the right thing and potentially even do it better by rendering it operative long before it otherwise would be. The other proposal that I had before you was to amend in the major donor disclosures piece. I do not want to undervalue how critical that piece is. And the only way that that piece is going to become effective before the June election, where we're anticipating millions of dollars in dark money that we will not see, the only way to get that piece effective before the June election is for you to adopt it into the file today and forward it to the Board of Supervisors.
And then may I ask
Sure.
a clarifying question? So that from a process standpoint, then, the joint Board of Supervisors and Ethics Commission would consider this combined legislation, so the anti-corruption ordinance along with the major donor ordinance that Supervisor Peskin has proposed?
That is correct. The major donor disclosures piece would become part of the broader anti-corruption and accountability ordinance, and it would theoretically be passed all as one by this commission and the Board of Supervisors.
I see. And that your read of the committee and the board is such that there would be enthusiasm, this would be taken up, and that this could conceivably be passed before the June election? That's
correct. Supervisor Peskin has issued statements to the press along those lines, public statements in many fora, trying to drum up enthusiasm for this idea. And I think that there's a general consensus among the board, among the mayor, who has also issued public statements to this effect, that we can pass this major donor disclosures piece long before the June election is over.
So the major donor disclosure piece, what about the anti-corruption ordinance?
And just a clarification about the charter authority of this commission, the Board of Supervisors cannot on its own sever out any piece of this and pass it independently. So it would be part of the broader anti-corruption and accountability ordinance that you forward today.
Okay, thank you.
Thank you.
All right. Mr. Bush.
Larry Bush for Friends of Ethics. I've been working on an anti-corruption measure since I served on the civil grand jury in 2013, 2014, and have met with national organizations like the Campaign Legal Center. Certainly have gone to the interested person meetings that have been held here at the commission and have been a strong advocate for a robust version of this measure. I think that it would be prudent and good policy as well as good politics to wait and not put this on the June ballot despite all of that effort. I think that if I understood the calendar correctly from the Department of Elections, you have until March 5th to put something on the ballot. If you have until March 5th and you're having a joint meeting with the Board of Supervisors and the Ethics Commission before that date, then at that vote, you could go ahead and decide to put it on the June ballot. It wouldn't be too late in that case. But even if you didn't have, even if I have my calendar incorrect, the board could take it and move it forward. And I do believe that Mr. Hepner and Supervisor Peskin are accurate in terms of what they think the lay of the land is at the board. I don't know that they have 8 votes, which is I think what you need in some of these, but I think that they certainly have 6. And I think that they have the mayor's support, and I think that would bring the other 2 along. There is such a strong impetus at the board these days on ethics in general. It doesn't matter which part of the ideology on it. You've got Malia Cohen talking about more disclosures at the retirement board. And you have Jane Kim doing on campaign finance. And those are 2 different parts of the spectrum on City Hall. The press conference on behalf of the major donors thing that Peskin just did had the support of Jeff Sheehy. It is a broad group. George Gasconi was there in support of it. So I think that there is a good reason to have confidence that if the March 5th date is correct, but even if it's not, that you wait and do this after you've had an opportunity. And it also looks better to the public that you've taken an additional step after the coverage that was in the paper. Thank you.
Hi, Charles Marsteller for the record with FOE. I've been counting votes at the board. There are 4 co-sponsors on the Peskin bill as it stands, a likely 5th in the wings. She's reading the bill now. There have been substantial conversations with the mayor. So it certainly looks like, surprisingly, that there's a broad support among both spectrums of the board for the Peskin measure, and in a way that I have not seen in 20 years. There seems to be excitement and enthusiasm, and I think it's a simple fact that the supervisors have gotten tired of being shaken down by the donor base, mostly the IECs, or what we call non-candidate committees, non-candidate controlled committees. And I think this is indicative that we are in a historic moment of change. I was speaking with our former counsel, who's now counsel to the board, Mr. Givner, and he and I both talked about what we see as a turning point. And we've seen it here at Ethics, so I think much of it has to do with you. And there's a certain spirit now at the board to try to turn some of this campaign finance stuff around with some innovations that, frankly, a majority of the board, if not most of the board, would be prepared to fight in court to sustain. I don't think they're going to be deterred by any argument that this matter is, the Peskin measure is unconstitutional. I think they think that there's aspects of it that they could successfully argue before a court for the city and county. So I, too, have concluded that you do have time, could lay this over today, immediately meet with the board, and try to come to some consensus on how to proceed. And hopefully we can have all of this enacted, and this ACA or ACO, whatever we're calling it, is a better, much better bill for the process. Because right now, to my way of thinking, it's not a strong bill. It's been watered down. And I do think adding it and incorporating other ideas like Mr. Peskin's measure at the board would be very helpful in making this a strong bill. Thank you.
Debbie Lerman from the Human Services Network, and I find myself in agreement with Friends of Ethics that we should not place this on the ballot today. There are a few process comments I'd like to make. First of all, there are three versions, I guess, of the legislation floating around. The board has 2 duplicated files, your original version that you sent over last year, their amended version, the new one coming out of here today. Supervisor Tang introduced several amendments that are not yet out as of this morning. So the board committee version hasn't even been publicly released yet, but we believe there were some good ideas in here that this body may be receptive to. And given the desire to get this right, it would be best to allow a full analysis and a comparison of all the versions. Secondly, I wholeheartedly want to concur with Supervisor Peskin's office that there is a tremendous benefit to working collaboratively because it could be adopted at an earlier date. We've said all along, and I know this has been frustrating to many of you, but we have always agreed with 90% of what is in this measure. This is full of good government ideas, and we would love to see these things in place for the upcoming June and November elections. Also, this is a massive piece of legislation. It's 36 pages long, covers many different aspects of campaign law and conflict of interest, and it has a huge potential for unintended consequences as to how some of these things will work in the real world. Once it goes on the ballot, it can no longer be tweaked to fix any flaws, no matter how small or how large, without going back to the voters. So I think it would be wise to try to pass it legislatively and see how it works in practice through these upcoming elections rather than taking it straight to the ballot. And the last thing I want to say is there's been a high bar set for these kinds of amendments. The law says 4/5 of this commission and 8/11 of the board. And yes, you have the power to bypass that and go straight to the ballot. But there is a reason why it's such a high bar. These laws are complicated, and they affect public officials who are responsible for understanding these laws, but they also affect members of the public who do things like donate or volunteer for things. They affect our First Amendment rights. And because of that, and because we're potentially implicating and even imposing penalties on general members of the public, it is a most responsible thing to try to work together and, again, go with the board, which has a much more public process because everybody watches the board hearings, and a lot more people might weigh in who understand these things and how it might affect them, and we would be more likely to discover any flaws that people haven't even thought about. So I think it's the best process to all work together, save the ballot for the occasion where public officials really are failing to act in the face of obvious corruption. And so thank you for considering that.
Commissioners Ray Hartz, Director, San Francisco Open Government. What we really need in this city, and it's an oxymoron for most people, is an honest politician or a whole bunch of them. We need someone in the mayor's office who simply says, rather than writing laws to catch people after they break the law or commit an ethical violation, we need to get people who are ethically unchallenged in office. People who are just willing to come out and be honest and open rather than having to be forced or tricked into it. What we need is somebody in the mayor's office who will sit down and simply say, I am going to tell you every single dollar I got and every single person that it came from. I'm going to tell you why they gave it to me, when they gave it to me, how they gave it to me. Cash, check, money order, whatever it happens to be. You're always trying to close the barn door after the horses have fled. Basically trying to catch somebody who is taking contributions under the table, over the table, around the bend, or however they accept them. What we need instead is some leaders in this city. Someone elected to the president of the Board of Supervisors who gets all of the other supervisors to agree. We're not going to accept any money that we're not willing to publicly acknowledge. We are not going to accept any contributions from any person who we are not publicly willing to acknowledge gave that contribution. And if the public thinks there's a conflict of interest, then they have the information they need to make that determination. As it is right now, we don't know who's giving what to whom, who's accepting what from whom, why they're accepting it, what they're doing with it. And when Mr. Hepner starts talking about Mr. Peskin's concern about dark money, the dark money's all there. And it'll be, you know, as much as the staff here is sitting and spending all this time and energy trying to write a law that will keep this from happening, they have 5 attorneys for every one of yours and 5 staff members for every one of yours finding a way to get around the law you write. And I'm sure what they do is they follow this and say, the minute that you approve it, oh, okay, here's how we'll get around that, here's how we'll get around that, and here's how we'll get around that. So by the time it goes to the ballot, the citizens are being sold a bill of goods. Basically, we're saying to them, oh, we're going to have all these things that we're going to make this city ethically less challenged. When the reality is, no, until we get people who just aren't ethically challenged into office, working for the interests of the city and not for their own interests, we'll never get anywhere.
Again, it's Mark Bruno. Thank you for allowing me to speak. I'll be very quick, Chairman Keene. As Mr. Lewis has so rightly said many times here today, honest minds can disagree about these complex issues. I would like to see what Supervisor London Breed and Supervisor Jane Kim, both of whom are running for mayor, have to say about this proposal. Why not? I mean, it would seem to me it would be a sort of a good public policy purpose if, in allowing it to go to the Board of Supervisors, whether it passes or not, the public has a chance to see 2 of our major candidates discuss these complex issues. So for that reason alone, unless it undermines the whole purpose of this, and it seems to Mr. Hepner, who I trust implicitly, that it does not undermine this proposal, why not let it go before the board and hear our supervisors discuss these issues? I would certainly appreciate that as a member of the public. Thank you.
I would just like to make a couple of comments. We've been working on this measure now for 2.5 years in terms of attempting to restore Prop J, which was put on the ballot, and which was passed by the citizens of San Francisco and had a lot of very strong anti-corruption measures in it, and was sub rosa, under the table, over the years by various boards of supervisors, completely undermined and repealed part after part after part. We started, Commissioner Rennie gave the mandate, it's more than 2.5 years ago, to go ahead and restore Prop J. We've been doing that. We originally restored as much, literally, of Prop J as had been there to begin with. We then had innumerable meetings like this one in which we were criticized, we were asked for concessions, particularly by the nonprofit people, in terms of their saying, give us these concessions, give us these concessions, give us these concessions. And we gave them the concessions again and again and again and again and again, and they were never satisfied, and they're still not satisfied. We now, in terms of attempting to put together something close to an anti-corruption measure, have, I agree, put forth a much weakened measure than what we originally wrote. But it is an anti-corruption measure. It's more than what we have now. And this does not preclude Supervisor Peskin or the supervisors from going ahead and putting forth their own ordinances if they think we haven't done enough. It doesn't preclude this body from adding additional things in the future in terms of recommendations for ordinances. But what it does do is attempt to give back to the people of San Francisco the democratic process that they originally put forth in Proposition J. They voted for this. It was stolen from them by the city officials. We're trying to restore it. We're not able to put together anywhere near what we'd like to, but we've put together something. And we have a bevy of opposition, not just from the nonprofits, who, in my opinion, have lost any credibility in terms of what they have done in regard to arguing for this stuff. I think much of their arguments come. It makes them look like they are in the pocket of many of the big characters whom we're trying to regulate. At the same time, and I'm looking at you, Mr. Bush, it's criticized, and we're by Friends of Ethics that no, it's you just haven't put together exactly what we wanted. It's not tough enough. Toss it away. Don't do it. That's very short-sighted on the part of the Friends of Ethics and people who really want to have some sort of measure with teeth here. We've put something forth for the voters to consider. This is a democracy. The people are going to look at it and they're going to make their own determination and vote on it. In terms of all of the criticisms, like the criticisms we get from Mr. Kars about there's just a small bunch of people doing various things, this is the ultimate democratic measure that everyone is going to look at and either vote up or down. So we ought to go with it. And if we don't go with it, then I don't see much reason for the continuation of this commission. I really don't.
Chair Keen?
Yes.
I actually have a couple questions, and I may direct them to staff and the Deputy City Attorney, just from a process standpoint, to understand procedurally what is before us. So I think we have reviewed the amendments to the ordinance and that we had been prepared to vote to put it on the ballot. But as Mr. Hepner has spoken earlier and has been alluded to throughout our conversation there this evening, there's the opportunity to engage in further discussion with the board through a joint session, and I asked Deputy City Attorney Shen if this is, can this be done? I assume it can be done, for the Board of Supervisors and the Commission to meet to discuss this this ordinance. So it would be the anti-corruption ordinance as well as the major donor legislation that Supervisor Peskin has proposed.
From a process standpoint, yes, hypothetically, there could be a joint session. Obviously, there will be a few challenges. From what Mr. Hepner related earlier in the meeting, I don't believe that the Board of Supervisors, through its president, has necessarily indicated its willingness to participate. We'd also have to coordinate schedules of the commission here. We may need to land on a date in which the full Board of Supervisors is already meeting, and we would need to manage to get all that done before March 2nd. Which is the ballot measure deadline.
I see.
I assume that would still be a constraint on the Ethics Commission's willingness to participate in that process, which is, obviously just 2 weeks from today, and there's a 3-day weekend this weekend as well. So it could be very challenging to fit all that in.
And we're putting our faith in a legislative body, all due respect to Mr. Hepner and to Supervisor Peskin, that is now hyper-political during the course of jockeying for mayor, several people being on it, others jockeying for power, one group trying to screw the other group, and we're saying, well, we're gonna drop what we've done here, and we're going to have faith in the particular political process of the Board of Supervisors of San Francisco as it currently exists. Well, again, with all due respects to several members of that board, not to all of them, that is total foolishness, in my opinion.
Mr. Shen, let me ask you.
Commissioner Rennie.
Process question. The board has the draft ordinance that we sent to them on a vote of 4-1. They have that before them. If we did not, and what we have before us now is some amendments to what we sent. If we were to not vote 4-1 at least, to approve our action tonight and send it, put it on the ballot, if that were not approved, what's before is our earlier proposed a ordinance still active, and this joint commission could make all the changes that we spent 4 hours on tonight?
Wait, so I'm not sure if I understand the question. So you're saying if the commission submits this measure to the ballot tonight?
No, we don't, we vote against it.
Okay.
In other words, say it's only get 3 to 2 votes.
Okay.
So that therefore, we don't have the 4 votes. Is the situation then that we've got the present ordinance before the Board of Supervisors, which is then subject to the Board of Supervisors doing what they want, or are we then putting it on the November ballot?
Right. So the Ethics Commission's amendments adopted tonight would not be automatically incorporated
Right.
with what's before the board.
Right.
A member of the board would need to amend one of the existing files and incorporate the staff changes and the additional changes submitted by the commission tonight.
Well, which causes me to say, should we then have 2 motions? One is whether or not to accept the amendments on our draft ordinance. And once we approve that, then a motion to put it on the ballot.
So to bifurcate?
We've already accepted.
Yeah, you've
the
already accepted the
amendment, So that's not necessary.
Did we vote?
We voted on the 4.
Yeah, we already accepted all the
They're there.
amendments.
We have a package.
Right. This is a pure question of whether to submit it to the ballot for the June 5th election.
Yeah.
All right, so the only question is
Procedural.
the question of should it go on the ballot?
That's correct.
That's correct. That's our remaining question. Commissioner Chu.
So my additional procedural question, so assuming there would be this joint meeting that could be scheduled in time before the March 2 deadline, it would be finalized, and if the board approves it, then, and the commission is satisfied with the ordinance, then it would then, from the date of that approval, 8 out of the 11 votes would become law within 30 days.
Well, I mean, there would have to be some additional time for the mayor's office to review it. I mean, but we still have the same operative date, I would assume, that's at the current draft. I've heard from some members of the board, maybe they want to move up with the operative date. So I think that would still be an open question for this theoretical joint meeting of the Board of Supervisors and the Ethics Commission.
Right, but it's yes, so assuming whatever dates we would agree to collectively, it would then become effective. But the law itself, whether or not we can implement a filing and disclosure regime within 30 days or 60 days, 180 days, that will be a practical question. But, with respect to some of the other provisions, it would be an effective law 30 days from the date of signature by the mayor. Is that? I just want to understand what the process is.
Yeah, essentially. I mean, but if we do want portions of the law to go effective sooner rather than later, if we want to choose ones that we, for various reasons, thinks that we can implement and should implement on an earlier basis, then we should probably specify that in whatever section we specify the operative dates for.
So, and then
I mean, that would be a policy option for the theoretical joint meeting.
Okay, and then from a process standpoint, if we put our measure on the ballot tonight as is, the effective date would be January 1st, 2019.
The operative date would be,
Yeah,
yes.
operative date. Okay, and then
It would be effective as soon as the voters voted on it and the board approved the results of the June 5th election.
Then my second question is, so if we have this joint meeting with the Board of Supervisors and it is a product that we are not happy with from an Ethics Commission standpoint, but is approved by the board, it would then we would still have the 4/5 vote to approve or amend, like to change the ordinance.
You mean at the meeting, at this theoretical joint
Yeah.
meeting, would you have to approve the amendments by 4/5? Yes.
Yes.
That is correct.
Okay.
It would be the same vote threshold, right? It would be a 4/5 vote there as well.
Okay. And then so if it were not hashed out to our satisfaction, then presumably assuming all the logistics align, and it's before March 2nd, then we could still place it on the June ballot.
Right. I mean, I assume if what you're asking is the joint meeting, there is no meeting of the minds between the Board of Supervisors and the Ethics Commission, that this Ethics Commission would need to reconvene somehow and then vote to submit it to the ballot of its own accord. And that would also require 4 votes.
Right. Okay. Thank you. And that the as from the recommendation of staff is to place it on the ballot for the June election as opposed to the November election. And is there a view as to the downsides to placing it on the November election?
Thank you for the question, Vice Chair Chu. I think, as by my count, as I look through the provisions that are in the ordinance before you, that you adopted, there are about 11 provisions that would require systems, processes, forms, reporting schemes to be implemented. There were 2 that would be prohibitions. So I think it is very important to underscore that in order to make, in our view, the operative, these provisions operative in practice, so that it's not simply a window dressing effort, it needs lead time. They cannot be turned around on a dime. Our view is putting it on a June ballot would allow the commission to implement it by the January 1st, 2019 deadline. If the commission were to, say, have a joint meeting or perhaps put it on a November ballot, that's, of course, the prerogative of the commission. Our recommendation in that case would be we have to be very clear that the operative date then moves out correspondingly. Despite how much money might be provided to us, as Mr. Hepner indicated, it's not about having the money, it's about our ability to spend it quickly enough to make this happen. So I think we just really, from a staff perspective, want to frame for context so that there is not disappointment by voters, the public, or the commission or the board, what it truly takes in practice to, in the city, operationalize these kinds of provisions with all due haste. But that's our recommendation, and that's why we were focused on providing this set of provisions to be effected, operative January 1, 2019, because that's the time it's going to take to get it done.
Okay.
I'm sorry,
yes.
I have one last question. Deputy Attorney Chen, is it possible for us to vote on a motion that would contain alternatives so that, for example, hypothetically, if we were to say, if a joint meeting with the Board of Supervisors does not occur before date certain, March 1st, for example, I know that doesn't leave us a lot of time, then we would have voted to put this ballot measure, put the ordinance on the ballot.
I would really not recommend creating alternatives, because as much as we can try to craft a very complicated motion with a few things dependent on certain conditions, I would really hate to have this commission, my office, be in a position of making a call about whether those conditions were satisfied. I would strongly recommend against that.
Commissioner Rennie.
Chairman, I just want to point out for the board's knowledge that I will not be here after the 23rd of February, so that even if you have a joint meeting, if it doesn't occur sometime before the morning of the 23rd, I will not be here, and I will not be here for the March meeting.
And we need 4 votes. Okay. All right, the question's been called. Unless the commissioners have any further comment, the question has been called, the motion has been made, and it has been seconded. All those in favor of putting on the ballot say aye.
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 I'm going to say aye.
Thank you.
Only because of the perspicacity of our chairman.
Thank you.
That's Mrs. Kopp.
Thank you. She's calling you to tell you to vote aye.
In a moment.
Okay.
I won't repeat my comments about the diluted version of what began, but I do it from respect for chairman and other commissioners and the process which the commission has endured and interested parties have endured.
Okay, we're not finished, though. All those opposed?
No. I struggle with this because, on the one hand, we have worked on this for a long time, and in the current form, I think that it is it's where we are, and I think it's been a very good process from the stakeholders across the spectrum. And to engage in the legislative process, I think that as we have the past few weeks with the Budget Committee, as also with Supervisor Peskin and Supervisor Tang, has been very helpful, because I think that this is a law for all the people of San Francisco. We're running up against the realities of the deadline. But on the other hand, going through the legislative process, I think we could end up with an earlier effective date, versus January 1st, if it were approved. As I hear Mr. Halpern talk about the momentum that I think is witnessing, and we heard from others in public comment, that there is a lot of support for reform, both contained in our ordinance as well as in the major donor legislation that is proceeding, and that it could conceivably strengthen our package of regulations. And so, it's it's on the one hand, we have certainty now of putting something on the ballot, and then there's the risk of going through the legislative process with continued amendments and continued changes. But as I have served on this commission, and I come to realize and have go through this process, for the first time, I realize that this is democracy at work, right? This is what we are all here to do, and so with that, I struggle with this. I really do, because I on the one hand, I feel like let's just put it on the ballot, because we can put it to the voters and it'll be over and done with. On the other hand, could there be could there be benefits to the longer process, and possibly a better outcome, right? And that we would be committed to working towards, and so with that idea of engaging with other stakeholders and continuing to honor the democratic process, I will vote no on putting it on the ballot.
The measure fails. I resign. Chairman Toots?
Yeah. Call a recess.
SF Gov TV, San Francisco Government Television.
Madam Chair, would you ascertain whether Mr. Hepner is still here?
Yes, could Deputy Attorney Shen, thank you, City Attorney.
And Madam Chair, would it be appropriate for us to consider a motion to set up a meeting with the Board of Supervisors as promptly as possible to proceed on the draft that they have in front of them?
So your question is whether or not we should consider a motion for the Board of Supervisors to proceed on the draft of the ordinance that they currently have, so not the one that we have considered today.
That's right. In other words, the alternative, I think we were given, sir, there were three alternatives of what this commission could do, one of which agree to a joint meeting with the board for the purposes of finalizing a ordinance for approval by the board and by the commission.
Yes, and so would that, and Deputy City Attorney Shen, would that require us to review the version of the ordinance that they currently have, or what we have approved here today, if we were to have this joint meeting?
No, here's Mr. Hepner.
Yeah, so the commission has approved a package of amendments tonight, largely based on staff's proposed recommendations and some additional amendments from the commission. I think the commission can certainly transmit that to the Board of Supervisors.
And would that supersede the version that they currently have in terms of the file?
Wait a minute.
It would not automatically supersede.
Wait a minute. How can you transmit it without a 4/5 vote?
Well, no, assuming there's a vote.
Huh?
I'm not suggesting that we automatically transmit it.
All right.
That we
Right, and
that
I
we
believe
would
you've
vote.
adopted all of the amendments.
Yes.
Yeah.
And the last question before the commission was whether to submit it to the ballot.
The question I asked is, could I make a motion that the version that we considered tonight and agreed on, the changes, that be submitted to the Board of Supervisors for meeting at a joint session of the Commission and the Board of Supervisors in an effort to work out an agreed ordinance that would be approved by the board and would have to be approved by the Ethics Commission.
Yes.
Well, that would be my motion.
Is there a second?
I'll second it.
Any discussion amongst the commissioners, or should we go to public comment?
Call the roll.
Commissioners, thank you. I trying to process what is happening right now, but I understand the motion is to forward the accountability ordinance as amended to the board in a joint session with the Ethics Commission. I think that is if that is accurate, or if that is an accurate restatement, the only thing that I would add and request is that this commission also amend in the new subsection 1.158 and the additional amendments to subsection 1.161 and 1.162 pertaining to major donor disclosures and television and audio advertisements. I think you can safely continue this to the next meeting of your Ethics Commission, which would be a joint session with the Board of Supervisors, and then we could act on that in joint session as part of the accountability ordinance. And I look to the city attorney for support on that, but I understand that procedurally is above board.
The joint session?
Amend in section 1.158 the changes to 1.161 and 1.162, continue it to the next session of the Ethics Commission, which would be a joint session with the Board of Supervisors. Is that procedurally, legally feasible as it was yesterday? I believe so, but...
Talk about the procedure.
Yes or no? Can we get an answer?
Yes, you can amend it in and continue to another session where the commission and both the Board of Supervisors can consider it.
And I think the staff would have some feedback we would like to provide about the merits and of doing that or not doing that.
Through the chair, I think that there is ample opportunity for staff feedback and to provide that feedback in advance of the next commission meeting. If we lose the opportunity to amend it in today, this does not become effective before the June election.
Through the chair, may I ask you, when can we get this joint meeting? February 28th?
It's not my prerogative, but I told you earlier in this meeting that I believe that it can happen the first week of March.
Well, then you're through with June.
And
you're through with June.
Commissioner, through the chair, if I may again repeat that if you put this on the November ballot with the same January 1, 2019 operative date, staff has the lead time to get this done. Don't let
You're
staff tell you
going
that
to
they can't do
miss
this.
2 elections. And the June election is going to have as much money as the November. I am not taking recommendations then from Supervisor Peskin's office.
Thank you, Commissioners.
Yeah.
Okay, any other public comment?
I think I'm going to try to explain for the television meaning the public, what it is we're doing. The recommendation by Mr. Peskin's office was to make sure to include the Peskin ordinance proposal, the major donor side of this equation, into your amendments and recommendations to the board tonight. So you would transfer the ACO, I believe it's called, the Anti-Corruption and Accountability Ordinance, ACAO, and add your support, as Mr. Peskin had already requested of you tonight, 3 days ago when he wrote, or before then, to endorse his legislation, as you would normally do in the legislative process. So the public will know that tonight you would have a unified bill which has 2 components, Mr. Peskin's concepts and your concepts, before you, again, when you meet with the Board of Supervisors, as soon as possible. I assume this would go to the Budget Committee. Maybe this is a question for the Council, but I assume that the Budget Committee would be meeting on this matter since it's before them. But there may be something extraordinary, too, that could be done. I don't know. They have dual options. Something extraordinary in the Budget Committee? Oh, sorry. Okay. Well, it's before the Budget Committee now. Anything you input back essentially goes to the clerk and then back to the Budget Committee. So that's where it's at now. What they want to do with this proposal to meet with you, I don't know. But I will say one thing, and that is that I have attended joint commission meetings like DBI and planning and other joint commission meetings on common interest issues such as seismic. So this is done not routinely, but certainly has been done with some degree of frequency.
Thank you.
Commissioners Ray Hartz, Director, San Francisco Open Government. Again, Mr. Marsteller, I understand your comments. However, for the public, I would like to point out that what we end up having is going from a year and a half, 2 years, whatever the length of time Commissioner Keene was saying that the staff has worked on this, and was put out to the public as being what was considered for adoption for the ballot measure, and furthermore sent to the Board of Supervisors. And now we're going with some sort of a thing yes, it was in the package as a proposal from Supervisor Peskin, but now all of a sudden we've got this amalgamation, this golem that we're creating, where all of a sudden the public doesn't understand completely all the different facets of what Supervisor Peskin is proposing and how it's going to affect what you just did. We sat here for 4 hours, you went through and did all these changes, and now you're going to just arbitrarily accept a whole smear of input from Supervisor Peskin, carte blanche. Just throw it in there. How's it going to affect the legislation overall? How's it going to affect the meeting with the Board of Supervisors? Nobody has considered that. Nobody's even thought about it. We're just saying, oh, you know, Supervisor Hepner says we ought to do this. And, you know, Commissioner Kopp just finished saying we've stopped taking advice from Supervisor Peskin's office, and yet it seems like you're going to go, from what I can tell so far, and sort of adopt a whole bunch of changes that he's proposing willy-nilly. I mean, if you couldn't get it right in 2 years, and we got here tonight and had all of these discussions where it was very clear to me, and I think the public, if they were paying attention, it was very clear to them that that you all didn't really agree on a lot of what was being put forward. And I would think after 2 years, the stuff that was put before you by the staff would have been something you pretty well understood with only slight modifications. And yet it appeared to me the entire night that you were having these arguments about nitpicky points of every single point, and it's kind of like, okay, so this is what you're presenting to the public after 2 years of your working on it. And now it seems like what you're going to do is say, well, let's take stuff from Supervisor Peskin and put it in, and let's just throw that to the public and hope they're ravenous enough to pass it. Hope they're dogs looking for red meat. I mean, this would be that would be the most unacceptable and most arbitrary action that I could think of to end out this bizarre item.
Thank you.
Madam Chair, may I ask a question of Mr. Hepner?
Yes, Commissioner Rennie.
Mr. Hepner, why does Supervisor Peskin want us to incorporate in these two proposals of his rather than letting the board do it at this joint session?
Thank you for that question. I think procedurally we cannot act on anything that this commission has not approved. So the idea is to have this commission make the statement today that it is ready to move forward this major donor disclosures piece so that the board can approve it at our joint session. I think that that's the importance today, is moving this forward in that fashion to send that message.
But when you say that it can't be approved at this joint session without our first tonight approving it?
Well, I guess the question that I would have, Commissioner, through the chair, is whether the commission would be able to take action in approving this major donors disclosure piece during the joint session without having to continue it to the next session of the Ethics Commission for final approval. And again, the Budget Committee or the Board of Supervisors can't approve anything that this body has not approved by a 4/5 vote.
I think that's a question for Deputy City Attorney Shen.
Yeah, so a couple things. So it's hard to say whatever could be heard at this, again, theoretical joint meeting. Not sure what comes out of that meeting is going to necessarily require another meeting. Obviously, we're talking about a meeting that hasn't happened yet, so I can't speak to that. If the commission wants to amend this in and continue matter, that's fine. But it does not necessarily mean that this commission formally approves the concept put forward by Super Peskin's office. As you know, what is in the commission packet is in draft form. It has moved very quickly, and there still needs to be time for both my office and the Ethics Commission staff to analyze and consider the consequences of that measure. I understand your goal is to move this along as quickly as possible, and we can try to move it along on a somewhat expedited basis, but it will still take some time.
I understand that, and respectfully, I think that if that advice comes before the board takes final action, before this commission takes final action, that ought to suffice.
Commissioner.
All right, let me make myself clear. I am not going to change. I'm going to change my vote on the ordinance as amended. I'm going to vote no. The question, Mr. Shen, is can I move for approval and transmission forthwith to the Board of Supervisors, sections 1.158, 1.161, 1.62, that's 1.162, 1.168, and section 3.231, 3.640, 3.650, as Mr. Peskin has proposed in his letter of February 13, 2018. All the provisions except the provision on recusal. Can this commission adopt and recommend all of those to the Board of Supervisors tonight?
Let me see if I understand that. So do you want to rescind the prior vote on the amendments considered by the Ethics Commission tonight?
No, I don't want to rescind it. That's through.
Right, but you said you wanted to vote no on some amendments.
Well, I
I'm sure what those
apprehend that it may be revived. Don't get in the weeds with that. Forget that. Forget what happened. It's dead for tonight. I'm asking you about this. Can I move approval and transmittal to the Board of Supervisors?
No, as I just tried to explain to Mr. Hepburn, no, the Ethics Commission cannot approve the proposed amendment incorporating a new section 1.158 tonight.
Why not?
As I already said, this measure has moved on very quickly, and I understand Supervisor Peskin's urgency in wanting to move forward with it very quickly. But again, as of today, there's no version of it that's signed. It's signed as to form by my office. It has moved very quickly and has also not had the benefit of analysis from both the City Attorney's Office and the Ethics Commission staff.
Could this...
The answer is no.
Could this then be moved at this theoretical joint meeting?
Yes.
All right. When can the joint meeting be held, Mr. Hepner?
Sir,
bearing in mind you've got to be at the Registrar of Voters by March 2nd. Can it be held on the 28th?
Sir, that is so far above my pay grade to be setting a joint meeting of the Board of Supervisors and the Ethics Commission.
I'm not asking for a binding answer. Do you think that's possible? 28th is a Wednesday. I'm available in the afternoon.
Paul's going to be gone.
Oh, you're not?
Yeah, Commissioner Rennie will not be here, but
Well,
as
I'm available on the 22nd in the afternoon.
Well, as the city attorney informed me earlier that although Chair Keene resigned, in order to actually effectively resign, he will need to submit something in writing. So that has not happened yet. So we may prevail upon him to reconsider.
And Commissioner Carp, with all due respect, I think the concept of putting this on the June ballot failed.
Yeah.
So that the March 2nd date is sort of an irrelevant.
Academic.
And I think the motion that I made and was seconded was that we deliver to the board a copy of the amended ordinance that we ruled on tonight and request immediately a joint meeting with the Board of Supervisors to consider finalizing the ordinance for approval by the Ethics Commission and the Board of Supervisors.
A question, Commissioner Ronnie, through the chair.
Yes.
How can you do that if it failed?
No, there's a current motion that as I understand, Commissioner Rennie, is to take the motion that just failed was to put it on the ballot, but the ordinance as amended was approved, and that would be transmitted to the Board of Supervisors with the request to schedule a joint meeting as soon as possible.
So you mean just continuing it to a joint meeting?
Yes.
And when can that joint meeting occur? February 20th?
Listen, you spent more time on the Board of Supervisors than I did. So
well,
how long it may take to get all of 11 of them agreed dates?
This is all academic unless it can happen by the 22nd. And give, what do you need, 48 hours notice to the public of a special meeting?
Commissioner, I am not entirely certain on this. What I will say with absolute certainty is that if the major donor disclosure piece is in this legislation, you have a majority of the board already co-sponsoring that piece and wanting to move on that quickly. So there will be a lot of desire to hold that meeting as soon as possible.
But I just heard from the Deputy City Attorney that we can't include that tonight.
Right. Commissioner Chu, I think to clarify, I think what we can do is amend that into the file and continue it for further consideration by the Ethics Commission. The Ethics Commission cannot take final action to approve it tonight, but it can continue it to its next meeting, which by Commissioner Rennie's motion would be a joint meeting between the Ethics Commission and the Board of Supervisors to consider taking final action on that.
May I ask a question?
Yes.
Mr. Hepner, what's the support at the Board of Supervisors for this proposal? Why are you rushing to have our commission approve it?
The support for the broader anti-corruption and accountability ordinance for the
the major donor proposal. Why are you coming to our commission before you get the support of your board?
Required to under the CFRO. We have been told that we are required to come before the Ethics Commission for this body's approval of that before we can approve it.
Yeah.
If that's incorrect, then that is profoundly different advice than I received from the city attorney 3 days ago.
Yeah, so let me see if I can propose something that will allow us to move forward from this item. Okay, so I hear there is a motion on the floor proposed by Commissioner Rennie to, again, not make any further changes, not make any further amendments to what was approved by the commission tonight, and forward it to the board for its consideration, right?
Correct.
The chair, Chu, for the time being, has the ability to call meetings, call special meetings, and I believe can, I assume, cooperate with Ethics Commission staff, Mr. Hepner's office, and try to find a date for this joint meeting.
Mm-hmm.
The joint meeting may or may not occur, but certainly we're not going to figure out a date for that meeting tonight. We not only have to coordinate all of your schedules, we have to coordinate all of the supervisor schedules, figure out meeting room availability, et cetera, et cetera. But I think with the understanding that Chair Chu can proceed and pursue that option to figure out whether that meeting can happen and whether the scheduling can occur, I think that's within her discretion as chair to call meetings and to set agenda items.
How many hours notice? Is it 48?
I believe it's 72.
Yeah, in general, there's 72 hours notice for any meeting.
Huh?
Yes, in general, 72 hours for any meeting.
All right.
Okay. So is there any additional public comment? Yeah, I believe so the motion then from Commissioner Rennie is to take the ordinance as amended this evening and forward it to the Board of Supervisors and to request as expeditiously as possible a joint meeting of the full board as well as the commission.
Just a clarification on the motion, does that include amending in sections 1.158 and the amendments to 1.161 and 1.162, which I believe Commissioner Kopp expressed some interest in?
Yeah, you want to take the recusal section out?
I don't have any comment to make on the recusal section.
I'm not going to move it.
Then I would support whatever it takes to get the major donor disclosures piece 1.161 and 1.162 included in the broader accountability ordinance for the joint meeting between Ethics Commission.
I thought Mr. Shen has already said we can't do it.
No, and Deputy City Attorney Shen, if you can please clarify, what you can do is amend it into the file and continue it for consideration by the Ethics Commission at the next meeting.
The next meeting.
Which is exactly what your motion proposes, Commissioner Rennie.
Right, so you can amend it in, but it does not constitute approval for CFRO amendment purposes tonight.
All right, I'll move it to be included in the rest of them without section 3.20.
Right, but which, just again, I know there's been a lot of amendments tonight.
What?
So what are we amending in?
So as I understand,
right here,
the motion is to take the AAO ordinance that we amended tonight and also, as approved, send it to the Board of Supervisors. But we are also amending in, without approving, but simply continuing for discussion with the full board and the commission, the proposal of Supervisor Peskin, we'll call it the major donors financial disclosure.
Madam Chair.
Without the recusal procedure section.
Madam Chair, may I ask if Commissioner Rennie would be open to have two separate motions, your standalone and another one to include the section 1158? It seems like we only have one option to vote right now.
Okay, so you want to bifurcate the vote. So we'll have a vote first on Chair Rennie's, which is to send over the amended ordinance and ask for the joint meeting to be scheduled ASAP. And then a second motion, Commissioner Kopp, your second motion would be to, what was the right term? Amend in sections 1.158 as proposed by ETSEC, proposed by Supervisor Peskin, with the exception of section 3.209.
Correct.
That's fine with me. Let's.
Other than it could convey your support for this, and
What?
this will convey support for this major donor proposal, whether or not it works for CFRO. And I just want you to realize that that's what you're conveying support for. We don't fully understand it, so
You don't understand what?
how this major donor proposal would work, or whether it's constitutional, or whether there's a number of questions that we have about it.
You'll raise them at the meeting.
But I'm trying to say that voting to amend it into the file conveys your support for it.
Well, I do support it.
I just want everyone to understand that.
All right, let's.
So I
Go
think
ahead.
we can go ahead and call the vote on the Commissioner Rennie's first motion to send the amended ordinance over to the Board of Supervisors and schedule the joint meeting.
Well, may I suggest that I think this should take precedence, be voted on first to be included in it.
I think as chair, you can call the motions as you see fit.
You can what?
She's the chair of the commission at the time being. She's called the motions.
So, all in favor?
Aye.
Aye.
No.
The motion fails. Is it three? Okay, the motion passes 3-1. On the motion to incorporate or to amend in Supervisor Peskin's major donor disclosure and incorporate that into to be sent over to the Board of Supervisors to be included in the joint discussion. All in favor?
Aye.
Aye.
Aye. Yvonne?
No.
I
No.
think you suggested that.
No, Supervisor Cobb, Commissioner Cobb suggested. I just wanted to separate the.
So,
Actually, they just separated.
Yes, that's why I voted no on this amendment.
okay, so the motion passes 3-1. All right. So,
Can I clarify that last motion just for the record?
yes.
Just so that I'm not doing it with watching it back. I believe the motion was to amend in 1.158, and then the amendments to 1.161 and 1.162, and I believe what Commissioner Kopp had moved was to not move in the deletion of the recusal section.
You've got 1.168. And you've got,
this is why I wanted to clarify, because I think.
I clarify it.
Sure, thank you.
All except section 3.209.
In that.
Yes,
Correct, thank you.
which you prepared with your own hands.
Thank you.
Okay.
Okay.
So we have the rest of our agenda to get to. Unless there's anything else on agenda item 4, we'll move to.
So I'm so sorry, but you all voted to take out the recusal part? That was not my understanding of the vote.
No.
Of Peskin's.
Of Peskin's ordinance. So in Peskin's ordinance, he had eliminated
Right,
the
but
recusal.
we don't have that, so. It's right here. Okay.
Here, give this to her.
Right, we had proposed deletion of the repeated recusals. The commission did not want that.
Right.
Madam Chair, can I just have one more clarification? I know it's a long night. Assuming the joint session will be coming up soon, but if it doesn't, can we have the city attorney's office as well as the staff to give us a more detailed analysis of Supervisor Paskin's proposal?
I don't want to speak for staff, but certainly in advance of the next meeting,
Right,
whenever
right.
that meeting occurs,
Right.
we will
That's all I wanted.
provide more analysis.
Thank you.
Thank you.
Okay. The next agenda item is number 5, which is the discussion and possible action on proposed Whistleblower Protection Ordinance, SF Campaign and Governmental Code Section 4.100. That's it.
No. Commissioners, this is our staff memo on the status of the whistleblower ordinance. We have provided to you a copy of a version of the ordinance in 3 formats. One is a whistleblower protection ordinance in a ballot measure format as attachment 1 to agenda item 5. We also have a red line version of that. And then we also have a version of that revised whistleblower protection ordinance were it to go to the Board of Supervisors for its action. Since your last commission meeting, 2 notable events have occurred. One is that the meet and confer process concluded. A minor change in response to those discussions appears in this document. It simply removed a requirement that a specific form be used for supervisors to handle and refer the complaints regarding retaliation. And this does reflect the same changes that you saw last month and embraced last month as part of your adoption of the 2017 version of the Whistleblower Protection Ordinance. We're providing this to you as you requested at this meeting so that you could determine whether or not you wanted to take steps to place it on the ballot, or whether you wanted to take steps to place it, send it to the Board of Supervisors for its action, requesting that it be reintroduced with the new language. We have received a word from Supervisor Breed's office, who was the sponsor of the 2016 legislation, that she is interested in reintroducing the ordinance. And so that's a point of information they've asked us to relay to you, of course, so that you can consider that in determining what next steps you want to take. But with that, I think I'm just want to open it up for any questions or public comment.
Commissioners, any questions?
Yes, I would make a motion that we adopt the ordinance, which is identified as our 2017 WPO ballot measure, which is attachment 1, and have it placed on the June ballot.
So I have a clarifying question for staff, if you will. I understand that the ballot measure and the ordinance as drafted, there are some slight differences as between the two. Could you give a summary of that to make sure that I understand what would be missing from the version that would go onto the ballot?
Yeah, so due to the jurisdiction of the Ethics Commission's ballot measure authority, we had to slightly scale back and slightly narrow what would be proposed in the full legislative proposal.
Mm-hmm.
And I think those changes can be sort of fall into 2 categories. So the proposed changes to 4.105, which generally govern the overall scope of whistleblower complaints, which can include complaints raising conflict of interest and ethics concerns, but can raise other types of concerns.
Mm-hmm.
Those proposed changes were removed. The other big category of changes were the proposed edits to section 4.107. Those proposed edits would have addressed the controller's whistleblower program, so something outside of the Ethics Commission's jurisdiction as well. But I think the bulk, and I'll let staff speak generally to this sort of policy impact, but the bulk of, I think, the amendments in the full legislative package are still there in the ballot measure version.
Okay. And then for those provisions that are excluded from the ballot measure provision, could the board act to incorporate those, or do they just disappear forever?
I think if the Ethics Commission were to move forward with the ballot measure, I'm not sure Supervisor Breed would want to introduce the remainder of the proposed changes.
Okay.
I mean, I think that would be a different decision point for her.
Thank you. Any other comments or questions from
Well,
commissioners?
let me express myself. One of the problems voters face is too many ballot measures to figure out. And that's why I would just prefer an ordinance, especially when apparently Ms. Breed is committed to this and she's president of the board. She ought to be able to get enough votes to get it passed. The other matter is a question. Why is the controller involved in whistleblower complaints? Anybody give me the rationale?
The charter and the Campaign and Governmental Conduct Code designate the controller's office with the authority to run the whistleblower hotline, and that's just how existing law has set it up.
Yeah, but what's the rationale? Do you know?
I can't speak to the policy rationale as why it's with the controller's office versus 311 or the police department or the ethics commission. I can't speak to
Or the ethics commission, or the city attorney.
My understanding from the whistleblower director is it's because of the controller's expertise in financial matters, and most of the complaints allege like fraud and waste of city resources. So in contracts or in different financial capacities. So their auditors have a special expertise. That's the rationale I've been given.
Pretty weak rationale.
Okay.
Why can't
Any other
the city
questions from the
attorney
commissioners?
do that? Or the ethics commission do that?
But
Commissioner Rennie?
But does the Ethics Commission have jurisdiction on those items that the controller is deemed to be most knowledgeable about? In other words, misuse of city funds?
Our jurisdiction is over conflict of interest and campaign finance, governmental ethics rules. It appears in 4107. And retaliation. So if anyone's retaliated against, it doesn't matter what the underlying complaint is.
But if the complaint is that somebody has misused city funds, if they come to the Ethics Commission staff, they're directed to go somewhere else, are they not?
Unless there's an allegation that the misuse was related to a personal financial interest, we would direct them to the controller's office.
Right. Any public comment?
Commissioners, Ray Hartz, Director, San Francisco Open Government. Whistleblowers in the city and county of San Francisco are very courageous people. Unfortunately for them, sometimes it is their last and only option. They come forward trying to right a wrong, knowing that historically they will receive nothing for their trouble but abuse. To my knowledge, this Ethics Commission has never done anything to protect a single whistleblower. They just keep rewriting the law, hoping the public doesn't notice the complete lack of law enforcement. Commissioner Keene earlier this evening talked about going to the ballot and talking about the will of the public, et cetera, but the Sunshine Ordinance passed with a 67% margin, and you won't enforce that. So what is it? You enforce one law because the public votes for it, and you ignore another law because the public voted for it. I don't understand any sense of logic there. So you keep rewriting the law. Why would you, in the name of all that is holy, enforce this law? This law, along with others like the Sunshine Ordinance, are approved by the public to control city government, particularly elected officials. In other words, the very people who appoint the members of this commission. From studying the historical record, no reasonable person would expect that these political appointees would side with a whistleblower against their political masters. How many times will the public allow them to repeat this farce? When will the public demand results? Achievement, not simply activity. You pass a law and you enforce it. If you pass a law and don't enforce it, then there was no point in passing it in the first place. The city of San Francisco passed the Sunshine Ordinance, and I've got 36 order of determination myself as one individual, all of whom you have refused to enforce. So basically, why should the public accept this oxymoronic logic where you're saying, okay, this was passed by the public as a ballot measure, we will enforce it, when we have another law in the books that we're responsible for enforcing that was passed by the public, and we won't enforce it. You don't like my comments. I know that. And sometimes, as I said earlier this evening, sometimes it's a matter of getting it in the public record so that 3 years or 4 years down the road, when we're in the same discussion, I can come back and say, I told you so. Or the possibility is maybe you will actually do something. And I will come back and I will say I was wrong. And in an official record, I made a statement, and I'll admit now that I'm wrong. I hope that I prove to be wrong.
Thank you.
So I'm one of the last men standing out here. We've lost Mr. Bush. We lost, unfortunately, Dr. Kerr, who submitted a letter with his comments. I would urge you to take his carefully considered comments in hand and make sure that you give them due consideration. I am not an expert in this area. Certainly Mr. Bush was, because he's a member of the Controller's Advisory Committee, which is called the General Obligation Bond Committee. I think the reason it is true that I think Controller ended up with this because it's a historical artifact in early charter. However, I think also with Prop C monies coming into the Controller's office to do audit, this boosted resourcing at the Controller's office, and that's probably why ethics is quick to refer certain types of complaints right over to the Controller. So it's probably a dollar and cents and a resource issue, although that's less of an issue now that the Commission staff has grown with the support of the board and the mayor, including Mr. Lee, who we want to appreciate for his support of the ethics budget. But that's all I really wanted to say on this. I hope you will put it on the ballot. I don't know if Supervisor Breed has the time for it until certainly after July or June, but it's likely if she's elected, of course, she's not going to have time for it at all. So it might be something you might want to do if you have your votes.
Thank you. Any other public comment? So on the motion from Commissioner Rennie to take the Whistleblower Protection Ordinance and place it on the June 2018 ballot. All in favor?
Wait. I want a comment from staff on the first point Dr. Kerr makes. The second point I'm not concerned with, but he refers to state legislation. It sounds like it's pending. Do you know, AB 403? Or was it enacted and he's using the bill number? Do you know?
Yeah, I followed it loosely in the news, but it did pass.
All right, then get to the substance of using the words interference with and retaliation for making protected disclosures. Is that preferable language?
We have not undertaken an analysis of anything in Dr. Kerr's public comment that we received yesterday.
So you don't have an answer?
No.
You have any feeling?
Do
I mean, I kind of like the phrase interference with, but all right, no answer.
So are you okay with?
Well, all right. I'd like a staff quick analysis at your convenience.
On analysis on AB 403 that outlined in section 1?
this one.
You'd like the analysis of the language of interference
that
with?
language from a bill which was just passed by, what was it, signed by the governor?
Right.
All right, so it's law. I'd like an analysis of the use of that phrase in that legislation with what is in our proposed ballot measure.
Okay.
Sorry to interrupt. Does enabling, okay. I was wondering if you can get a reg that addresses this for Mr. Kopp.
In view of Commissioner Kopp's comments, I will withdraw my motion and have this put on the March agenda.
Okay.
So withdrawing your motion, putting it on the March agenda, then precludes putting it on the June ballot.
Oh, yeah, that's right.
Yeah.
That means November then.
Correct.
You're satisfied with that?
That's fine.
Okay.
It has less impact on the elections.
Yeah.
As opposed to our anti-corruption ordinance.
I have a procedural question for the city attorney, Deputy City Attorney Shen. If with the withdrawal of Commissioner Rennie's motion to put it on the June ballot, does the commission need to take action, or we just hold this over into the March meeting?
Right.
Continue it pending staff's analysis of the language that Commissioner Kopp had requested.
Right. So I understand the motion be withdrawn, so there's no proposed action on this item. And so this goes back into the Ethics Commission docket, and whenever the commission wants to reconsider, it can reconsider it.
Okay. So we'll take this up at our March meeting then. Okay. Item number 6. Discussion of staff update on research about online paid political communications, including legal and policy considerations for the Commission's review.
Thank you. Quickly, as you all know, in November of 2017, Commissioners Chu and Lee met with us, the staff, and former FEC Chair Ann Ravel, Professors Chris Elmendorf and Abby Wood. That was related to a proposal that those three individuals had worked on together that highlighted some analysis that requested that some localities review online political communications. From that, the most significant provision was a provision highlighting a political filing or archiving system. From those meetings and from the January meeting of this body, you all, well, actually from December and January, I guess, of this body's meetings, you had requested that we continue to sort of review the legal and policy implications of these documentations. We worked through our Leanne, Jessica, and I's visit to the Conference on Governmental Ethics and Lobbying, and continued to work with those professors here to do to provide a legal analysis. And I want to recognize Professor Abby Wood and her two research assistants, Justin Mello and Rachel Grant of the USC Gold School of Law. They prepared for us in Attachment 1 a very nice analysis of the main legal concern, which is regarding federal and state preemption as it relates to creating this political filing system. Their research concluded that there likely would not be a preemption issue either at the federal or state level. We'll let you all consider that attachment if you have not had the chance to review their legal work. In addition to that effort by Professor Wood and her research assistants, staff has also been monitoring a number of white papers, law reviews in this area, but in particular, we've really been focusing on two other localities that have been addressing this issue. The first and most important system that we're monitoring is the city of Seattle and the state of Washington. Both of those entities, I guess I will call them for lack of a better term, had or have had on their books for roughly 3 decades, going back to the 1970s, a provision that would effectively require what Professor Wood and Professor Elmendorf and former Chair Ravel are proposing. that would require each commercial advertiser that has accepted or provided political advertising during the election campaign to maintain for public inspection basically a political archive of these items. After sort of, although this provision had been on, as I said, been on their books for about 3 decades, that law really wasn't used before until recently, and the Seattle Ethics and Elections Commission had recently instituted a procedure that they were going to now begin to enforce that provision, and they had asked that Facebook provide comment to them regarding whether they were going to comply with this provision in the political file. Facebook did comply. However, the director of the Seattle Elections and Ethics Commission determined that what they provided was insufficient. So we are continuing to monitor what, if any, sort of administrative or legal action. They are working with their local attorney to determine whether and how they can force Facebook to comply. So we are monitoring that very closely. We haven't seen any updates since that occurred just a couple of weeks ago. In addition to that, we are monitoring New York, and Governor Andrew Cuomo's has relayed an interest in a similar proposal, although more directly related to the Honest Ads Act. There are slight differences there. I don't think it's really that important to get into those today. What I think is more important to get into for our purposes is Section C, and that's on page 5 of Agenda Item 6, is that although we've gotten some very nice legal analysis from Professor Wood and her research assistants, there still are a number of open policy questions that we have ascertained from documents. Stanford, directed by former Senator Russ Feingold, and a couple of others had directed some research that raised a number of questions regarding the sort of a public file or political archiving system. So you'll notice in Section C that we have laid out a number of additional questions for further exploration as we go along, and we've sort of identified concerns in each of those categories. So these are items that we want to continue to explore and work with our other partners that we've already identified to move forward on. So those are really informational for you all, just to know what we are continuing to research as we move forward in this arena. And lastly, on to page 6 of item 6 is a proposed schedule going forward. This might have to be slightly modified because of the action on agenda item 4, likely pushing back the dates that we have proposed in here. But this is a tentative schedule of dealing with these items, with the next 2 months basically just being continued research and working with Professors Elmendorf and Professor Wood to continue to research this item to see whether we can put forward a rational piece of legislation that will potentially address this election meddling and online political communication issue. So with that, I will leave it open to questions from the commissioners.
Any questions or comments from commissioners? Commissioner Lee.
Thank you, Madam Chair. I just have a quick question regarding your proposed schedule.
Yes.
You have included a proposed public forum or a meeting with subject matter experts
Yes.
for spring. I would suggest that before the public forum, that the staff will put together a stakeholders meeting to bring together subject matter experts and other potential partners before the public forum, to really iron out some of the other issues, preferably close to the June election, because that's where we can gain a lot more insight in the subject area, and that would be really helpful.
Thank you, Commissioner. We'll take that under advisement and with the, I think, direction of the Vice Chair at this time. So thank you.
Acting Chair.
Acting Chair, yes.
Any other comment? Commissioner Cobb. I would just like to say, I would like, please extend my thanks to Professor Wood and her two law students who did, stellar work on the analysis, because I think that the preemption question was a large one and a significant one that would that needed answering, and for them to be able to prepare such a detailed and thorough analysis in the time frame that they are working under is greatly appreciated. And so, and please keep up the great work, and look forward to continuing this dialogue and engaging with the stakeholders. And I don't know if you all saw, but there was an article just a couple days ago where the FBI is warning that there will be more Russian meddling in the 2018 elections. So I think this is very timely.
There was 13 indictments today from
Yes.
Mr. Mueller. So
Yes, exactly. So this is very much of the moment. Any public comment? No? Okay. Moving on then to agenda item, where are we? 7, discussion and possible action on staff's monthly policy report, including possible updates to the annual policy plan.
Thank you. I think I will run through this fairly quickly. I think we've addressed a number of these items. The only thing I really want to specifically point out, because I think we've addressed everything else, is on agenda item 7, page 2, the Form 700 non-voting ordinance. That was taken up by committee, the Rules Committee this week, and that was voted on unanimously. It was favorably voted to go to the entire board. So I think there's a very high likelihood of the Form 700 non-voting ordinance being approved perhaps at the next full meeting of the Board of Supervisors. So we're optimistic there, given the full positive recommendation of the Rules Committee. I really don't have any other updates on this, but if anyone has any questions, or any of the commissioners, that is, have questions based on this, I'd be happy to answer them.
Mr. Kendrick, I had a question about Supervisor Kim's legislation. There was an attempt at the end of 2017 to meet with her, but that was scheduled and canceled and rescheduled, and so it never happened. So I'm not sure where we are with that.
Yeah, absolutely. So we passed along a letter to them, sort of outlining a number of our just open questions and potential concerns that we had for them, and that was January 17th of 2018 that we sent that letter across. So the policy division had concurred, and we will reach back out to them after this meeting to see sort of if they've had a chance to review and sort of where that progress is. But we have not heard any subsequent item.
Well, she is running for mayor, but I understood from her last year that she wanted to enact something or put it before the full board in order to have it be in effect for the mayor's race. But she was thinking down the road, not in June. But I don't know if the events have overtaken her and have changed her timetable.
Yes.
So, but okay.
Thank you.
Thank you. Any public comment?
Yes, I can update you on Supervisor Kim. She's had numerous interested party stakeholders meetings. FOE has been attending every one. And she has commissioned a study by the Office of the Legislative and Budget Analyst to look at all the public financing systems, or at least 6 or 8 of them, the major ones in the United States. That study is in phase 2 development. It's very impressive. I sent Bob Stern a copy at their request. They expect to have a 3rd draft, which will be the final draft. It's very robust, and at that point, they'll release it, and I'm sure we'll be happy to share it with the staff. But now that it's a moving target, there's very few people that have seen it. They have a general policy preference, but they're open-minded, and they have asked everybody they've been talking to get prepared to make comment to them after June election. She doesn't want it to appear that this is done for campaign purposes, and she's busy anyway. So after June, this summer, maybe next fall, she'll be working on it, depending on if she's elected.
Thank you. Any other comment? No, hearing none, we'll move on to agenda item 8, discussion of staff's monthly enforcement report, including an update on various programmatic and operational highlights of the enforcement program's activities since the last monthly meeting.
Thank you, Chair Chu. The enforcement team has been busy. We have the three investigators are working diligently to conduct interviews. They're busy every day. I barely see a couple of them. They're doing great work. We received 9 complaints since our last meeting, and we decided 5 merited dismissal and opened 2 new investigations based on audit findings. We continue to work toward resolution of complaints. We have scheduled our first probable cause hearing since the new investigative staff came on board for March, and have a meeting with that respondent in an attempt to reach a negotiated settlement in advance of the meeting, but plan on going full steam ahead if that doesn't pan out. I've updated the number of open complaints, open investigations, the Bureau of Delinquent Revenue chart, the payment plan chart. Everyone's up to date so far. And then the caseload data for you, visual caseload data for your review, and I'll take questions.
Any questions or comments from commissioners?
Get me an answer from the Bureau of Delinquent Revenue as to whether an order of examination has been conducted in the first 4 cases you've got there. The last one is bankruptcy, but I see nothing about an OEX having been up.
Okay.
Any public comment? Okay, then moving on to agenda item 9, discussion of executive director's report.
Thanks, Chair Chu. The ED report is a little bit long this month. We've started I've included some information about the public financing program since the June election is underway in earnest. We have 2 candidates as of today that we have certified to receive public funds for their campaigns. We will continue to update our web pages live with information about candidates who've qualified as well as disbursements they've received. So that's information that's contained in this report. We've also launched our Statement of Economic Interest filing process and filing season with outreach to departments. We've had our first information session for filing officers to help them understand what to expect this year, including some new regulations about the sunshine and ethics certification and training that the Commission has adopted recently. We also have good news in terms of our campaign audits. We have completed 4 of the 5 non-publicly financed candidate committees through our in-house staff. We are also very soon, probably the next week or so, expected to post online, in addition to those, the slew of publicly financed candidates audits that were conducted through the City Services auditor contract audit team that did those. So we've made some good progress. Our audit team is pulled off daily dealing with the public financing qualification program, though, so that is putting in abeyance some of the continued audit work. But on that front, I am pleased to let you know that we have a new auditor joining our staff in 2 weeks. Rob Hodge couldn't be here today, but he is going to be joining our staff. He's got direct experience working as a compliance specialist and political reform specialist at 2 of the area's political law firms. So he's very familiar with the requirements of city law and lobbying laws as well. So we're looking forward to having him join the staff. I think you also earlier in the evening met Thomas McLean, who we are pleased will be joining our office next month as our new 4th senior investigator to round out that team, working with Jessica. And again, both individuals have terrific spot-on experience. We're excited that they're being able to bring their insights and experience to the staff joining us in the coming weeks. We have instituted a work order with the Department of Human Resources to continue to be as aggressive as possible to complete our hiring plan between now and the end of the fiscal year. We have 4 positions that remain outstanding, so those are positions that we are going to be working on very quickly now with the additional assistance of DHR. And then lastly, but very importantly, we have, as you know, our budgets are due to the mayor's office next Wednesday, the 21st. And I've attached to this an overview of the budget the budget package that we plan to submit. There's no action required on your part. This year, the mayor's office, again, has, as Mayor Lee, the late Mayor Lee asked in December, Mayor Farrell is continuing his direction to mayoral departments to submit budgets with a 2.5% cut each fiscal year, and not to increase budgets with any full-time equivalencies. Our budget request will not ask for new positions. We are very committed to filling the positions that the mayor and the city, the Board of Supervisors has embraced in the last 2 years to help right-size our organization and staffing, and to continue with our capacity building efforts. We will not be seeking new FTEs in this next year's budget. We are not, however, in a position to offer any cuts. We are trying to continue the trajectory of making the improvements and innovations and changes that I think you've seen on a monthly basis. We know that we have a ways to go in terms of continuing to improve our programs across program area, to continuing to deliver audits in a most timely and thorough way, continuing to make great strides as we have with Jessica and her team and bringing the lags in enforcement cases down and bringing the significance of cases we review up. We've been seeing progress on that front. We are at a period where we need to continue those gains, and that we need to invest in the staff who will be in the chairs doing those jobs. So our budget request provides three particular things. One is a retention of all the staff that we currently have, 24 authorized positions. We are also asking that we have full funding for those positions, because as you recall, that when we have new positions authorized, they are authorized only for a partial year. And so in the normal course of things, this next year we would have positions at a full-time, 100% full year capacity, and we want to make sure that we have funding for that and recognize that any structural salary account shortfall is dealt with. We also are asking that the attrition savings amount be returned to our operating budget. This is a formula that often in the budget process essentially takes off some from the top and makes departments that have a lot more staff and turnover than we do manage to a lower target than a full salary savings account. That doesn't work when we're a small organization, and it particularly doesn't work when we've just recently been staffing up. So we are asking to not be held to a attrition savings target in the coming year, so that we can have seats filled, bodies in those seats, and the work being done. And then we also, importantly, are recognizing that we want to expand not only our policy outreach, but education, outreach, and public engagement to communities that are not as fully served. We have not had a line item in our budget for translation services and our communications to communities that do not have English as a first language, or that communicate largely in English, in non-English languages. We're not communicating well with. So we have asked for a budget increase of $15,000 to make sure that we can, both in offline and online materials, help provide information to people at a time when there are, as you've heard tonight, significant political change in the city. It's really important that we reach out broadly to help make sure that we are engaging as broadly as we can to make sure we have transparent and accountable government. And then lastly, to support staff development and retention, we need to invest in the staff that we have, and so we've added additional $37,000 for training to invest in employees' knowledge, skills, and abilities, along with a continued work order with the Department of Human Resources to provide expanded human resource and personnel services to our department administratively, because we don't have them now and our department needs them as a growing department. All in all, this is roughly a 10% increase over our base operating budget. And again, this is something that we think is critical to get us in the right structure and setting to keep delivering on the things that we've identified as priorities as an agency over the last several years. So that is the budget that we'll be submitting. Happy to answer any questions. We've presented basically an overview and a scorecard of how we're doing based on the specific goals that we identified back 2 years ago in our Blueprint for Accountability. And this reflects our best judgment about where we've been able to make some strides and where we still have work to do. The last thing I'll just say is that we talk often about our performance indicators and how do we know if we're making progress. We hope that our work speaks for itself. We know that there are improvements to be made, but we also see quality work and expanded work and only increasing work that's being demanded of us with elections and other issues coming our way. So one of the things that we have done this year is to make sure that we are closely aligning our individual performance goals each year with the overall organization's top priorities. So we have an annual performance goal discussion process with employees so that we all know how our individual work contributes to the overall success of us as an organization. And that's a really important and a new seriously taken process for us this year. So we'll be engaging in this next month in our check-ins for mid-year to see how we're doing. But it's important that we're all aligned with what we're trying to do organizationally in terms of our top priorities. So with that, I will stop and answer any questions that you might have, and happy to provide more information if you don't see it here but you'd like it.
Commissioner
I
Wren?
just have two questions related to the revenue report. How do you explain why the campaign finance fines are so much higher than what you anticipated, and the ethics fines are so much lower than you anticipated?
Do you want to talk about fines collection? Or I'll turn it over to Jessica for a bit of an insight.
Sure. It's hard to pinpoint or guess what forms people are going to file late and which they're going to file on time, but this year we just saw an uptick in the amount of forms that people filed late in the campaign finance context, and so their fines were assessed at a higher rate than we anticipated, and then our SEIs came in on time. I think that probably has a lot to do with targeted efforts in education and outreach on the statements of economic interest that we have not had the bandwidth to do for campaign finance. But it is that's one of our priorities for the coming year, and with the hiring of Gayatri Takandil as Chief Programs Officer.
Thank you.
And just one last note as well. I think this may be, that number for receipts in the ethics area may change towards the end of the fiscal year because the annual statements come in April. So this also may be subject to the unique timing.
A couple of questions. I found no mention in your report or any other document about my request for legislation to prohibit candidates for local election using funds that were part of a campaign for a party central county committee.
Next month.
Not in March.
Huh?
We have in our, we reviewed the minutes, or I'm sorry, the video, and you requested that in the independent council memo for March, for the March meeting.
The March meeting.
Right.
Thank you. And then secondly, what happened with that hearing at the Sunshine Ordinance Task Force?
They haven't contacted me and said that they're going to go forward.
right.
So I'm assuming it died,
news
but
is
we
good
did not
news.
participate.
Okay.
Thank you.
Commissioner, any other comments from commissioners? I would just like to comment on I believe is really critical that we communicate to the mayor and the controller that we have no staff reductions in the upcoming fiscal year, because this has been an ongoing effort for us to staff up, and we're still in that process, and that to curtail that now would be a significant and material critical hit to our ability to be effective. So I'd really like to emphasize that. And the second question I had was with regard to the public finance funds, because we are having an interim, a race for mayor in June, and we have a lot of supervisor races, and we have another election in November. Will we have sufficient funds to cover all the public financing needs?
Based on our analysis with the Controller's Office of the required fund amount, we will be fine for the June election, which carries us through the end of this fiscal year. For the November election, we're working with the Controller's Office and the Mayor's Office. They're aware that it will require an additional significant infusion to cover for that election, as well as for the next election in November of 2019. So we won't have that dollar amount until we know kind of what the drawdown is from this election.
Right.
But it's on radar, and we're working with it.
Okay,
Yeah.
great. And lastly, or actually no, second to last, on page 15, what a fantastic chart. Two of them. I think that that these graphics are incredibly impactful and powerful, and I think that this is what makes the story come alive. Like, to show this is what happens when you are understaffed, and this is why we need the staff to be able to do this work, because the spike speaks for itself. When we had 0 investigators, and the number of complaints had an all-time high of 131, and then when we have 3, it dropped to less than half. in January. And it ticked up a little bit, but I think this is, if anything, this is a testament to the power of hiring the right people and turning them loose and doing what they do best. And I like how the lines crossed, where we have more complaints that we're actually investigating as opposed to trying to figure out if it's actually worth investigating. So I think that's a really, really great development. And then lastly, I don't think you addressed it, Director Pelham, but there was the telephonic participation in commission meetings. Could you speak to that a little bit? And I had a question about sort of next steps and what it would like to hear from staff as to what your recommendation would be.
Well, I'm happy to also have the input from Pat Ford, who was in the meeting with Stephen Massey and the City Hall telephone people. The headline and the unfortunate headline actually is that there are technical requirements that make it impossible for us to have a telephone line currently for this meeting and this time in this room. There is technology that the system uses, a hybrid unit. I won't go into the details, but it is something that essentially allows for a party line. Right now it's used by one commission, the Commission on Disability. And so everybody kind of queues up on the telephone line and then waits turn to speak to the commission. Here, that technology would require, it prevents the ability, like a radio call-in show, to be the first queued person to speak. And if there is any kind of discussion or disruption among the group, the entire group has to be muted. And it requires a staff person to monitor that during the time of the phone calls coming in. So I would say it's rather arcane and probably not the most nimble of systems that would serve the interest that the Commission has expressed in wanting to have public participation remotely. And so that unfortunately does not look like a terrific option of any sort. But Pat, if there's anything to add to that, or
I concur with Leanne's assessment in meeting with the folks that specialize in this stuff downstairs. This seems to be really the only option, and it's not a very appealing one. It's very inflexible. It seems like basically the communications infrastructure here in City Hall is not.
It's not 2018.
Yeah, it's not able to accommodate lots of other methods that you might think of. It just kind of is a little bit narrow in terms of what it can accommodate in this way. So it would basically be everyone calling in at once, and there would have to be a dedicated staff member at all times to monitor the line, and there's really no way to police it. I mean, you literally just turn it off and on. That's it.
Do you know how...
Commissioner Lee?
Do you know how much a podcast... Do you know how much a simple podcast costs?
I'm sorry?
A podcast.
Oh, how much a podcast costs?
Yeah, would cost the commission, because it's such
don't.
a simple thing to do. We do that every week, and we have upward to 200 people calling in. And all it takes is just one staff to monitor the questionnaires.
So do you mean a way for people to communicate with the
If
commission
they want
through
to, if they want to
online?
ask questions, they just punch in, and then we'll just queue them in.
So
they could participate the entire meeting.
Right. So my understanding
4 hours.
From talking with the experts here is that that kind of option, which I believe is called voice over IP, VoIP, is not available here. That there's not the technology to patch that in, because the problem is it has to be able to be patched into the television system, and that's not feasible. They can't do that. The only way to do it is to mount some kind of unit in the audio system that we're all speaking into right now, and they don't have a way to have a VoIP system patched in that way. They can only use this. Basically, it's a telephone that would be patched in, and it would be a conference line that's based in our office, and people would call into the conference line just on the actual telephone. So not through VoIP, like through the internet. It doesn't work that way.
I think, and these are constraints based on the assumption of City Hall meetings. we haven't researched this, but it is probably the case that if there were meetings available in other buildings somewhere else in the city of San Francisco, this technology hurdle may not be the challenge. So in terms of next steps, to the extent that we can continue in conversation with city technology people to see if there are other places or other ways where meetings are handled in a little bit more 21st century technology, we can certainly monitor that and report back on where that might be possible. Ultimately, that might require some consideration about whether City Hall is the best place for the commission to engage the public in that way. But, we can certainly continue to ask and monitor and engage in conversations about that.
Yeah, so my comment would be sort of similar to Commissioner Lee's, and that would be to ask to go back to the experts in IT for the city. Is there a way to incorporate a feed into the television itself? When you watch CNN or something else, you've got the ticker tape that goes on the bottom that can update with tweets or other comment. It seems very standard for current media, but it might be much too complex or incompatible with our current city systems. But I think it's worth asking the question.
Yeah, we'd be glad to reach out to them with that question.
Thank you. Any public comment?
My name again is Mark Bruno, and the real reason I came tonight was because I want to just familiarize myself with the Ethics Commission, because I have an ethics complaint that was filed in September. Of course, I won't refer further to the specifics of the complaint except with regards to this executive director's report. So in asking for additional staff and asking for an additional budget, I think one of the things the Ethics Commission must consider for the sake of the public, people who might be filing ethics complaints, and in my case it was a conflict of economic interest at the Board of Appeals, is that without enough staff and without enough resources, what has occurred in my case and might happen in other cases is that we've gone forward with an appeal to the Board of Supervisors, and now currently before the Superior Court, what's called a CEQA case, California Environmental Quality Act case. And as you all know from CEQA cases, there's a very strict schedule of how that proceeds. So when you guys doing your best work, and by the way, the few contacts I've had with the ethics staff, the Ethics Commission staff has been incredibly positive. I get a sense of people who are not overworked, but doing a fantastic job and pretending they're not overworked, and really spending time with people like me who, a non-lawyer, to explain what the law is and help put together a meaningful complaint, which they did. And the point is that here now we have a judge, Superior Court judge in Department, I believe, 603 is a specialist in CEQA matters, and we now have a settlement conference, I do, next week, with the City Attorney's Office, all as a consequence, and I think this is a valid argument before the budget people, deciders for you guys, in a lot of other people have been resourced and spending money, city money, because the Ethics Commission is not being given the resources to do a quick job. I realize there's also due process elements when a complaint is made, and some things have to take a while, but my sense, without knowing for sure, but my sense from two of the supervisors who are friends of mine and other people who work within government, is that the reason for the delay is simply not enough resources at the Ethics Commission and the staff. So again, I think it's a valid argument to the government that we could be wasting money by not having enough staff here at the Ethics Commission. Thank you.
Thank you. Mr. Marsteller.
I'll try to be brief. The Rules Committee met last Wednesday and took up the Commission's proposal to encumber the vote of someone who has not, if they're a commissioner who has not filed their SEI. I'm wondering if anybody could report on feedback from that meeting?
Yes, Charlie, that was voted favorably to advance to the full board, so it was unanimous going forward. So the full board will hear it at the next full board meeting.
Great, congratulations. It sounds like it's moving very fast. I'm wondering if you are online here on your PCs. I think you are. And if you could designate an email box that's only germane during the meetings, so that people would know that they could send an email with a question or a comment on any agenda item that may be sparked during the discussions or the debates of the commission. And that might be the simplest and best way to bypass the complexities of the City Hall network. And I did want to say that I'm very pleased to see such high caliber talent that's attracted, because obviously our salary system, the city's salary system, is very commensurate. So you've done a banner job in getting the appropriate staff funding levels to attract strong talent. Obviously, from what the agenda, what your report is here, we're doing very well in talent, and I can see it on the staff. But I was also going to say, I see you're having oral interviews for the senior auditor. Will they be in line within the next 2 months or 3 months hired? And then that's good, because this year's going to be a busy year. And they need training. The other thing is, when you say job posting and development, how much of a lag time is that before the actual staff person would be likely hired? Is that more like 9 months?
Our goal is to have those positions filled by the end of the fiscal year. So
Fiscal year.
That's an aggressive goal, but we have DHR working with us.
Very good. I see that. And I think that's a great plan. And I'm optimistic on the budget, the support for the Ethics Commission budget. And I wanted to also say I found the graphics very useful. I think the public would as well. And I'm sorry, I'm running out of time here. I think I'm done anyway. Thank you very much.
Thank you. Any other public comment? No. Okay. Next item, Agenda 10, is discussion and possible action regarding status of complaints received or initiated by the Ethics Commission, and possible closed session. So I think we need to take public comment.
I'm going to speak Tuesday with Ms. Bloom rather than go into a closed session. It's too late.
Yeah. Any public comment on this agenda item? Yeah, there being none, we'll move to agenda item 11, which is discussion and possible action on items for future meetings.
Yes, I would like to see placed on the April agenda, agenda, a discussion of a possible campaign finance ordinance to either end or limit super PACs and ban foreign influence corporate spending in city elections. Pardon me?
Restate it. Would you restate it, Commissioner Rennie?
It would be a proposed San Francisco campaign finance ordinance to either limit or end super PAC and ban foreign influence corporate spending in city elections. And I hopefully before that will provide the staff with some legal research and some proposed drafts that are being prepared by a group that is very interested in trying to get San Francisco to adopt such an ordinance, even though it may be over the objection of the city attorney, because, as I understand it, the city of St. Petersburg has done that, and it may be a subject matter that will become important from a litigation point of view.
Question for staff on this. Would this be incorporated into the review of CFRO that is currently contemplated?
I mean, I think generally, if there are items that relate to campaign finance law, being able to fold it into a broader review of our city's laws that were. Yeah. I mean, we could follow up offline.
Well, I was looking at the policy report on page 3, and it had review of CFRO regulations and beginning in April 2018. Okay. Okay. Any public comment? No. Our last man standing is walking out the door. Okay. Okay, that's, and I guess we are adjourned.
No, I will
Oh,
move to adjourn.
I'm sorry. All in favor of adjourning?
Aye.
We are
Now that we're
adjourned.
adjourned, please contact our chair to tell him that cool off and get back.